participants. Once again, I thank those participants that partook in the live Zoom webinar yesterday, as well as the participants who have posed questions live on Facebook Live. Thank you very much for that. A bit of housekeeping. Please remember, I cannot see any comments or posts made on any other page other than the Advocate Mohammed Abduroaf Facebook page. You can see it on top over there, www.facebook.com// Advocate Mohammed Abduroaf /live, or you can make use of the link www.abduroaf.co.za /live. It redirects you to the other link. Please make use of that. If you have any questions, if you do not have any questions, that is fine. You can join in and watch from wherever you are, but we do advise you to like the Advocate Mohammed Abduroaf Facebook page for the sole reason we are streaming from that specific page. So you'll have first notification of whatever videos are streaming. These webinars are very interactive. You pose your question, I'll be able to see it. There's no questions now. You can see there's no comments above. The moment you pose a question, no one can see who you are really, unless they are on the page. And I will copy that question onto the screen on my left-hand side, the document stipulating live Q&A and with today's date. And we can all see it, and you are welcome to pose any additional questions or provide any additional comments after I dealt with the question. So try to be as interactive as possible. And I see we have one question that came in. It's on my phone in front of me, but is it on? Okay, I see it is on the live Q&A. Let's get to the question. Let me copy that question onto the screen. And if you have any additional questions, please feel free to pose it. I'll be happy to answer it. So this will be question one. If question one, commenter on question one has any additional questions, I will just copy it underneath that. I presume we all can see on the screen what the question is. It is as follows. Hi, Advocate. What can parents do if a social worker is handling a matter in a biased manner? One parent and the social worker are and have been friends outside the case. Thank you. That's the first question. I see another question also came in. I'll deal with that question after I dealt with this. But I see question one, he added additional comment. I think I might have to deal with that first. Let's put in that additional comment. Okay, that's the additional comment. The social worker is making suggestions that fit the wants of the one parent's needs. And is there anything else? No, there's nothing else yet on that. And let me just copy question two. Otherwise, we might lose that one, lose focus. Okay. Moving from one screen to another screen can be a bit challenging. And there's question two. So let me just deal with this first, and I'll later on deal with any additional comments. So the questioner says the social worker is biased. What can he do? They're friends, the parties, the social worker and the other party, one of the parties, they are friends. And he goes further, the social worker is making suggestions that fit the wants of the one parent as needed. Now that's obviously problematic because a social worker, when dealing with a matter, and I presume this is obviously a child custody matter or some dispute regarding parental rights and responsibilities, has an obligation, professional obligation, to be unbiased. He or she should apply his or her professional opinion on the matter and not be swayed by personal prejudice, personal judgments, and at the same time, knowing someone, one of the parties. So under these circumstances, I would, if I was a social worker, and this was probably the best thing to do, is to recuse yourself from this matter and say, I cannot, deal with this matter in an objective fashion because I know one of the parties, I'm friends with one of the parties. And let's say I have to find against my friend there will obviously be, negative consequences regarding friendship. I think you follow where I'm going to. So you will be limited to your decision. You might say, oh, I want to find against my friend, but if I find against my friend, he or she might tell my other friends, and then I'll be unpopular and so on. So on that basis alone, the person has to recuse his or herself. My suggestion is, to the commenter, is to ask the social worker, please recuse yourself from this matter. You do know one of the parties, you are friends, and it's clear that your decisions are in line with the ones of your friend. Even if it's not in line with the ones of your friend, you feel that there is some type of unfairness, unjustness, and there is a reasonable apprehension of bias in this specific case, that you think, you will believe, you are confident that the specific social worker will find in the favor of the other party or be sympathetic to the other side. And that becomes problematic, because how can you successfully or in a meaningful manner engage with a social worker or a professional if you feel that the specific professional is biased and will not make a fair and a reasonable decision on the specific matter? Therefore, under these circumstances, ask the person to recuse his or herself, maybe stipulate it in writing, send an email to the party and also copy the other party in as well. Send an email to the social worker and copy the other party in as well. And if the matter is before court, also file that specific letter or document with the court and tell the court, this is your concerns, this is how I feel. I do not feel that I can, in a meaningful manner, deal with the specific social worker. I hope that answers the question to a certain extent. Question number one, you're welcome to pose any additional comments now that I have given my view on the matter. Let's just deal with question number 2. What happens when one takes a retrenchment package after serving court papers? No court order yet, can I apply for future maintenance? I would obviously want to ask the question, are we referring to parties who are married to each other, income into property or out of come into property, with accrual, without accrual? That could possibly play a role. Or the parties not married to each other and the one party is getting a pension payout and there's no maintenance order in place. So I presume we deal with maintenance here, but the commenter could possibly add some additional information, some background information. Where are we going to? Because you are entitled to take a retrenchment package after serving court papers. What type of court papers are we talking about? Divorce court papers, maintenance court papers? I do not know. Maybe add a bit of comments and I can give you more of a meaningful answer to that. So I'll hold that. If I do not get additional comments, I will come back to it and I will try to answer it on basically on various scenarios. I have a third question. Let me just copy it in. Okay, got it. It seems to me the best way to do this is a manual way. Use a mouse and copy, not Control and C and Control and V. There we are. Third question. Morning, please advise what can be said to MO, I would presume the maintenance officer, who is telling parties that because one party is unemployed, the expense of the child should be split in a 50-50 ratio. Now, let us maybe go to the basics first. Maintenance is not payable 50-50. The law doesn't say that. It's almost like saying if a child costs, for example, 1,000 Rand, I'm using round figures, and another parent earns one of the parents earns 500 Rand, and another parent earns 10,000 Rand. Then you're basically saying if it's 50-50, the one parent, all his or her income must be used for child maintenance, and the other parent must only use 50 Rand of his 10,000 Rand towards child maintenance, if I remember the numbers correctly. That will obviously be unfair and unreasonable if you go on the 50-50 ratio. Same would, for example, apply the child costs 1,000 Rand, but one parent earns 2,000 Rand, so he must pay 1,000 Rand according to this logic. And the other parent who earns 100,000 Rand per month, he should also pay 1,000 Rand. So one parent pays 50% of his or her income, and the other parent pays, how much is that? 10% of his income. Sorry, 1% of his income. Now, be that as it may, whatever the circumstances of the case, we need to make a fair decision when it comes to maintenance. Now, maintenance is applicable or payable according to your means and proportionate to your means. And at the same time, someone can be earning nothing, be unemployed, but he or she owns a great amount of assets, is extremely wealthy in the sense of assets-wise, owns few houses, lots of cars, but has no salary per se as such. But the one parent, the other parent earns a salary of, let's say, in this case, 2,000 Rand per month, the child costs 1,000 Rand per month. You can't say I am earning nothing and therefore I can't afford to pay. So, because you have assets, that basically applies generally how maintenance is calculated. So my advice to you, the Pacific commenter, is unless you have a lot of assets and the court considered your assets, then the court could be right, it must be 50-50 because the one party earns X amount of money, but you have a lot of assets and you are unemployed. But if you're unemployed and without any significant amount of assets, the usual assets which people will generally have, the same like the other parties, what the other party has, then maintenance should not be split 50-50, it should be according to your means. Because let's say for example, you are not unemployed. You earned half the other person's salary. Then the law, certain specific maintenance officer would apply the principle that you should pay 1/3 and the other parent should pay 2/3. But here you do not earn half his salary, you earn none of his salary. So obviously 2/3 or 1/3 will be impossible. But you earn nothing, so automatically the amount should be less. It can't become more. It's like saying somebody earns X amount of money, you should pay little maintenance. But if you earn less than that amount of money, you should pay more maintenance. And the logic doesn't make sense because there is no money. You are unemployed. How can you pay that 50%? So there is no logic. The child requires 1,000 Rand per month. That's my example for now. The maintenance officer's logic is, because you're unemployed, you should pay 50%, 500 Rand. And the other parent should pay 500 Rand. Where must your 500 Rand come from if the other parent can afford to pay that? Unless possibly the other parent cannot and can only afford to pay that 50%. And then, unfortunate for the minor child. Then we have to maybe go to the grandparents and look for money from them. So I think the bottom line is, regarding the law, you must probably just have to go look up some case law, Google child maintenance amounts, some cases, how the courts dealt with that, and address that to the maintenance officer, or maybe to the maintenance magistrate, or speak to somebody in the court, maybe a maintenance prosecutor, for them to try to explain to the maintenance officer that that is the specific law and that is how it should be applied. If the party can only afford the 50%, the other party, then that is a factual thing. And then unfortunately for the child, that the other parent doesn't work. The unemployed parent must make a plan. However, nonetheless, moving forward with a specific thing, look up the law, find out how the law works, have a discussion with the maintenance officer and see what he has to say. But at the end of the day, if he makes a silly order, remember, he can't make the order, sorry, my apologies. The maintenance officer cannot make the order. He only deals with the administrative aspect of the case. It is the maintenance magistrate that makes the final order. Address it to the maintenance officer. If it doesn't work, you have to address it to the maintenance magistrate. But however, the entire process still needs to take place. There still needs to be an inquiry. How much does the child cost? What is your income and expenditure? Of course, it's zero your income. then the court has to determine, you need to explain to the court how do you survive, and same with the other party. The other party has to do exactly the same. So I hope that gives you a bit of a nutshell, a general understanding on how these type of things work. I see question number 2 added some additional comments. I'll be happy to copy that quickly in. I think my query was what court applied. That's the first comment I see. Any other additional comment? So let us make this as interactive as possible so we can all learn and benefit. I also learn and benefit because I give my brain a chance to develop and to keep it moving. I have another comment, question number 4. Let me just quickly add that one in, so while I'm busy with copy and pasting. There it is. So let's go back to question number 2. What happens when one takes a retention package after serving court papers, no court order yet, and I can apply for future maintenance, divorced parents, is a child maintenance order. Okay, so the parties are divorced. There's nothing regarding the patrimonial property aspects. Here, one party is going to take out a retrenchment package, or maybe cashes retrenchment package. He took a retrenchment after I served him papers for maintenance in March. He is welcome to do that. The only way you can attach that specific money is if the person is not paying child maintenance. It is a sound reason for that specific person not paying child maintenance. Sorry, it is the only reason, sorry, my apologies for this. The only time whereby you can attach that specific retrenchment package is if the other party is not paying child maintenance on time, he does not want to pay, or he refuses to pay. The maintenance obligations will obviously apply on a month-to-month basis. So as long as a specific person pays maintenance on a monthly basis, then there's no basis on which you can now attach his specific lump sum. It is his money. Regarding the specific retrenchment package, if there is any cash amount being paid to him, I presume there will be a cash amount paid to him, and this basically increases his wealth, his net worth, then the court can basically relook this whole situation. Because before he cashed his retrenchment package, his earnings or his net worth was a bit less. Of course, he had a package lying somewhere there, but his disposable income was less. Now he's cashing in on this retrenchment package, and he has more money available, more money to dispose of, which money can obviously or should be used for the minor child as well if the minor child requires that. So that is where the court can look at that. But he has full right to make use of his retrenchment package. He worked with it. The parties are divorced already. Life went on. If he does not pay the child maintenance, then you can ask the court, please attach this pension fund or interdict the retrenchment fund from paying monies to him, and they should pay the specific monies over to me as maintenance in lieu of the current maintenance order. So there needs to be a legal basis upon why you say the court must now attach or take this money or use this money. So going to the question, what happens if one takes a retrenchment package after serving court papers? Nothing. You can do whatever you want to. You applying to the maintenance court for a certain amount of money. I presume you're applying to the maintenance court for an increase. He can do whatever he wants to do with the money. The same way you can do whatever you want to do with your money. Only if there's a problem and the court is afraid or you are afraid that he will dissipate the money, then you can approach the court and say, please hold on to that money. We found some money. Please hold on to it and let the money be used as maintenance. Sometimes the mind goes a bit here and there because the screen is just moving up and down. So I hope I have answered that specific question. Let's go to question number 4. How do you prove that the other parent have extra income but the business is not registered? That is a very difficult question. My guess is just as good as yours. I can give you a lot of possible scenarios. One would be to speak to the person's clients, have an investigator follow this person, find out what the person's operations are. If the person has a bank account, has the bank account subpoenaed. Those are the normal stuff. I mean, this is isolate. Every case is different. Every parent is different, every business is different, and how the specific person operates is different. Some people, they run a business where they do one job per month, so it's one invoice going out and one payment coming in per month. Let's say they do big jobs. And some people, they do a lot of small jobs for the month, or maybe 200 of it per month, and they get paid most probably 100 Rand per job. So those are the variables that applies here. Some people work with cash, some people work with bank accounts, some people work with EFTs, credit cards, and so on. So what you need to do is you need to be creative. If you, ultimately what I'm telling you is, what I'm mentioning to you is, if you cannot prove that this person is earning extra income, and this specific person denies it, and there's no evidence before the court that he is earning extra income, then more than likely he's not earning any extra income. It's your allegation against his or hers, depending upon the gender of the parties. Therefore, if you have a strong assumption based upon facts, or there is information which you have seen while you were with the person, while you were living with the person, or what people have told you, this person is operating this business, he's doing graphic designing, he's setting up websites, he's a taxi driver, he's an Uber driver, whatever the case may be. So there you have your evidence. Now you need to dig a bit further, and you need to now maybe get the assistance of the maintenance court. So if he's an Uber driver, working in the evenings, doing Uber work, and he's earning some money from that, if he's a delivery guy who must delivery, extra income, whatever the case may be, you can ask the maintenance court to subpoena the Uber, Mr. Delivery, whatever it is, the bank statements, and based upon that, the court will know whether or not he is earning extra income or not. But generally, when you go to the maintenance court and you make these type of allegations, do your research first. And if you come to court with a strong allegation, for example, no, he works for Uber, he has photographs of him driving customers. I actually know of a few people that have, you'll say this, that have a use of his services, etc. And I found Uber, and Uber confirmed he works for them. So when it comes to the maintenance court or the maintenance inquiry, he won't deny it, he will admit it. But if you go to the maintenance court and you say, I believe he earns more money, I do not know, he'll most probably keep his mouth quiet, or she will keep her mouth quiet, depending upon the facts of the matter. The same way, if a child does something naughty and you do not know what he's doing, you will obviously have to do research, investigate. You know, he or she might deny it. You have to find out ways of figuring out the truth. The same way with the maintenance matter. This is an income, additional income. There should be bank statements. There should be some type of proof that the person is earning additional income. And you need to find it. I hope that answers that. If not, if you are commenting now additionally, please just say question 4, question 3, question 2, so I know where you belong. Sometimes it's a bit difficult to connect the name to the question as the string goes further and further. But now we got question 5. Let me copy it over quickly. Copy. And there we are. Let us deal with this question. Is there any recourse a parent can take if the court loses the case file? An urgent application was made, but due to COVID, the matter was postponed for 1 day, only to hear the medical test need to be performed and returned to court. Upon return, the court claimed they lost the file. The urgent matter has now become just another matter and not handled in an urgent matter anymore. The urgency was based on drug use by the primary caregiver. Should the parent engage the court administrative clerk in a more aggressive, constant basis to find the file or start a new process? I feel that we are parents and children are not responsible for the court's administrative and operational process. This is a very sad issue and a very concerning issue because, you know, if court files are getting missing, there are original affidavits, original court documents in the court files. The court is a public building, people go in and out all the time. The files can easily get missing, and that's unfortunate. And if the files have gotten missing, it places the parties in a very difficult position because you spent thousands of rands or hours, if you've done your own matter, on preparing, filing, serving documentation. It costs money also to do all of that in serving documents via the sheriff, emails, whatever the case may be. Now the lawyers are ready. We're in court, ready to proceed with the matter. The fees must be paid. I mean, the time is money. Court file is missing. Court says, I can't find the file. Everything else is stamped. On your side, you have proof that the documentation was presented to the court. The clerk stamped the court, documentation the day before. Obviously, it was handed in to him or her, and so on. Court file is missing. There's nothing can be done. Yes, you can give the court a photocopy of the file. I presume there is a photocopy, but then the judge never read through the documentation because the file was not handed to the judge. And everything is stalled for a day or two. One option you obviously have is to file a duplicate court file. Obviously, the principle would be always have photocopies available of all documentation that you file at court. But on the bigger question, you can obviously, if you feel that the court was negligent, the court did not do their job, negligent in losing the court file and so on, you can suffer damages. You can sue the Department of Justice for not doing a proper job because of the damages you suffered. They had a legal obligation to ensure that the court file was taken care of while it was in their custody, and because of their negligence, whatever the case may be, it's all theoretically I'm talking now, not specifically say it applies to your case, but theoretically, you can prove to the court that due to the Department of Justice's negligence, you have lost out or incurred certain damages, and they must compensate you for that. It will be a very interesting case. I never heard of any such a case before because I went to court so many times over the years, and so many times duplicate files had to be opened because I can't find a court file. Files get issued, it goes in the pigeonhole behind, at least I'm referring now to my local courts. It goes into the pigeonhole. Anybody can come later and say, oh, that's my file, let me have a look at it. While they're having a look at it, the clerk is busy with another 100 people. You would have forgotten about. The person can walk out of the court with a file, put it in a bag and walk out. Nobody will know. Maybe there should be cameras, maybe there should be a more stringent way of dealing with these type of matters. So I hope that specifically assists with that specific query. Depending upon the nature of the matter, you might have to decide to file another application, depends on the facts of the matter. The question is, should the parent engage the court administrative clerk in a more aggressive constant basis? If the file is missing, the file is missing. There are thousands and thousands of files in the High Court, tens of thousands of files in the High Court that are being issued. Thousands of files are being issued on a yearly basis, but there are tens and thousands of files in the High Court, maybe a million, I don't know, I do not know. If that file is laying with anybody else's file, let's say the clerk came and they came to collect a certain file, but took your file by mistake and in some judge's office on the 3rd floor. And it will remain there maybe for the next 3-4 months. So the file is most probably missing. Duplicate files are very useful, and if the court is willing to issue a duplicate file, that will most probably be your second best guess. And obviously, suing the Department of Justice if you feel that you have been strongly aggrieved and you have suffered damages. I never saw such an action before, but you can consider it. I see no additional questions. If there are any additional questions, please feel free to pose them. We are now past, let's see the time. From a recording time now, I record these videos from the moment I started so I can put it onto YouTube later on. It's 28 minutes. That's a lot of time. If there are any additional questions, please feel free to pose them now. Otherwise, we'll conclude this video. We will have another one again tomorrow morning. I cannot say exactly what time because with this COVID-19 and everything, you do not know how your schedule goes. We are busy with another court case, a custody battle for the last few years. The matter was heard last before COVID-19, when things were still fine. I think it was in February. And then the matter got postponed for the other party to get legal representation. COVID-19 came in. Now we're back in court a year later on the same facts, on the same reports, just because of this COVID-19 challenge we had. I see another question coming in. And it's concerning because you do not know how to deal with these type of matters unless you keep an eye on them all the time. We had to confirm with the judge, are we being heard virtually? Is the matter being dealt with in court? All important things to do, but it's a different world in the litigation world. So you do not know what happens, what to expect the next day. Generally, I will start high court litigation or high court proceeding at 10 o'clock. So I leave my chambers at about 9:30, get to court, introduce myself to the judge if I never met the judge before the time, and so on. Now, those have been suspended. You do not meet the judge before the time in the chambers, even if you never met him before, to limit the spread of COVID-19, which is all fair and reasonable and correct. The challenge comes, of course, in knowing how to deal with your day. Sometimes you prepare to appear before a judge in court, but then you get a notification that the judge is dealing with the matter via Microsoft Teams. So that also puts a bit of a challenge, but it seems to me that it's working very well. Okay, the last question, I guess, but however, feel free to pose any questions. I'll copy this quickly. Question number 5. Question number 6, sorry. We'll stop there. There we go. This is a two-part question regarding maintenance. Can a parent provide physical items, formula, clothes, food, etc., instead of transferring currency? I think that's the first question. If so, will this method not lessen the rampaging parental alienation issue in the country by using this method to keep the parents in contact with the minor children? I would say that's a good idea if the parents are fine with that. The difficulty with such a scenario, if it's not workable, is that we have this constant communication between the primary caregiver and the secondary caregiver, whereby they will have to be, the parties are acrimonious, the parties are not friendly with each other. And now the mother says, for example, I'm using the stereotype example that the mother is the primary caregiver. She says, I require X, Y, and Z, right, for the minor children. Clothing, food, etc. But how does she work the food out? Because she can't only 3 potatoes for the minor children, but then she needs to add, because there's 4 other people in the house, let's say new kids and the step parent. How do you work that out? And what if the bill comes to, let's say the maintenance order is 500 Rand per month, and now she says, no, I require the following, and now the bill comes to 800 Rand per month. Does the father only buy 500 Rand worth of groceries, or the last week he says, no, I'm not buying any additional groceries? What if the mother does not want to make peas food and the father's buying the peas food all the time? And she'll say, I mean, we can't eat peas food all the time. So if there is an understanding, wonderful. If there's no understanding, it does make logical sense in my view. If you just pay the one parent the maintenance, and that parent is supposed to use that maintenance. Then you deal with the issue of control, because parties are separated, they divorce, they move on with their lives. Where one parent got to always be involved in the other parent's life. So every week, email his ex-spouse, here's this, and if there's a dispute, they start fighting. And I don't think that is in the child's best interest. In my view, my professional view, not my personal, my professional view is, you pay the maintenance, the other party will have to use it. 1 month, let's say you pay 1,000 per month, but the kids are now, for example, not so much at home, and she only uses, for example, 800 Rand for the child. But the next month, the kid eats more. Then she will use that 200 Rand of the previous month for the next month. They need parties who are acrimonious. They should not have to communicate on issues concerning the child. Tomorrow the mother says, you know, I needed some more potatoes. I couldn't get hold of you. I bought another kilo of potatoes. Then the other parents said, bought the potatoes. Say, no. You should have contacted me. Or I bought a lot of potatoes last week. All these type of challenges comes about. We have one parent who is actually caring for the child, who knows exactly what the child requires on a day-to-day basis, and another parent from the sideline who is not so actively involved with the child. That is if it doesn't, if they're acrimonious. And having such a clause in place stipulating that one parent should purchase certain items can just cause more problems. But if the parties are fine, you know, their marriage has broken down, if the relationship has broken down, and they WhatsApp each other, they have an understanding, wonderful. That is perfectly fine. You know, things like school fees, those are simple things because those are monthly expenses or yearly expenditure, and all that the parent has to do is just pay it. School fees, extramural activities, and so on. Those are easy to resolve. But when it comes to these groceries and food, is a bit hard. Clothing as well can be difficult because a primary caregiver will know exactly how much what the child requires. Like sizes, I mean, who's to, take the child to the store. The other parent, if that's fine, if they're happy with it, that's fine. But however, if there's issues between the parents, because now the dad buys the daughter a nice miniskirt, and the mother said, "How can my 16-year-old daughter wear this miniskirt?" You know where I'm going to. And the commenter says, "Thank you, advocate. Appreciate your advice anytime. You are all welcome, and thank you very much for your questions. We have 6 questions, and I think that is it. If there's anything else, please pose it now. Otherwise, I'll have to end this webinar in the next minute or two. That is it, guys. I appreciate it very much. I hope to see you tomorrow online again. If you have any additional questions, please feel free to pose it on the Advocate Muhammad Abduroaf Facebook page. I hope you can see, you can't see it on the screen. You see something on my right-hand side, but you can't see the finer details. Just type in the Advocate Muhammad Abduroaf, not my personal page, but the Facebook page. Have a lovely day further, and I'll see you tomorrow sometime online. Let us begin. Welcome again, and thank you for joining us in a live webinar on child custody and child maintenance, where I'll be discussing on these specific issues and topic. However, if you have specific questions, feel free to pose it, and I'll try my best to answer it. With the lockdown, COVID-19, and the restrictions on movement, many challenges have come about when it comes to the issue of child custody and child maintenance. As I mentioned in yesterday's webinar, the word custody is no longer being used legally, but I still continue using it. The legal term now is care and contact, no longer custody and access. But for the purpose of this webinar, and many people do not know those specific legal terms, and they're used to the term custody and access, I will play around with those terms. I'll more than likely use the word contact as opposed to access. I had a few webinars yesterday, specifically yesterday with a practicing attorney from Durban, and she agreed with me that when it came to COVID-19 and the lockdown, our jobs of legal practitioners became more relevant because there was major challenges in the protection of minor children's rights, the protection of parents' rights, and the issue concerning general parental rights and responsibilities. The courts were challenged to us. It was very hard, or it is still hard to obtain, justice or legal recourse for the sole reason that there are certain regulations in place, certain practices in place, where the courts are trying to limit the spread of COVID-19, and being heard or obtaining some form of justice from the legal system becomes a bit harder. For example, you might have a criminal matter pending against you, and they postpone this matter to another date. You may have a pending maintenance matter, and they postpone those matters sometimes indefinitely, sine die, and you will have to be informed later on of that date. Urgent applications to the High Court or to the Children's Court and so on is becoming very difficult. However, nonetheless, they are still being made, and the courts have a legal obligation to attend to your matter. But having said that, at the same time, it is expected upon parents to act reasonably and understandably, knowing that we are in a pandemic, and it is in no one's best interest to play the system. I do not advise you to do that, because judges know what's happening, magistrates knows what's happening, and if you are trying or attempting to renege on your maintenance obligations or your child custody rights and so on, or obligations, the law will pick it up, and once these matters are presented back to the court will obviously know your attitude and act accordingly. So please, we're in a pandemic, be reasonable with the other parent. And when I say reasonable, and maybe I can provide an example, we know that during this lockdown period, kids are longer with one parent. kids are on holiday, they're costing more money, they're eating more money is required for argument's sake, for entertainment, maybe internet, whatever the case may be. They flush the toilet more, they use more water, and so on. Is it necessary for one parent to approach the court in order to convince the other parent that there are more expenses in relation to the minor children? It's clear. If you have a maintenance order which you have to adhere to for the sum of 500 Rand per month or 10,000 Rand per month, whatever the amount is, and the minor child is now more in the care of the other party, where the school holidays has been extended. It has already been extended initially. This is the longest school holidays, December school holidays, children had in many years, maybe decades. Nonetheless, expenses are high and expenses are still being incurred for the minor child. You as a parent needs to be responsible and need to know that and cannot hide behind the fact that the court order says you must only pay 500 Rand per month. That 500 Rand per month might be adequate under normal circumstances, where the school holidays are a certain period, a few weeks, but it's not adequate during this lockdown period. Even if we go beyond the school holidays, kids are most of the time at home. They go to school every second day. They're online all the time. It costs more money. Why should the primary caregiver approach the maintenance court in order to increase that maintenance order, despite its common knowledge that the minor children are costing more during this lockdown? So that's my comment on that. So things are different, things have changed. Regarding the change in circumstances of child custody rights, another issue. During this pandemic, minor children spend more time with certain parents or less time with certain parents, depending upon the certain circumstances. Yesterday, in my discussion with the attorney, I posed a question on catch-up contact. Catch-up contact in the sense of whereby a parent was was limited in his or her contact based solely due to the pandemic. For example, at the start of the lockdown, the law was clear. Minor children should have remained in the care of the caregiver they were at the start of the lockdown. Therefore, if a father, in my example, always had contact with a minor child only on a weekend, once a month, and the other parent cared for the minor child, of course, for the rest of the time. But let's say lockdown started on the father's weekend. Maybe they live a bit far apart. They received notification that the lockdown came in and they did not understand the regulations. But all of a sudden, midnight came in and the minor children were with the father. The law specifically stipulated, despite a court order saying something else, the minor children should have remained in the care of this father until those regulations were changed. And that was a few weeks later. And despite that, parents still quabbled and parents still refused the other parent time and contact to the minor child. Where I'm going to with this is, there is no such thing basically as catch-up contact. Parents need to act responsible and reasonable. They cannot hide behind a court order. So let's take that scenario, for example, that example, and take it further. Let's say the mother, who is a primary caregiver, had the minor children for that first 3 weeks during lockdown, and the father, who was supposed to have contact to the minor children, could not exercise contact. Let's take it further. Let's say there is interprovincial contact, whereby The father stayed in Cape Town and the mother stayed in Johannesburg, and the kids usually come down to the father for half the school holidays and so on. But it could not happen because of the regulations limiting interprovincial travel of people. During the year of 2020, clearly, one parent would have had much more contact to the minor children than the other parent. The one parent will complain and say, I had little contact to the minor children. Please give me some type of additional contact. Despite it being a court order which stipulates how much contact I'm entitled to or when I'm entitled to have contact. And the mother, for example, in my example, they will say, no, the court order says the second half of the June holidays, the kids are with me, and that's it. Or the court order says that the second half of December holidays, the kids are with me. If you could not, because of the law, exercise contact during the first half of the December holidays, that is your fault. That's unfortunate. Sorry, not your fault. That is unfortunate. But I'm not here to forfeit any of the contact which I am entitled to have in terms of the court order. So with my discussion with the attorney yesterday, she advised me, and I agree with her, the courts know the reality. The courts know that we are in a pandemic, we're in a lockdown, and clearly, there needs to be a change in circumstances, or a change in the manner in which parents care for the minor children. You cannot hide behind a court order if it's blatantly clear that the child needs to have more contact with other parent, but you are using the court order as a means and a mechanism of limiting contact. Therefore, on that note, please be reasonable, please be understandable. We do not know how long this pandemic will continue. Could be many more months, I don't know. My guess is as good as your guess. However, we're living in a reality where I honestly and truly believe that the minor children are being damaged. They are losing out on education. They are losing out on contact to the parents and so on. And therefore, we need to make it as comfortable and as good as possible for the minor children in order for them to enjoy life and live a life as normal as possible. But limiting contact to a parent because of this lockdown, despite a court order, because the parent did not have contact during a specific period of time because of the regulations, would not be in the minor child's best interest. And at the same time, why let one parent suffer and struggle despite you knowing that that parent is incurring more expenditure during this lockdown? Having said that, if you have any questions, please feel free to pose it. I'll be happy to answer it. Please comment where you watching it from. And as mentioned earlier on, you need to pose a question on the Advocate Muhammad Abduroaf Facebook page. You can see it over there, www.facebook.com/ADV Muhammad Abduroaf/live. That's where you can watch a video. But if you type in that link, you should be able to come to the relevant page. We try our best to post or advertise these webinars before the time. Unfortunately, we can't have a fixed time. I need to be in court, things happen, other consultation and so on. So at least the day before or the morning early, I'll know my schedule and I'll know when I can go online for about 35 to 40 minutes. And you should get a notification of that. If you are working during the day and you are extremely busy, like all of us are, and everybody should be, keeping busy is the way to survive. Please visit that page again and you can watch previous videos. They are all stacked there and you can catch up. You do not have to watch it live. You can watch it later. While we're waiting for people to pose questions, I see a question came about now. Let me deal with that question. The question goes as follows. Can maintenance be reduced because he had another child? That's a very interesting question. And I'll answer the question, and a question which arises regularly. The quick answer is yes, it can be reduced for the sole reason, and it doesn't necessarily have to be reduced. It can be reduced. It's possible that it can be reduced. It does not always mean it should be reduced, or there are valid reasons for the reduction. Let's say, for argument's sake, let me first deal with a scenario where it will not be reduced, and then we can go further from there. Let us say the father in this scenario has to pay child maintenance, and child maintenance is an amount of 500 Rand per month. He clearly can afford it because he earns 50, 60, 70, whatever amount of 1,000 Rand per month. So it's affordable and he can do that. And the mother can afford it as well. Let us say tomorrow he gets another child. Or 9 months later gets another child. The obligation or the people who is obliged to care for the new child is of course him. So the expenditure would obviously incur, and obviously the mother, the new mother of that specific child. However, if the amount is, insignificant, he's paying for his new child 300 Rand per month, 200 Rand per month, and he's still earning 50, 60,000 Rand per month. Are we going to deal with rands and cents over here? So under those circumstances, I would say, there's no valid basis to approach a court to reduce it by 100 Rand if you really can afford it. But having another child, nobody limits you to do that. If you have one child, you are not limited nobody can tell you can't have another child. That's just being silly. People go on with their lives and move on with their lives. You cannot say, because I'm paying maintenance for my one child, which I had in a previous relationship, I am limited in having other kids, because I must continue paying for that. That's not how the world works. But you obviously have scenarios where fathers are fathering kids left, right, and center, and they do not pay maintenance for any of them. The principle that would be applicable here would be the father earns so much money. He has one child, which he always maintained in terms of an agreement, a court order. Now he has a new child. He is incurring more expenditure. He is. And we have to look at the facts of the matter. If at the end of the day he's working very hard and he can only afford to pay for his first child 500 Rand per month, now is another child. He has a legal obligation to maintain that child. Should the new mother go to the maintenance court, the court will make a maintenance order for him to pay maintenance for that child. So what do we do then? In order for him to earn his salary, he has to buy clothing for his work, he needs food, he needs a place to stay, and so on. So the long and the short of the matter is, yes, it is possible that the court can reduce the maintenance for the first child based upon the fact that he has a second child. But it all depends on the mathematics, the economics, and so on. If he is incurring additional expenditure for the second child, we can't, the law doesn't say, okay, second child, you have a lesser right to maintenance from your parent, like the father, because the parent has a first child, or the first child has a better right. We have to look at all the mathematics, look at all the equations, the income, expenditure, the father's, what he does. Does he smoke regularly? Does he consume alcohol a lot? Does he entertain himself a lot? So those are the factors we have to look at, and that's how a maintenance inquiry works. We look at the man's lifestyle. But if the man earns 1,000 Rand per month, he bare minimum, whatever he earns, he goes to his accommodation, which is totally reasonable, transportation, work, etc., food. So that's bare minimum. And because he earns 1,000 Rand per month to the bare minimum, he has 300 Rand available to maintain for maintenance, to pay for maintenance. How the second child came out about. He only has a 300 Rand to play around with. Can we say that the second child should not receive any maintenance? We cannot say that. That will be improper, He's not curtailed from having maintenance, but he is only 300 Rand. He doesn't waste money on cigarettes, on entertainment. Salary goes to small room accommodation, or shared room accommodation, to a limited amount of food, and that's it. And it's 300 Rand left, which he initially paid for the first child, but now is the second child. That's a scenario if I should apply it, whereby there will be grounds for a reduction of paying maintenance for the first child. Yes, we can say he must find a better job and a new job. Yes, and he's doing that, but that's a scenario. That's my general answer. Obviously, the facts might be totally different where the commenter is concerned. There might be a totally different financial scenario whereby the person who is paying maintenance can afford it, and he is just hiding behind the fact that he is now a father of a new child. We need to also look at the circumstances of the new spouse. How are they married? If he married a wealthy woman, income into a property, he became wealthy overnight. The new woman, the new wife of the father, has a legal obligation to maintain the father and the minor child as well. So those are all the factors that we have to look into. Oh, I have another comment over here. Says, thank you. Wow, a lot of comments came in now. I should keep my eye on this one. I have another additional question. Can maintenance be reduced because ex and new wife ran up more debt? My son's expenses are high because he has special needs. The maintenance should not be reduced on principle that someone now ran up debt. Let's say the maintenance is 100 a month, but this party goes to the retail stores and buys an item of clothing on credit every month for 100 rand. And because he or she does that, they are incurring more debt each month. That will obviously be improper. If you look, so the maintenance should not in principle be reduced. There are ways of servicing that specific debt. And of course, if we on principle say that it can be reduced based upon debt, what are we telling the world? What are we telling people? That if you don't want to pay maintenance, incur debt, buy nice clothing, buy nice items and so on, and then go to the maintenance court and say, okay, when the order was made, I had to pay 100 rand because I was only in debt of 20 rand, minimum debt, just 1 or 2 accounts. But now I've lived lavishly. I went on holidays on my credit card. I purchased nice clothing. And now I am 5,000 rand in debt. The maintenance amount is 100 rand. My salary is 1,000 rand. I'm in debt. What are we saying here? We are telling people that it's fine, to incur a great amount of debts, and at the same time put the responsibility now on the other parent to maintain the child. Because in that scenario, the mother would be left with the brunt to care for the child based upon the father living a good life that got himself into debt. Where I'm going to with this is we need to look at all the circumstances, and if the father's debts are not reasonable, not justified, if his debts were based upon, paying medical expenses for the child, was for his personal medical expenses, something very important that is justifiable, that's a different ballgame. But if it's silly debt and debt of living a lavish lifestyle, the court should take a robust approach and say, sir, the maintenance order still stands. You have to pay the maintenance order. If not, you make a plan. Go into further debt and pay the maintenance order, but make a plan. So my quick answer over there is depends on the circumstances, but generally, debt should not be a reason why the maintenance order should be reduced, especially if the child has special needs. Thank you for that question. I have another question. If the parent's time is split 40-60, 60 to the mom and 40 to the dad, and he says he should pay maintenance also, if he says he can't pay, can the parents be held liable? Can his parents be held liable? I presume the general question would be, can paternal grandparents of minor children be held liable for maintenance? The general rule or the law, grandparents can be held liable for maintenance if their specific kids can't afford to pay the maintenance. Therefore, if a father can't afford to pay maintenance, and then they can approach his parents to pay maintenance. But I also believe then you have to look at both sides, the paternal and the paternal side of the scenario. Yes, you can. If the father truly cannot afford to pay the maintenance, then you may approach the maintenance court. You first need to deal with the inquiry regarding the father. Okay, I see the person says he shouldn't pay maintenance. No, he should pay maintenance. Okay, but let me first deal with the issue concerning claiming maintenance from grandparents. You can't go directly against the grandparents. That doesn't make sense. Grandparents live their life. They've brought up their kids. They've paid their support. They've paid their dues. If, however, there's a scenario after a full-blown inquiry and it comes about that the father cannot pay child maintenance, or he can pay limited child maintenance, but the child requires additional maintenance. And also we looked at the circumstances of the mother. Then, under those circumstances, the inquiry can go into whether or not the father's parents can come into the picture and assist in paying the child maintenance. But in my view, then we have to look at both sides of the scenario. We also have to look at the maternal side. It will be unfair for the paternal side to only be responsible for that shortfall in maintenance without looking at the maternal side, despite the maternal side being extremely wealthy. So therefore, for argument's sake, let us say the child cost 100 Rand. And the mother, based on her salary, she can only afford to pay 20 Rand. Now they do an inquiry and they find out that the father can only also afford 20 Rand, but the child requires 100 Rand. So there is 60 Rand missing. Would it be fair to only proceed against the father's side for that shortfall? No. You need to now do an inquiry on both paternal and maternal grandparent side. But this specific father says now he does not want to pay. That's nonsense. You can't say that. Even if the mother cares for the minor child 60 and the father 40% of the time. How would that generally work is maybe the mother cares for the child Monday, Tuesday, Wednesday, Thursday. That's 4 days, and the father has the other 3 days, and so on. And then the mother again cares for the child Monday, Tuesday, Wednesday, Thursday, alternatively. But if that scenario does apply, we have to look at the circumstances. We still have to look at the income and expenditure of the parents. Despite the father caring for the kids 40% of the time, if, however, he earns much more than the mother, and we work out it proportionately based upon the expenditure which the father has and based upon the expenditure of which the mother has, there would be a legal obligation for the father to pay the mother maintenance. However, if the mother earns much more than the father and she has much more wealth, remember, maintenance is not only determined based upon your income, it's based upon your assets as well, your means. If the mother earns, for example, 10,000 Rand per month and the father earns 5,000 Rand per month, but he cares for the kids 40% of the time, and all else is equal, then I would say there's no legal obligation for him to pay maintenance to the mother. There might be an obligation upon the mother to pay the father maintenance to maintain the child, because he's caring for the kids, he's incurring expenditures for the kids, but the mother earns much more than him. So that's scenario is possible. I look at maintenance matters as mathematical equations. I take a spreadsheet, I analyze it from that basis because it needs to make logical sense at the end of the day. If the father is looking after the kids 40% of the time, he still has to provide a room, electricity, water, Wi-Fi. Those are now the new things now that's coming about in maintenance application forms, and so on. So he needs to still provide those provisions to the minor child. And the mother needs to do exactly the same. So the child has two households. The mother's electricity bill might be a bit more, her food bill might be a bit more. But if she's earning triple of the father's salary, then she will have to pay the father some maintenance because he's caring for these kids for 40% of the time. So therefore, take a spreadsheet, work it out, what's reasonable and logical. Based upon that, you can determine. But there's no principle applicable that if one parent, even so, if the minor children are shared equally between the parents, 1 week, 1 week, 1 week, 1 week, it's still possible, and it happens regularly, where one parent has to still pay maintenance towards the minor child to the other parent. So I hope that answers that question. Okay. I have an additional question. Okay, going to the previous question regarding can maintenance be reduced based upon debt? The additional comment is, if debt is personal loans and vehicle debt. No, man, they had a choice, personal loan. What did he do with that money? I didn't know what he done with that money. And vehicle debt is for vehicle. You can't hide behind those specific items not to pay maintenance. As I said now, there are scenarios, there are situations where it makes sense. But why must one party be prejudiced because you decided to live a lavish lifestyle or be irresponsible where debt is concerned? Like a vehicle debt, for example, if you need to have a reasonable vehicle because you work in a dangerous area and you need to have this vehicle, otherwise you cannot work, then obviously you're allowed to have that specific debt because you have to pay it. But vehicle debt will be a monthly payments, monthly installments. Alternatively, if you took out a big amount, you took out a personal loan and you purchased a vehicle, and now you have to pay that loan and something happened to the vehicle. Where I'm going to with this whole answer is you need to look at the matter logically and reasonably. And if it's a reasonable debt, of course, he has to incur it. You can see it as an expense, a monthly expenditure. But if, for argument's sake, the guy earns 10,000 Rand per month, he was flush at the start of the year, now he's in debt of 100,000 Rand per month, 6 months later, clearly he was lavish and he wasted money. The court will have to consider that, and the court will consider that, and under those circumstances, he must make a plan to pay the debt, but he needs to continue paying the child maintenance. I have another comment regarding the issue of grandparents. No, this is a total different comment. If grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the basic scenario would be, let's say mom and dad, father is most probably an American. He comes to Cape Town, they're in a relationship with a mom. She has a child. He goes back overseas, he passes away. That could possibly happen. Or he goes overseas and can't find him, or he doesn't have any reasonable wealth or income. Now you want to claim maintenance from the paternal grandparents. Now, those are tricky questions to answer because we have to go through a checklist first. The first question, the first thing I have to mention to you is South African law or South African courts or the South African government cannot advise another government what to do. South African court orders are not applicable in other countries. Countries are autonomous. Our court orders are only limited to South Africa, and the same way European, American, Russian, Arab countries, their specific orders are applicable to them. It makes logical sense. Imagine you get someone goes to America, lay a complaint against you, an American court gives a warrant of arrest, and South African law must just follow the order. Countries are autonomous, and one country can't tell another country what to do. There are, of course, agreements between countries. For example, like extradition. If someone commits a crime in one country, in South Africa, for example, and he flees to a different country, there may be an agreement between South Africa and that country whereby they will send that person back to South Africa. But that's based upon, obviously, upon an agreement, an international treaty, and so on. The same applies to child maintenance. You can't make a maintenance order in South Africa and expect the maintenance courts that side to enforce it and execute it. Who are we to tell them what to do? I mean, they got their own laws, their own court orders, and so on. And the same way, if they send a court order to South Africa telling us to do something, we won't do it. We don't have to. Now, international maintenance, or the law that applies to that, is the Reciprocal Enforcement of Maintenance Orders Act, the REMO Act. You can Google it, it's REMO, or Reciprocal Enforcement of Maintenance Orders Act. Type it into Google and you should find one. I know the Department of Justice has a website dealing with that. There are certain countries around the world who entered into an agreement, South Africa is one of them, signatory countries, where the agreement basically says the following: we will assist each other in enforcing maintenance orders. The long and the short of it is, if there's a maintenance order in South Africa, you can have that order registered in another country. But there needs to be an agreement between the two countries. So I think South Africa has agreements with a few states in the United States of America. The basic principle on how it works is you apply to your local maintenance court. So the father is in the States, the grandmother is in the States. You live in Cape Town. You go to your local magistrate's court, Cape Town, Wynberg, Mitchells Plain, wherever it is. You advise him that the other party lives in the United States. The maintenance officer will go onto the website of the Department of Justice and find out, is this a signatory country? He decides, yes, it is. Wonderful. An inquiry will take place. Remember, we do not have any of the father's details over here. He's in the States, so we can't deal with him. An inquiry takes place. We deal with the issue concerning paternity, details of the father, what the child cost, what the mother's income is, her expenditure. So we do a full-blown inquiry here, but a one-sided inquiry. We don't listen to the other party because we do not know who the other party is, or we do not have jurisdiction over the other party. And he's in different province, in a different state, in a different country. That's done. So the maintenance court in Cape Town or in South Africa will now decide. We believe that a reasonable amount of maintenance for the specific child would be amount of 1,000 Rand. I'm using simple figures here. That specific order and all the documentation, supporting documentation through diplomatic channels will, for example, diplomatic channels will be the Office of the Family Advocate or Director General in government, whatever person that is designated in the relevant legislation. So the REMO Act will actually explain that to you. It goes to that office, that department. It gets registered with them, and it gets sent via diplomatic channels to the other countries' receiving party, designated party. That could be the Office of the Family Advocate if they have one in the new country, the minister, whoever it is. So each country has a different person. They'll have their own act in place. That documentation goes there, and ultimately, I would presume it goes to the relevant court, the maintenance court or the family court, depending upon the country. They will call the father in, and they will do their own inquiry. They will look at the documentation that the mother has provided. They will look at the documentation that the father provides, what he says, his income, his expenditure. They'll do an inquiry that side, and then whatever order they make that side will be registered there, and of course a copy gets sent down to South Africa via diplomatic channels again. That is how the Reciprocal Enforcement of Maintenance Orders Act works, and how international maintenance orders are made if you live in South Africa, and vice versa as well. I was lucky or maybe experienced in dealing with both scenarios, whereby someone in another country applied for maintenance, and I was involved in Cape Town, assisting the process, where the father lived in Cape Town, and at the same time where the mother lives in Cape Town and she's applying for maintenance against the father in a different country. So that's a practical aspect of it. We can't necessarily answer how the other country works. You'll need to look at their specific law. Like we have the Reciprocal Enforcement of Maintenance Orders Act in South Africa. The states, whatever other country, they will have their own specific laws. So answering this question from the specific commenter, if grandparents are not SA citizens and do not live in SA, can you claim maintenance from them? So the first way to answer the question, number one, is it doesn't matter if you're an SA citizen or not. If you're not an SA citizen in South Africa and you live in South Africa, you can claim maintenance from that person. So you're not immune from the maintenance court, unless you maybe like a diplomat or whatever the case may be. Going forward, you need to look at the REMO Act, to the specific commenter, find out if South Africa is a signatory to the Act. If the father lives in South Africa, the inquiry must first be finalized against the father. Then after that inquiry, and you still require more, the court here locally needs to process that inquiry in the States, like by diplomatic channels. If the father is not in South Africa and the father is not being able to be found, and you only have the details of the grandparents who are living in the States, I'm using the States as an example, you need to make an application to the local court, and the local court will, through diplomatic channels, process the application. So that's a long and short of it. Please Google it. REMO, or Reciprocal Enforcement of Maintenance Orders Act. The Department of Justice got a nice, I think you can download the Act. And at the same time, there is a list of countries with whom South Africa has a reciprocal agreement with. So the commenter says, thank you, you are welcome. I do not see any additional questions. If there are any, please pose it as soon as possible. I'll have to leave this webinar quite soon. I do appreciate all the comments. It's always valuable to have people comment so that I can answer practical questions, as opposed to just talking and advising you of what I think is reasonable or rational to speak about. But at the same time, the viewer might not find it rational or reasonable or relevant to his or her situation. Therefore, if you do provide me with live questions, I can at least assist one person, and maybe many other people with the same problem can benefit therefrom. Otherwise, tomorrow morning, I'll be back online. It will either be 9:30 or 10 o'clock. If you have any questions, please feel free to pose it. And as I mentioned earlier on, you might later on watch this video on a different platform, Our Lawyer, for example, but please like the Advocate Muhammad Abduroaf Facebook page. That is a page from where we are streaming from, and there will be notification on that page. Type out the questions today, and tomorrow when I go online, it will either be 9:30 or 10 o'clock, more than likely 9:30. The moment I go online, pose the questions so we can get immediately on that. Have a wonderful day, and I hope to see you tomorrow. Thank you. Good morning. Welcome, everyone. Thank you for joining our live webinar. We are streaming live on Facebook Live as well. And also those of you on Zoom, thank you for joining us. It's always good to have some live audience. So if you look at the screen, the guys on Zoom, you'll only be able to see me and, of course, the questions which I'll be posing soon. And the guys on Facebook Live will be able to see a screen that's different from what you have. Nonetheless, this is the way we're going to deal with this interaction today. Perfect. Someone commented, we can hear me loud and clear. Wonderful. So there's two ways of interacting with me. Yes, we have questions on the whiteboard. I shall deal with all those questions. There are quite a few of them, about 15 of them, which I want to get past in the next hour. If you're on Facebook Live, you can leave a comment and I will look at that and I shall deal with that as well. And for those of you who are on Zoom, please remember you are allowed to deal and interact with me live. So if you want to say something, if you want to speak to me, please feel free to request and unmute, and then I'll unmute you and we can converse. Remember, your face won't necessarily be on the video, so I advise you, in case a technical glitch might appear, to, how can I explain to you now, not activate your camera. Many of you are doing that, and that will obviously assist us in, trying to be anonymous and so on. So wonderful. If you have a question and you want to interact with me live, feel free to do so on Zoom. And put up your hand and you're welcome to do so. Yeah, the screen is a bit messy, but that is fine. So on Zoom, let me do one thing quickly. Let me share the screen. And the screen will obviously be the questions that were posed. Okay, wonderful. Let me sort something out here. It seems to be coming out a bit funny when I do that. Nonetheless, let me admit these people. Okay, sorry about that. Let us stop it for now. Okay, let's deal with the first question. And feel free to interject at any time. Pose a question, put up a hand if you're on Zoom, and we'll deal with that. Okay, today's topic, child custody, child maintenance, and divorce, live Q&A from myself. I'll hopefully be able to assist you and guide you on the specific topic. About myself, I'm an advocate practicing as such for the last almost 20 years. So I'm a family law expert. I deal with a variety of family law legal matters, ranging from child custody, guardianship, relocation, maintenance, domestic violence, and everything. Divorces, I deal a lot of divorces as well. And that's where my expertise comes in. Many people, they cannot afford legal representation or legal advice, and that's the purpose of this webinar. And at the same time, many people can afford legal advice, but they don't get a chance to actually, get some insightful advice regarding the specific matter, and that's the purpose of this webinar. So the first question goes as follows. It's from Gauteng, and it says, my wife's attorney, who is handling the divorce and is a ACER, I presume, meaning plaintiff. And the person said, sorry, do not know the English. I found I found is lying to the High Court and impersonating the magistrate to cancel my contact to the son. So the person obviously wants to know what type of advice do I have for the specific person regarding that. Obviously, long and short of the matter is you're not allowed to impersonate a magistrate. It's obviously a criminal offense. So the first issue, the first thing we need to do is try to get rid of this magistrate, or try to expose the magistrate, or this person who's trying to impersonate himself as being the magistrate. So I cannot maybe take it further, because that would most probably be the quick advice to you to deal with the matter on that specific basis. Lay criminal complaint, speak to somebody, and hopefully they can make some noise and they can deal with a specific issue. So let me go on the Zoom one more time and try to share the screen. My apologies for this. I've never done this since March. That's the last time we've done these webinars. Okay, let's do that. I'm seeming to still have an issue, a problem with this. Nonetheless, my apologies for that. And obviously the email questions will be emailed to each one of you afterwards. And you'll be able to see this later on as well. Ah, there we are. No, sorry, there we are. Let me get past that. Okay, then the second question, let us deal with that quickly. The second question that was posed, an interesting question, it goes as follows. Separated but married with 3 kids staying with me. Looking for financial help and a parenting plan from the father of the kids. I've initiated maintenance against the father, but his sister is paying the school fees. So that's what the person from Gauteng commented and stated. I do not have any additional information, so I'll try to deal with that. And hopefully I will be able to be of some assistance regarding that specific question. Okay. Regarding child maintenance, if a party is separated from the other parent and you're not living together anymore, maintenance will obviously have to be determined based upon your means. Okay, so if somebody is earning quite well, automatically what that means is that specific person will have to pay more child support or support the child more than the other party. That makes logical sense. So here the parties are separated, they were married for 3 years, and the kids are, they're married, and the kids are obviously living with the one party of their 3 kids. Now he's looking for financial help, and obviously they try to enter into a parenting plan. He initiated the maintenance matter against the father, but the sister is paying the school fees. That's the information I have, so I'll try to be, creative and try to assist the specific party over here. The sister has no legal obligation to pay the school fees. Obviously, the sister is paying the school fees on behalf of the specific parent. Under those circumstances, that is fine, and it can be seen that the specific sister is paying the maintenance, or the specific parent is paying the maintenance, but the sister is doing it on behalf of that specific parent. My advice to you is unpack exactly what the needs of the child are, or the kids are, the 3 children are. Work out exactly what your specific income, potential income is, and also the other party's income. And that is most probably the starting blocks on where this matter will have to be dealt with or, action from. Once you've determined that specific date and that specific information, then you'll be in a much better position in order to advise the maintenance court on coming to a fair conclusion regarding child maintenance. So that's basically the advice I have regarding the question that has been posed from the specific commenter. Let me change the screen quickly. Okay, there is it. Let us move on. Please, those of you on Zoom, you're welcome to interact with me live. I have no problem with that. And we can hopefully be able to advise and assist you properly. Okay, the third question I received is from KwaZulu Natal. The question goes as follows. Can the father change the maintenance amount according to his own calculations to exclude things he thinks is not needed, like exclude the nanny's fees, even though I need her because I work? Now, this is a challenge people will have. If the parties cannot come to an agreement regarding child maintenance, it's not for one party to decide, I make the decision as to what is fair and reasonable. No, that doesn't work that way. Maintenance, as I mentioned earlier on, is is determined according to the party's needs, their means, the child's needs and the child's means, and so on. So therefore, when it comes to the scenario, you might say, I require the following, and the father should be paying this, and maybe he should not be paying that, or maybe he should be paying more, I do not know. So I always advise people, if you want to have a fair assessment on child maintenance, you need to have this matter properly resolved in a maintenance court, in a proper forum. So here we're having a situation where the person believes he's entitled to, for example, the nanny fees, but the father believes he's not entitled, he should not be paying that. I do not know, my guess is as good as you. Maybe you're earning more than the father, maybe you're earning less, or maybe the father should be paying that. The bottom line is, if the parties cannot come to an agreement, it's silly for you guys to go on like this, where the father believes he must pay for this and the mother believes he must not pay for this, or whatever the case may be. Try to resolve it as quickly as possible. If you cannot resolve it, one of you have to take the matter to the maintenance court. And here, obviously, it will have to be the mother. It's possible for the other party also to take a matter to the maintenance court if, for example, there is a maintenance order in place and you want to vary that specific maintenance order. From KwaZulu-Natal, I hope I answered your question. That was the third question. If I did not answer it properly, feel free to put up your hand if you're on Zoom now at present, and add additional comments, and hopefully I'll be able to assist you and advise you accordingly. I'm seeing we are having some technical issues here regarding the screens. Hopefully in part 2, next week and Saturday, we can sort out all these glitches. But thank you anyway for partaking. Question number 4. We go as follows, and this question also arrived from KwaZulu-Natal. The reason why I'm mentioning the province is because it will just connect you to the question. Many people, they pose these questions, but they do not know, later on, they do not know if they pose a question or someone else pose a question. Of course, I copy these questions verbatim as it was received from you, with the spelling mistakes, with the grammar mistakes. None of us are perfect. So you can just double check later on if it was your question. Question number 4. How do I find my ex-husband who has immigrated to New Zealand? I think it's immigrated. He has defaulted in child maintenance, unlike many other parents, feel exhausted, and the justice system does not help either. Now, this is a bit of a challenge because here we're dealing with international maintenance. If a party immigrated to a different country, now obviously South Africa courts does not have power in a different jurisdiction, the same way that the Cape Town court doesn't have power in the Johannesburg court. The High Court in the Western Cape does not necessarily have power to the Johannesburg court. But here we're dealing with countries whereby how can a South African order be implemented in a different country? But there is something called REMO, Reciprocal Enforcement of Maintenance Orders Act. That is, sorry, my apologies. It is an international agreement between South Africa and various other countries. You will need to determine whether or not South Africa has an agreement with New Zealand. If there is an agreement with New Zealand, you can enforce a maintenance order made in South Africa to another country, to another signatory country. So you need to look into that. However, if South Africa does not have an agreement with New Zealand, unfortunately, there's not much you can do unless he has assets and property in South Africa. I hope that answered your specific question. If I have not, please let me know. Okay, somebody put up their hands. I see somebody wants to ask a question. I will unmute that person and hopefully we can deal with that question live. Please go ahead. I'm unmuting you. Or you may unmute yourself. There's it. You're welcome.
Good morning, Advocate. How are you? Good, thanks. I have a question regarding primary residence. So I've got divorced like 6 years ago, and my ex and I, we reconciled a few months after we got divorced. But at the start of this year, I decided to move back home to KZN. It wasn't working. So we have an 8-year-old together. And, the advice that I was giving moving from Joburg to Durban was that I could. And I've informed him I'm in KZN. However, he's now challenging primary residence. He would like my son to be with him in Johannesburg. We've had our inquiries with the family advocates. I just wanted to know, a bit of insight as to grounds in challenging primary residence. When I left, I left without a job, but, I'm in a position now to provide for my child. So my son is in Joburg with him based on the interim order. he had to go back to his old school and he's with his dad. So now I'm just waiting for outcome from the family advocate. I'm not sure if I should, like be in contact with them to just find out how's it going, because they did advise me that, they're in a backlog with COVID and they under enormous pressure. So I don't want to come across as being too pushy at the same time, but I need something for now, because schools are closed because of COVID, but at the same time, primary residence is being in dispute. So any advice for me on that one?
Yeah, let's stay on the line quickly. Let me just get this right. So after you guys divorced, you were the primary resident, primary caregiver of the child while you were living in the same province with the father. Since you've moved, the interim order stipulated that the child should now, at least in the interim, remain with the dad.
Correct.
You can stay online. You can stay online, or you can, of course, interact with me via Zoom a bit further. So the challenge you have here is when the court deals with a matter regarding primary care of a minor child, the court obviously focuses on what's best in a minor child and his circumstances, etc., not necessarily what the parents want. The advantage a father here obviously has is that this child's school is in his province, and it makes logical sense for the minor child to remain there. You need to obviously now be strategic if you want to have primary residence of your minor child. You need to now start being proactive in the sense of, okay, I want my child to come to live in my province. What would be in his best interest? Obviously, making sure there's an adequate school for him to stay in there. What are the advantages a child has by living with me? Of course, I've always been his primary caregiver. I know when he gets ill, I know his moods, I know everything about him. So those are advantages of having you as a primary caregiver. The stickler here obviously is the minor child's school. Then also the other aspect regarding the father, can he adequately care for the minor child as well as you can care for the minor child? Obviously not. You can do a better job where that is concerned. So you need to present that specific scenario which I mentioned now to the family advocate, and let the family advocate be convinced, you know what, okay, yes, the child's school is here by the father, but it will be holistically more advantageous for the child to live with the mother. He will be better cared for, better looked after. If the father has more money, that is fine, but he can pay more maintenance to the mom. But at the end of the day, you must just make a very good argument to stipulate, yes, the child will be deprived at least by leaving his old school, but he just has a good school. Children adopt, and there's no reason why the child should not be in my province, live with me, be cared for me, and he'll thrive there from. I hope that answers your question.
Yes, thank you very much.
I see there's another hand. I think your hand is coming down. Any other hands up there before I go with the next question? You're welcome to put up your hand, and I will unmute your microphone, or you can unmute it yourself, and you're welcome to pose any additional questions to me. Let us carry on, and hopefully soon I'll see somebody's hand up to pose another question. Question number 5 from the Northern Cape. If my ex and I split, we were never married, that's fine, and he now has decided to get married to someone else. Does he and the wife have a better chance of getting custody over me, a single mom? Okay, one of those difficult questions to answer because I do not have too much data coming here, but I presume that the mother is the one who's primarily caring for the minor child, and the father is the one that's remarried, and he has contact quite often to the child, but he's not the primary caregiver. That's why there is now a custody dispute regarding this. In principle, there is no reason to stipulate that because a party remarried or married to somebody else, they are in a better position to care for a minor child. That's nonsense. There's no principle where that is concerned. I know in many cases whereby the reason why we were successful in receiving primary care for the one party was because the other party met someone else and remarried. There's a lot of things that can play a role. For example, the other party might have, the new party, the step parent might have, for example, kids from previous relationship. The house might be crowded, the room might be small, they might be arguing a lot, and the mother situation is obviously better and more reasonable under the circumstances. So under those circumstances, I do not, on principle, stipulate that that is necessarily an advantage. It could be, depending upon the circumstances. It could also be a disadvantage. You need to focus, the person from the Northern Cape, you need to focus that you can care for the minor child better than that specific scenario. That is what the court will ultimately have to decide. Which parent can care for the child much better, considering all these factors. And if you can show that, and you can show to the court going forward, I will look after the child much better, then obviously the court would make that order in your favor. That's question number 5. I have a question on the Zoom. It says the following. Is a father allowed to withhold maintenance when the kids visit for a few weeks? One of those difficult questions, because I believe maintenance are mathematical equations. The long and the short of the matter is no, but it also depends upon various circumstances. For argument's sake, if the maintenance is being paid for certain type of expenditure, for example, aftercare, extramural activities, certain expenditure which are not being incurred at all during this time that the minor children are with the father, then clearly it doesn't make logical sense for the father to continue paying those specific expenditure. At the same time, the argument can be made if the child is with this father now for a few weeks, and the father now has to spend a lot of money on food and certain things which he has to obviously incur because the kids are with him, he can bring up an argument, the kids were with me for the last few weeks, I spent so much more money on them because, and the mother, the other party, who is a primary caregiver, saved a lot of money where this is concerned. If it's for a few weeks, like 2 or 3 weeks, I would say no, there's no case to be made, because at the same time, many times the primary caregiver incurs more money than what the maintenance order says, more expenditure, my apologies, what the maintenance order says. So it doesn't necessarily cut there. But if it's for a long period of time, like 2 or 3 months, then I can strongly argue that the person who is supposed to pay maintenance, who now cared for the minor child for the last 2 or 3 months, would have a very good case to stipulate that during that 3 months, I paid for all the water, the food, the clothing, the accommodation, everything, and the other parties saved there. There needs to be a relook regarding that specific amount. I do not think it will be correct to stipulate that you can withhold. There needs to be a discussion and an agreement. And if the agreement cannot be amicable or agreed upon, the parties can't agree to it, then obviously one party will have to go to court. So if the maintenance order stipulates that the father must pay, and he feels now, okay, it's now 2 months down the line, he must still continue paying the maintenance because they can't come to an agreement, then he needs to approach the maintenance court for variation of the order. And he can have it backdated as well. I hope that answers that specific question, and if I did not answer it, you are welcome to pose an additional question to that. Question number 6, from the Western Cape, where I'm from. Son had a case at the High Court, Cape Town. He stopped at the mother, put the child on question through many things. I asked the paternal grandmother, I presume, went forward. The advocate that advised handling the current case said I. In all honesty, I copied and pasted that. I didn't know what it entailed, but that's a question from the person from the Western Cape. Question number 6. If you have any additional comment to that, question number 6, just leave me a note and I will deal with that a bit further. I do not know how to answer that question. Let us deal with question number 7 from KwaZulu-Natal. When your kids and you are still on the family trust, what are the benefits and what are the benefits, okay? What happens when the divorce? Please may you discuss family trust benefits. Okay, I'll be short, and I told myself and I told you as well, I'll deal with all questions posed. A family trust will only be to your advantage and to your benefit if there are money and assets involved in it. That makes logical sense. But the one true advantage would be that the assets of a family trust is not the assets necessarily per se of the beneficiaries or the trustees. It's separate from that. And if there are assets in the trust, and monies that can be withdrawn on a monthly basis, you can look after the beneficiaries of the trust. So generally, the father and the mother will open up a trust for them and the minor kids. They must probably put some money over there, whatever the case may be. Should any problems happen regarding the mother and the father's assets, they become insolvent, the money will still be in the trust, and the trust can continue looking after them. At the same time, should something happen to the parents, whatever the case may be, the trust can still continue looking after the minor kids. So those are the advantages of having a trust. It's separate from the estate and the assets of the individuals. And it is a working structure in the sense of, even if the parents are no longer there, it still has life. It still has to look after the beneficiaries. For example, it can stipulate it should continue paying the interest or the profits or the rental received from the property that belongs to the trust to the minor children until they turn 21 years old or self-supporting. And when the younger child turns 18 years old or is self-supporting, then automatically then the trust can be dissolved and all the proceeds can be, or the assets can be distributed or sold and distributed to the beneficiaries. Okay, if you have anybody from the Zoom, you're welcome to pose any questions. I'm happy to take your, put up your hand and I'll be able to deal with that. Let me have a look at Facebook Live. There is no movement there, so that is okay for now. We are ending this webinar on the dot at 12. I had an agreement with some construction people. They are knocking here, so they'll be keeping quiet until 12 o'clock, so we'll have to wrap it up until then. But I'm sure we will do well. But that's why, if you have any questions, live questions, please pose it now and put up your hand. Let us deal with question number 8 from KwaZulu-Natal. Okay, that's great. KwaZulu-Natal is quite active today in this webinar. How do we go about using a state lawyer if one is unemployed? Okay, state lawyers, legal aid, that's what I'm hearing here. State employed. It depends. I mean, the Legal Aid Board does not deal with all matters. Of course, if you are an accused in a criminal matter, they will definitely assist you. But maybe, for example, maybe, I'm just speaking for example, let's say somebody knocked into your car and now you want to sue a third party, they might not assist you regarding that. But for legal aid, you need to go on the website, find out where they are, your nearest legal aid department office, go to them, they'll do a means test and they'll determine whether or not you qualify. If you are very wealthy, of course not, you will not qualify. Why should they give free legal service for people that are extremely wealthy? If you cannot afford legal representation and require legal representation, for example, a criminal matter, they will appoint somebody to assist you regarding that. So I hope that answered your specific question. Okay, I have a question here. Let me deal with that quickly from Gauteng before we go on to question number 9. Another question. I'm a single mother, 2 oldest from previous marriage. Okay, the youngest one's father claims to be unemployed, although I see him going to work. He also owns a house, pays a bond, and he can easily live with his retired mother. Okay, he changes the maintenance amount according to what he thinks he can afford. Every time this happens, I come short because I have to still pay the expenditure. Okay, that is a question over there. Yeah, that's a question, and I'll deal with that question now. So bottom line is, the father says he's unemployed, he can't afford the maintenance, but he works, he pays a bond, and he can live by his mom. Now he decides what he wants to pay, and the bottom line is the mother cannot, continue with a month, because every month comes, she is unsure, etc. She needs to approach the person on Zoom that left a comment. You need to go to the maintenance court. You need to resolve this matter as soon as possible. If there is a maintenance order in place and it's paying short, of course, it's a criminal offense. They should do something about it. And we all know being in contempt of a court order, we've seen it in the media, is quite serious. If there is no maintenance order in place, bottom line is, approach a maintenance court as soon as possible, and they'll have to do an investigation and inquiry. It needs to be done. It might take some time. It needs to be done, and the maintenance court will make a decision as to what would be a fair amount, and it will be an order of court. So the father will be forced to pay that amount. And he owns assets. I see he owns a house and so on. So that can also ultimately be sold to pay for the child's maintenance. So that's important to note. I hope I answered that question. The bottom line is you need to do something about it. Okay, I have another live question from the Zoom. Can a Rule 43 be brought to the respondent after 3 talaqs been given? If I'm working, can your long-term savings be taken into account as well, like retirement? So I think that's a talaq. Obviously, we're referring to Muslim marriages here. Muslim marriages are not recognized as valid civil marriages, therefore your assets of the parties aren't necessarily taken into consideration. And there needs to be some type of a legal basis as to why you want to bring your assets and your retirement investments into the picture. Okay, so the question over here is on the child custody. It goes a bit further. Let me go further. If a person has a mental condition and has a history of substance abuse, can the non-primary parent have sleepover contact? Okay, let me first deal with the first question. I think the same questioner has 2 questions. A Rule 43 is a application in the High Court for dealing with interim maintenance, contribution towards legal cost, and dealing with care and contact regarding minor children. Those are the three things that Rule 43 application deals with. The other parties have divorced, have resolved their marriage. I do not see the basis upon why a Rule 43 order application will necessarily be made. The marriage is over. If there's a dispute potentially regarding the marriage or the issue regarding that, then of course a Rule 43 application could possibly be made because it's a dispute regarding the marriage. However, if the marriage has been resolved, that's it, and in my view, the parties will have to continue with their lives. Regarding the second question, if a person has a mental condition and has a history of substance abuse, can the non-primary parent have sleepover contact? So I would imagine the parent. There's two scenarios here I'm seeing here. Either the parent who is a primary caregiver has those specific challenges. That's unfortunate. And then the question is, can the non-primary parent have sleepover contact? Sleepover contact either way, whether or not you have a mental condition, whether or not you're abusing substance, etc., it must be in the minor child's best interest. Full stop. And I'll be blunt here and I'll talk as a lawyer. It does not mean in principle that if somebody is abusing substances, he or she is not allowed to have contact or sleepover contact, okay? Because there are different levels of substance abuse. If the substance abuse takes place away from a minor child and at days and times when the minor child is not with a specific parent, then of course the legal answer would be that care and contact would not have to be limited based upon something that happens at different times. However, if the person is abusing substances and so on, at times when he or she is not having contact with a minor child, but it affects the contact ultimately, then of course it's an important factor. So what the court looks at and what the law looks at is not necessarily whether or not you're abusing substance, because that's not how the law works. We don't say because of this, we checklist. We still have to look at the matter holistically and properly. If the substance abuse has a detrimental effect on the potential or the dealing with aspect regarding overnight contact, then of course overnight contact should not take place. If it does not play a role, if it does not affect the quality or the safety of the minor child when overnight contact takes place, then of course overnight contact may take place, put it that way. I hope that answered that specific question. And I see there's another question on the Zoom, but before I get to that, let me first deal with question 9 from the Western Cape. Question 9 from the Western Cape says the following. Maintenance arrears, non-compliant, children's court, not doing anything about the arrears. So I'm presuming there's a statement and someone wants me to comment regarding that. Okay. If a person is in maintenance arrears, the maintenance court should be able to, should assist you. Not necessarily the children's court, it will be the maintenance court. And the maintenance court has two options. They can either deal with a civil route where they can assist you in attaching the person's assets, for example, his car, selling the car, his bank account, taking money from the bank account, or having his employer pay you the maintenance directly, a garnish order. So those are the things that could potentially happen and take place. However, not the children's court. So my advice to you is to approach the maintenance court, not the children's court. If they aren't assisting you and made a mistake here, and you mentioned children's court by mistake, my advice to you is to start complaining and to speak to the relevant people, go up the ladder. I know with COVID-19, some courts, I'm not mentioning any names here, but they are maybe a bit more not as enthusiastic to assist people as they would have been had it not been COVID-19. That is no excuse. You are being paid, you have a job to do, you should do your job to the best of your capability. So therefore, my advice to the Western Cape, question number 9, please go to the maintenance court, lay the complaints, criminal complaint or the civil. If they do not assist you, go up the ladder, speak to the manager, go up till the Western Cape Provincial Minister of Justice, speak to him, and make some noise. That would be my advice to you. How does one go about getting a copy of a court file from the children's court? I'm the grandmother and would like a second opinion on what the social worker is reporting. So that's question number 10 from Gauteng. Okay, this is the challenge you have regarding children's courts. If you want a copy of the court file, the magistrate will have to give you, authorize you receiving a copy thereof. You cannot just request I would like to have a copy. Even me as a legal representative to a party, and I can do it many times. When I get instructed and briefed by an attorney to appear in the children's court, I see we have a bit of a challenge here. We're back online again. Something happened over there. Okay, even me, when I get instructed and briefed to appear for a client in the children's court, I need to specifically request from the magistrate or via the clerk for a copy of the court file, and I have to give reasons therefore. So it seems to me the files in the children's court are quite locked. You know, they were sealed. So if you want a copy of that, you're welcome to do so. Go to the clerk of the children's court and ask the clerk to ask the magistrate whether or not you can get a copy of it. And if you have good reasons, they'll give you a copy of the file. But you are a third party, you're not the parent, so it might be a bit challenging, but I would say try your luck and see what you can do. Now we get into question number 11. If anybody wants any additional questions, you're welcome to pose it from the Zoom and the Zoom chat, which I've seen there are a few questions, or you can put up your hand and deal with it live. Question number 11 from Gauteng. When a child is removed from the primary residence and placed in a place of safekeeping by the Department of Social Development, social worker, after false accusations were made, what are your rights and recourse against a biased social worker? So what happened is, this is obviously a children's court matter. A complaint was laid and said the child is in danger or not being looked after, neglected, and they placed the child in type of foster care for safekeeping. Under those circumstances, a social worker obviously done some investigation, and then you are not happy with that. Obviously, if you're not happy with that, you're welcome to say that. But if you are saying that this person was biased, you'll be able to prove that this person is biased. And obviously, the first way to do that is to complain to this person's boss, go up the ladder. If, however, you feel the person is biased, and at the same time, the matter is pending in the children's court, and you disagree with that, you can present an argument why you think the person is being biased, but at the same time, you can also come with another opinion as to why a different decision would have been taken had the person not been biased. I see a hand going up. You're welcome to unmute yourself and chat on the... I'll ask you to unmute. You're welcome to go ahead.
Hello, can you hear me now?
Yes, I can hear you. Please go ahead. Thank you.
Hi, this was my daughter's question. And with regard to the case, it is still ongoing in court, and we just wanted to know, how would we present that to the magistrate? Do we have to fill in any kind of documentation to tell her that we would like a second opinion? Or how does it work?
So am I dealing with a question from Gauteng, question number 11
yes,
now?
Yes, that one you've just been dealing with.
Okay. So the challenge I have, the challenge you may have is that because the report is most probably not in your favor, the court and everybody else might think because the report is not in my favor, automatically I have a challenge with that, and now I'm saying the person is unbiased, is now being unbiased, or being biased, sorry. The way I will challenge something like that, and I'll be honest with you, is not necessarily attacking, say the person is being biased. I will unpack the report and stipulate exactly how did it come about that the report is flawed, that the logic applied by this person does not make logical sense, because that will speak better to another person. So, for example, if the person, for example, comes with allegations that was unsubstantiated, that are thumb-sucked, and that will be the way how you will attack that. So you need to sit down with pen and paper and say, this doesn't make sense. Or, for example, what happens many times with these reports, that people, these social workers, they put data in there that was never told by the parties. Or they come to conclusions that doesn't make logical sense at all, no matter how you look at it. And that is what you need to bring to the attention of the magistrate. Because if magistrates and court officials, I mean, they deal with hundreds of files on a regular basis. You this one file, and they look at, when they read through these reports, they jump, and I do it many times myself. the moment I receive a report, I go one time, I immediately go to the last page and look at the recommendations because I don't have much time unless I have to study it for court. Now, the magistrate might do that. So my advice to you is unpack that report, deal with it properly, say why you have a problem with that, and at the same time, maybe take that report to another professional person and find out if that professional person agrees to that. And that might be able to assist you regarding.
How do we present so when we go and we put it down on a piece of paper, do we just create an affidavit which we then present to the magistrate?
Yeah, so in children's court matters, you generally orally speak in the magistrate before the magistrate in the children's court matter as opposed to a high court matter. So regarding your circumstances here, not necessarily an affidavit. I do not think that's necessary. Maybe there's a response, a written response to the problems you have with a specific report, and you file that at the clerk of the court. Affidavit will only kick in, for example, if there are factual problems you may have. For example, if the social worker says, no, the child is 6 years old, but the child is actually 5 years old or 4 years old. And then you can say under oath, because now you're confirming with evidence. But if it's arguments which you want to challenge regarding the social worker's report, for that specific stuff, you do not, affidavit won't necessarily be necessary. This is an argument. So the magistrate can see now, this is the response I have regarding this specific report. And send that response also to the social worker as well, and he or she can obviously have a look at it as well. So everybody can, opinions can be presented.
Okay. You just hand that into to the clerk prior to the case being heard.
Yeah. So the way I will do it is yes. So you receive the report of the social worker. I would most probably just email it to the clerk of the court and ask him or her to give it to the magistrate. Then it is on record and it needs to be dealt with. You see that the difficulty we have in these type of matters, especially if you are a lay person and you're underrepresented, you talk and you argue and it goes through the one ear, into the one ear and out of the other ear. But if it's on paper, it's always there. And if you challenge these decisions on appeal or review, automatically it was on record and the courts will have to apply their minds to it.
Very well. Thank you very much for answering that. You have helped me tremendously.
Welcome. I hope you get justice. And I love it, honestly. People need to start owning their cases. You are in the system. The magistrate's job is not here to be the umpire and decide how you guys play the game. You play your own games as to the best as you can, and the courts have an obligation to decide on what's best for the minor child. Yes, but they can't tell you how to present your case. You have that duty and you have that right and privilege to be able to present your case and to deal with the case how you think is fit. So thank you for that. So let me deal quickly with, you're welcome. Let me deal with question number 13 from Mpumalanga. That's nice to hear people from Mpumalanga. Hi, Section 21 of the Act, I think presume the Children's Act, unmarried fathers, rights of unmarried fathers, stayed with the girlfriend till the kids were 2. Okay? She damaged my property after an argument and had to move out. I asked for the kids to remain but failed. Why are my rights as police help out her? So I'm still typing it out verbatim with all the WhatsApp type of short handwriting. But anyway, nonetheless, you as a father, you acquire full parental rights and responsibilities with the mother if you are involved in the child's life since the child's birth. So that is fine. If you have acquired that rights, if you wanted to form part of the child's life, you paid child support, you maintained the child, whatever is reasonably possible, and now the mother decides now, okay, I am now the mother, and therefore I can decide what's in the child's best interest. That's obviously nonsense. So my advice to you is, go to the children's court, let the court hear this matter, let the court make a decision as what's best for the minor child. If it does mean you must have limited contact and the court believes that is the case, there's nothing I can do regarding that. However, the court will obviously have to decide what's best for the minor child, and generally, what's best for the minor child is not necessarily what one or what the other party wants. The court will make that decision. So that's from Mpumalanga, and I hope I've answered that question, and hopefully we can go to question number 14, 15, 16, and 17. Okay, those are the last questions on the whiteboard. But before I deal with that, let me first deal with the question which I have on Zoom. Okay, I have a question on the Facebook as well, but it's basically a question regarding the Zoom link. Unfortunately, it will be too late to send the link out now because you are watching this. But please note, we are having a webinar next week and Saturday as well. We'll be better set up for that one. And any questions or any participation you'd like to make, you are welcome to do so with me. That's next week. Okay, so here we are, back on the Zoom. I'll make sure I should just make sure I do not lose out any questions. Okay, here we go. My son is spending time with his dad's side of the family today. My son messaged me to fetch him and he's scared. His dad is not around. Can I go through and fetch my son and try? Is it not a good idea? I'm available right now to fetch my son. He's clearly unhappy. And I'm available right now, okay, to fetch my son. It's basically repeating that. Okay, this is a difficult question for me to answer. I mean, in isolation, I mean, if the other parent has rights of care and contact, that person must exercise that contact. It's not for one parent just to go and play around with the care and contact rights. The first thing I would do is contact the father, discuss this matter with the father, and ask father, why are you not with the child? Remember, it's not for a child to decide what is best for the child. For the same scenario, for the same reason, and I will say this. Let's say tomorrow your child decide, no, mommy, I do not want to stay by you this week. You know, I want to stay by dad, and it's your week on. Do we listen to the child wholeheartedly, or do we apply our independent mind to this? My advice to you is, find out from the father why is the child unhappy, what is happening there, why is the child not with you, because we all know many times parents have care and contact over a minor child, but you know, they have to do certain things, and for 1 or 2 or 3 hours, a child can have to be cared for by third parties or be alone if the child is safe and so on. Then later on, you exercise contact. It wouldn't make sense, for example, if a child gets picked up by the dad, picked up the mother at 8 o'clock in the morning, take it back to the mother at 12 o'clock or 2 o'clock, collect from the mother at 2 o'clock, and now the dad must go quickly back to work at 5 o'clock and drop the child. It doesn't make sense, you know, up and down, up and down. It doesn't mean the child must always be physically in the care of one child, depending upon the age and maturity and so on. To be careful here, and I wouldn't want to advise you just to collect the minor child. Speak to the father, try to come to some type of understanding. Can I collect my child? What's happening there, etc. At the end of this contact period, then of course this matter must be properly re-looked at. Then I would advise you, please speak to a parenting coordinator, speak to a social worker, speak to some professional person, try to resolve this, because we do not want this to happen again in the future. So I'm very weary or very loath in stipulating collect your child. I mean, what am I basing that upon? You know, some text messages here. I cannot do that. My advice to you is speak to the father, contact the father, communicate with him, and find out exactly what you can do. And if he says, okay, fine, you can collect your son or child, wonderful, please do so. But please try to resolve this matter soon after this contact period has come to an end. I hope that answers your question. Another live question on the Zoom. Does the case go to the children's court when the agreement signed at the family advocate is breached? I am nervous that he will get more rights than what he deserves if I go to the court. So I've been tolerating the short payments out of fear. Okay, the family advocate can have the parties enter into an agreement, but that agreement will basically be useless unless it is registered with the Family Advocate's Office, Parental Plan registered in terms of Section 33 of the Children's Act, alternatively made an order of court. If it's only an agreement, it doesn't really mean much. It's just a piece of document signed by the parties. It has a bit of value in it as to what the parties intended, but it doesn't have any legal effect in that specific regard. We understand where I'm going to. So court order, as opposed to an agreement signed, it's two different documentation. If a party is not adhering to this agreement, yes, you need to take the matter to court. I cannot tell you not to. Sometimes the courts will agree to the specific agreement, or sometimes the court will come to a different conclusion based upon the facts and circumstances of the matter. My advice to you is, if the person is not paying child maintenance, is not doing what he or she is supposed to do, you're supposed to enforce your rights. I always have a policy of moving forward as opposed to taking punches and holding back. You believe that the child will be best in your care, or you believe that the care and contact arrangements are in the child's best interest, you need to fight for that and you do uphold that. Do not, be bullied by the other party, by, I will pay less maintenance, but if you go to the children's court, you might get less contact. That's not the way we want to deal with these type of matters. It's not in the child's best interest. Okay, before we deal with Western Cape, question number 15, the last 3 questions, let us deal with the questions coming from Zoom. What happens if I pass away primary residence and the father not in a position to take care of the child? What route should my parents or siblings take if they want the child to be in their care? We're married but separated, no physical contact with the child, only video call twice a week. Automatically, because you are married to the other party, both parties have full parental rights and responsibilities of guardianship, care, and so on. Should something happen to you, automatically the father will be the sole guardian over the minor child, and he can take the child away, and the grandparents and the sisters and the brothers have no rights over the child. That's the way it is. If you are concerned that should something happen to you, and the father will automatically be the sole holder of parental rights and responsibilities and take the child away, and is not in the child's best interest, and you want to reign from the grave, I'm just giving some advice over here, you need to speak to your family now and advise your family. Family, if something happens to me, immediately go to the High Court or see an attorney or speak to somebody and immediately make an application in terms of Section 2425 of the Children's Act for interested third party like you to acquire certain parental rights and responsibilities. That is possible to be done. So you need to have the conversation now with your family, or maybe now you speak to an attorney regarding that. And should something happen to you, they should immediately approach a court and try to enforce the rights. So what we'll basically do is, let's say something happens to you, heaven forbid, but let's say something does happen to you now, but obviously the child was with you and the father had video contact. Now the next day, after they buried you, immediately, or maybe before they buried you, immediately your parents should approach High Court and say, Judge, the mother passed away, the father only had every contact, whenever by video contact. We would like to keep the status quo for the child to remain with us until there's a full-blown investigation by the Office of the Family Advocate to determine what is best for the minor child. So you're maintaining the status quo. So that's how I will deal with that matter strategically going forward. Okay. I saw another question coming in over here. So that's the last question on the Zoom. We're ending at 12 as I said. So let me first properly deal with those next 3 questions, and I can go back to the Zoom. And if you want to put up your hand, you're welcome to put up your hand, and I'll unmute you. Question number 14. A parenting agreement was signed in the Children's Court, and the father no longer is paying for maintenance and refuses to pay any more than 500 Rand for the support of the child. I don't know what the question is, but if a party is not paying an adequate amount of money which you believe is reasonable and which you believe he can afford to pay, my advice to you strongly is go to the maintenance court. The maintenance court will obviously make a decision and determine what is a fair and adequate amount to pay. So generally the Children's Court doesn't deal with maintenance matters, they deal with care and contact arrangements. I hope that answers the question from Gauteng. If I have not, we have a few moments to deal with that. Okay, today I have to just push the video for the sole reason that at 12 o'clock, these construction people are starting to work in this building. However, next week, we will have this webinar again, and any questions I did not deal with adequately, you are welcome to engage with me next week. Same time, same place. Question number 15. Do I have to inform my ex about my children's lives if he is not paying maintenance? Do I have to inform my ex that I'm getting married? We share 3 kids. Can I cut communication because of verbal abuse? This is the challenge you have. Now you do not inform the other party. What happens then? There will always be controversy. There will always be issues. My advice to any parents who are separated, you need to communicate. You need to go for co-parenting counseling. You need to become the best co-parenting co-parents for your child. That's very important. If there's a court order in place stipulating that you need to communicate and you have to deal with these specific issues via email, you need to do that. So I would strongly advise you, I mean, you're remarrying, it will come out. Send an email to the other party. If the other party is being abusive, go to the domestic violence court, get a protection order. So you have a protection order limiting the other party from abusing you emotionally, psychologically, etc. But you still communicate with this person and tell the person, you could have a protection order. So be respectful here. But I'm informing you that I'm getting married, X, Y, and Z. So I strongly advise, for the sake of the child, for parents to continuously communicate with each other. So I cannot say do not communicate. I cannot say cut that communication. You must try your best that you can do in order for you to avoid that scenario from happening. Question number 16 from KwaZulu-Natal. Thank you, KwaZulu-Natal. Hopefully next week we'll have more from KwaZulu-Natal and from other provinces as well. I'd like insight on having an X-file for primary residence. I'm in KwaZulu-Natal and he's in Johannesburg and he wants residence of an 8-year-old child. Had an inquiry with a family advocate, but I'm still waiting. Okay, so I like the insight on having an X-file for primary residency. The bottom line is the courts and the family advocates determine what is best for the minor child. They look at your circumstances, they look at the child's circumstances and the other party's circumstances. They look at everything. Generally, the professionals comes on board. The family advocate, they will investigate this matter. And if they decide that it is best for the minor child to be in your primary care, they'll make that decision because the child's best interest is of paramount importance. If they make the decision that the child should be in the other party's primary care, they'll make that decision. So my guess is as good as yours based upon this data. But if you feel that you want to have primary care, you need to put your best foot forward and try to motivate to the court why you believe the child will be best cared for by you. And now the last question before you go back to the Zoom. If you want to put up your hand, do so now. Question number 17 from Limpopo. Thank you for joining us, Limpopo. Future maintenance not in the Pension Act and the lack of it in the pension fund. Oh, I think the person is basically asking the question here regarding future maintenance. Can you attach pension funds and how does it apply? That is very, very sad because I honestly believe that a person should be entitled to attach a pension fund. But it's one of those things that the Maintenance Act does not necessarily allow that you can attach somebody's pension fund while the person is employed for the specific fund. I might be wrong. I will have to relook that as well. But what can happen is if the person is acquiring money every month or is entitled to have a lump sum, and that specific money can be attached. Thank you for that. For those who have posed questions, next week again, we're back same time, same place, and we can elaborate further. Let us deal with the Zoom questions, and that will be basically the end of this. Hi. If there is a parenting agreement signed and contact as per the agreement, father access to contact is supervised by the father's mother, and introduction of contact was done over 6 months period to get more. Now the father once again has taken me back to the children's court in unfounded allegations and concerned that this is the second time in the children's court when I have primary reasons over the child. A social worker is on the case and have not found any of the 13 allegations to be true. Father is abusive, and that's why he's separated in the first place, and we are unmarried, and he neglect to pay maintenance. That was agreed by the children's court. I see this is what we're having over here is we're having a serial litigator, someone that always approaches a maintenance court, always causing problems, always, despite there being any merits, he will still go to the maintenance court. My advice to you is, the court is in a difficult position. The court can't say, okay, you're not allowed to ever come to the children's court and lay a complaint, because what if at one point the father has good grounds for this specific thing? So I always advise parties under these circumstances, have a third party being appointed, a social worker or facilitator, a parenting coordinator, that's the term I want to use. So before anybody approaches a court, you first need to go through this third party, this parenting coordinator, to basically audit or to filter out unnecessary grievances. And if there are valid grievances, of course, then the person can go to court, but obviously with the permission of the parenting facilitator, because he would have looked through the system first and analyzed everything. If there aren't any merits for it, then obviously the parenting facilitator would not have given a certificate, and has this person gone to court based upon the parenting facilitator not agreeing to it, the court can maybe potentially make a cost order against the specific person. I hope that assists you with some advice. That is off-the-cuff advice I have for you. And the last question I have, I would just like to find out what can I do on an incident that I came across while visiting my son at a temporary foster care. On the one visit, I arrived to find that my son was full of bruises, bite marks, and scratch marks, especially bruises on his ear and around his neck. I took photos. I would like to find out what I can do. Can I open up a case with the police for abuse? I have contacted the owner of the home and they deny that there are any marks. Yeah, I think the challenge you'll have is to, with the police, I mean, the police will obviously have to investigate the matter. I'm not saying do not do that, but there needs to be some investigation within the foster care system. So you maybe have to go to someone further, Department of Social Development, to deal with this matter. And I would say that might be the better thing to do. Is it abuse? Is it a child maybe fighting with another child? I do not know. Is it a child maybe getting some flea bites? I do not know. I'm just saying, speaking general, speculating here. So the question I have over here is, you may want to consider going above the ladder. Oh, that's a noon gun in the Western Cape. Maybe you heard that. And I think I'll have to deal with this quickly before I hear some noise upstairs. Prime residency is that the child stay with me, the biological mother. Protection order was issued and we signed agreement in protection order court, domestic violence court, I presume, that he will stop the abuse. Okay. But he has not stopped the abuse behavior towards me in front of the child. Thank you. If the person doesn't stop the abuse and there's a protection order in place, he's in violation of the order, I would strongly advise you to go lay a complaint at the domestic violence court and lay a complaint regarding this. I mean, it's a criminal offense to violate the domestic violence order. So do that. So ladies and gentlemen, it's 12 o'clock on the dot. Thank you very much. And the person that commented here, thank you very much as well. Next week we'll have it betterly set up. As I said, the last time we had this live one was in March, unfortunately. But hopefully we will warm up again and try to figure this thing out as we go along. Have a lovely day. Thank you for joining us. Please, by tomorrow, notification will be sent out again for the new next Zoom webinar. Please register for that as well for next week. You're welcome to interact. You're welcome to ask questions. You're welcome to post questions. I'll try my best to deal with all the questions. And by that way, we can all learn and benefit from each other. Have a lovely day. Thank you.
Wonderful. Our official start. Welcome again to our live webinar dealing with the topic of child custody, child maintenance and divorce. Live Q&A part 2. Last week was part 1 where we dealt with quite a lot of questions regarding this specific topic. We have people viewing this video or this live video via Zoom. Those are people who have registered before in the last week to form part of this webinar. Quite a lot of questions were posed. About 13 we have today, dealing with various issues concerning child custody, child maintenance and divorce. If you have a question, those on Zoom, please feel free to put up your hand using the Zoom functionality, and I will unmute your microphone, or I believe you can do it, you can unmute your microphone, and then we can interact. And I call upon you to do that quite early in the webinar. This webinar is not intended to be any longer than an hour and 15 minutes, an hour and a half maximum. So if you have a question, please decide what the question is. Let us engage, let us interact, so that the community out there will be able to learn from our interaction. Nonetheless, those of you who have specific questions on Zoom, you're welcome to type those questions into the message section on the Zoom platform. I will periodically view those specific questions and then we can deal with that as well. So that's the other platform via Zoom. For those of you who are watching this video via Facebook Live, we are streaming on various pages. Please note that you are welcome to post questions on the Advocate Mohammed Abduroaf Facebook page. That is a specific page which I will be making use of, not our lawyer, the family consultancy page. I'm looking at the Advocate Mohammed Abduroaf Facebook page. I do apologize now. There is again still construction in this building, some drilling happening, and I do not know which floor it is. So intermittently you might hear funny sound. I do not have any power over that. And I hope you can be with me, and I'm being with them as well. Nonetheless, let us now begin with today's topic, and I'll be keeping an eye out on the various platforms. And please, on the Zoom, don't forget to put up your hand and unmute, and we can interact with each other. The person asked a question. I was unable to join last weekend Saturday. No, there's no problem with having been unable to join last weekend Saturday. There is a video that was uploaded onto our platforms, and a video should have been sent to you as well, so that is perfectly fine. Let us begin. Unfortunately, those on Zoom cannot see the questions on the screen. There seems to be a problem with streaming on the same PC and at the same time sharing that specific screen. But nonetheless, we're on the same page and we'll be able to get past this very easily. Child custody, child maintenance and divorce. Why did we or me choose that specific topic? It's obviously holistic. It deals with various aspects regarding family law, child issues, etc. Child custody deals with care and contact. You know, when can a parent have contact to a child? What's the circumstance? What's the law? What does the law say regarding that? Rights of fathers, rights of unmarried fathers, children born out of wedlock, and those things. Would contact be 50-50, 1 week with the mother, 1 week with the father? Can contact be suspended? You know, is that possible? With that, I'm also dealing with issues concerning guardianship rights, child custody issues, parental consent, for example, a child applying to a school, an application for a passport, relocation to another country, going for medical procedure, etc. So those are guardianship issues. Child maintenance, we all know what that is. You know, each parent has a legal obligation to support their child according to their means. Therefore, today's topic dealing with that as well. If you have any questions regarding that, feel free to pose it. And I see some questions are coming in via the Zoom platform. I will deal with that shortly. Great. And as I said earlier on, feel free to put up your hand and we can chat as well. So that child maintenance, we all know what that is about. For example, the mother is not paying child maintenance to the father because the father has primary care, or the child is living with the father for 1 week and with the mother for another week. What does the law say regarding that specific arrangement? Could there be a maintenance order in place if there's 50-50 care and contact? Is it possible? Or does the law say that one parent should care for the child for their week and the other parent should care for the child for their week, and we just split the schooling expenditure or the fixed expenditure like medical aid and so on? Nonetheless, those are hypothetical questions and there are answers to that. And those are the questions which I will not answer necessarily because it's not being posed. But if you have the question today, you're welcome to pose it. And then finally, divorce. Divorce, obviously, it applies to the adults, moms and dads. I'm not applying specifically to moms and dads. Obviously will advise people who have no children and they would like to get divorced. What's the legal requirements to get divorced? What are the proprietary consequences of divorce? For example, the money, the property aspects. What happens to the house? Who pays the bond afterwards? What if the parties can agree to what should happen to the house? What happens to pension funds? You know, does one party have a claim against the other party's pension fund? What are the various matrimonial property regimes? In-commuter property, which is a default, out of commuter property, which has two scenarios, with the application of the accrual regime and the other one without the application of the accrual regime. So obviously, those are interesting questions that people might want to ask and would like to find out answers to it because it applies to the specific scenarios, the specific situations. It might not apply to any other viewers today, but if you have an issue regarding that, please ask me and I would like to answer that for you. So before my Zoom chat becomes too full, let me first answer some of the questions that were posed to us whilst the parties when they registered for this webinar. Please note, you can register for our next webinar, taking place next week and Saturday again. You can do that via the link www.abduroaf/live1. My apologies for that. So it's www.abduroaf/live1. You can register for the next webinar. Unfortunately, I see it's not mentioned on our screen. So question number 1 from the Western Cape, my province. I think this was the first person that registered for this webinar. He or she asked the following: why is the judicial system failing me for 2 years for maintenance? Is this normal? That is a typical question I receive a lot. Many people, they approach the maintenance court and they do not get the type of relief or the type of response from the maintenance court, which they would obviously want. And so I generally have we apologize for this, what's happening here on the screen. Yeah, so I have generally a two-pronged answer to that. Number 1, either maintenance court may be assisting you to the best of their capabilities, however, you are not getting the type of relief from the other side. So, for example, you want X amount of rands maintenance per month, but the maintenance court is not assisting you in getting that specific amount because the other party from whom you are claiming from does not want to cooperate, does not want to abide, does not want to comply with your request. That's the one scenario. So the maintenance court is assisting you, but you're not getting the result which you are looking for. The other scenario is the other party can clearly afford to pay the child maintenance, but the maintenance court is dragging their feet. They're losing the files. They're not subpoenaing the relevant parties. They're not invested in your specific matter. So that's the two scenarios which you apply. Sometimes, I think most of the time, I get the scenario where the maintenance court, unfortunately, with respect to everyone, and not mentioning any courts, is not engaged or not invested in the specific file or specific case. The person mentioned something very interesting from the Western Cape. Mentioned the system failed me for 2 years. Now, we all know that COVID-19, I'm not making excuses here, but COVID-19 and the lockdown and the courts operating the way everyone operating the way they have been, has been a bit challenging for everyone. So I do not want to make excuses, but that could have been part of the problem. We all know that courts, at the start of the hard lockdown, everything was shut down, everything was basically closed, and they opened up, and then they started operating in a very skeleton manner. Things were not so accessible, and I'm still certain now they are operating much better. However, that could have affected the logistics of the matter. But that is still no excuse. The matter should obviously have proceeded. So this is the advice I have to you. If you are having problems with the judicial system in obtaining child maintenance, if your scenario is number one, the other party is not complying with your request. The maintenance court calls the parties in, they bring you in, both parties are there, but he or she does not want to pay the child maintenance. Under those circumstances, I strongly advise you maybe to get some type of better legal representation to assist you in your matter. Because the system works, but the enforcement, the maintenance courts only have so much clause, they can only do so many things. So that is the one aspect. Maybe get legal representation to assist you regarding that. But if the situation or the scenario is whereby the maintenance court is very lax, they're losing files, they're not doing their job properly, that I do not accept at all. Under those circumstances, I will start complaining. Speak to somebody above. Speak to the court manager. If that person does not try to resolve this matter, go further up, speak to the provincial minister of justice and make those complaints. So deal with those matters in that specific fashion, because the maintenance court is a creature of statute. They have a legal obligation to assist all parents in obtaining fair maintenance and acting in the child's best interest. So that was question 1, and I hope I've done justice to question 1. Question 2 from the Limpopo province. It is as follows. If a guardian is appointed in a will but stays overseas, must they adopt the minor or make an application for guardianship in order to come and fetch the child? Very interesting question. Now, a child would obviously by default have 2 guardians under normal circumstances, the mother and the father. If the mother or the father passes away, one of them passes away and the other one is alive, then the other party is automatically the sole guardian, full stop. Even if the parent who passed away stipulated in the will, I would like to make my aunt or my sister or my brother the guardian of the minor child, that won't necessarily work because he is a guardian who's alive, and this third party, why must this third party have any powers over the minor child? If the scenario applies to a fact whereby the parent who passed away was a sole guardian of the minor child, and that specific parent stipulated, I would like to have this party, and I'm using the example, my sister, for example, to be the guardian of my child at my demise. Then under those circumstances, the law will obviously have to give effect to it, because in terms of the Children's Act, that is possible. But the challenge you have over here is you have a piece of paper stipulating that. How do you know that is authentic? And you can't go right around the world when applying for a passport for the minor child, showing a piece of document calling a will. How do you connect all of these things? How do you know the person passed away in the first place? So you must move around, apologies, for the death certificate and with a will and try to prove all of those things. So my advice to you is to make an application to the High Court and have the High Court confirm that you are the guardian of the minor child. So that will be in terms of section 24 of the Children's Act, assignment of guardianship rights to interested third parties. So you will basically confirm that, for lack of a better way of stipulating it. You'll leave with a court order, and that court order you can show to anyone right around the world. So if you are overseas and the child passed away, so the parent passed away in South Africa, my advice to you is to get an attorney in South Africa to launch an application. You can stay where you are because the child is living here. Make the application, launch the application, obtain the court order. Nobody will oppose it. There's no interested parties other than you. And then that order can obviously be sent to you, or the attorney can use that order with some power of attorney to have the minor child sent to you overseas. So my advice to you is get an attorney on board. The matter is quite straightforward if the party that passed away is a sole guardian. Question number 3 is an international question from Maputo. Thank you, Maputo, for joining us on this platform. The question is as follows. If the father asks the minor children to reside with him for a certain date and agreed on the divorce settlement, what happens when the date comes and he doesn't take the children? Can I then keep the children? Now, that's a sad thing. And something which I've grappled, and I mentioned quite a lot in public, on various forums, on TV as well, that a parent would be held accountable if he or she refuses the other party to have contact. And that's right, I agree with it. I'm fully supportive of that. But the law does not cut two ways, in the sense of if one parent who is entitled to have contact, who should exercise contact to a minor child, decides not to have contact despite of a court order, basically nothing can happen to that specific party. That specific parent will not be held accountable for that from a legal point of view. A crime is not being committed, although a crime would be committed if the mother, in my example here, refuses the father contact in terms of a court order. So, yes, the answer is, of course, you must keep the child, because who must keep the children in the first place? The other party does not want to have contact or access with the minor child. If this does happen continuously, it happens a lot, then I would say approach the court to have the court order varied to avoid this scenario from happening in the future. The reason why I'm saying so is before put it differently, the father is supposed to have contact with the minor child on the Easter weekend. You make plans for yourself, because you know on the Easter weekend, in terms of the court order, he will have the kids, and you might make plans to go away with a friend or on a holiday, or you're remarried with your spouse, etc. You booked a place for 2 people, and that's it. Easter weekend comes, the father decides, you know what, I now decide, no, and I do not feel for these kids. I want to go somewhere else. I want to go on my own holiday. Mom, WhatsApp her, say, I'm not collecting the kids on this Easter weekend. That causes serious problems, because what happens now? Must the mother now cancel her plans with her friends or with her new spouse, etc., to go away on the Easter weekend as well? Must they now spend more money to bring these kids with them? How devastating is it for these kids as well? So under those circumstances, if it happens because of a very good reason, there's a death in the family, there are certain serious issues that happen, of course, we're all human, it's reasonable, I understand that. However, if the party, he or her, was vindictive or unreasonable, vexatious, and so on, under those circumstances, I would definitely approach a court and have the court order varied to be workable, more workable under the circumstances. I think that would be most probably make more sense. So I hope that answered the question for Maputo, question number 3. Let's move on to the Northwest, question number 4. Let me quickly have a look at our other panels, other questions. Great, our chat is filling up a lot. Please, okay, yeah, I see we have a question. Somebody put up their hand. Let me deal with that quickly. The person who put up their hand, you're welcome to unmute your microphone and start speaking. And let's take it from there.
Good day. Thank you for this opportunity. Can you hear me?
You're welcome. Yes, I can hear you. Please go ahead.
It touches on something that you have begun answering already. So you can tell me if I need to park that and you wish to continue. You were talking about the maintenance. I was the person who submitted that question about the maintenance dragging on. It's actually a combination. You said two prongs, and my experience is actually a combination of both. So I've got an ex-spouse who earns more than double my salary. He's being a high school principal, my being a part-time lecturer. But I'm finding that he's been not very uncooperative. So for instance, I opened the matter 2019 in the Weinberg court. The first date, the January 2020, he didn't appear. Then they served a subpoena and then only appeared in February. Unfortunately, by that stage, I'd been moved out of the home and couldn't continue staying where I was staying in the interim. So I then started renting a flat in Pinelands. Because of this shift, the magistrate was just frank about it, that no interim maintenance, she's not hearing anything. This doesn't fall under that jurisdiction. Transfer the file to Cape Town. So the file gets transferred to Cape Town, February 2020. I hear absolutely nothing. Of course, then lockdown hits. And I go back and forth and back and forth. I've appointed probably my third attorney by that time and had a consultation with the attorney and her advocate. I am out of funds. I am broke beyond what you can possibly even imagine. I am dependent on the good grace and mercy of friends and family to help me support my children and live at the moment. I have made this clear to the court. I've proven it with my bank statements and photos and everything. But what then happened was the Cape Town court lost the file, lost in inverted commas. And that dragged back and forth until when the lockdown levels reached a lower level, I then began complaining about it and nagging until I received, through a friend of mine, an email for Ashika Singh, I think it is. I think she's the head of whatever justice and in the Western Cape. So I emailed her. Then suddenly I got a response and I had movement and people were running around to find the file. But because I had now complained when I went back to the Cape Town court, of course, I was viewed in a very different manner. People were very offended by me having reported and complained and stuff. You know, I was seen as that person who had gone so high up and complained. So then they recopied the file. And then, of course, after they recopied the file, suddenly the file appeared. It was then found. Nevertheless, they made me open a brand new application, which application I then began in August 2020. Both appeared to the clerk in September 2020. Given a date, we go and then the man's, so of course we told what documents to bring forth, fill in, bring our files. I produced my file 1 week before the pre-trial. But my ex-husband, who note is a high school principal, tells the clerk over the phone, because he doesn't pitch, he doesn't produce his file. I'm sorry, I didn't know. I thought I should just bring the file with me when I come to court next week. So the man explains and the clerk says to me, ma'am, he sounds very confused. I said, no, sir, he can't be confused. He's a high school principal. How is he managing a whole school and yet be confused? You gave us both the same sheets of what documents to provide. So then he doesn't come. Then in frustration, my mother draws her last bits of money and says, look, my child, get a lawyer. No matter what, we have to sort this out. You need money for my grandchildren. You can't continue living like this. So I get a lawyer. Then when I go in November 2020, the magistrate says, sir, well, since she has a lawyer now, would you like a lawyer? So, of course, he ums and ahs, and there's death, and there's COVID, and there's all sorts of things. And he has a cousin who's an advocate, and we have to listen to this whole story. And he's very busy because he's a school principal. And this is where the narcissistic element comes through, because every person he meets, he has to tell that he is a school principal, and he's just so busy, and it's matric exams. So then in December, they meet. I didn't have to be present. This was merely to put his attorney on record. Then he's supposed to submit certain documents to my attorney by mid-December because, of course, he was too busy with the matric exams. I don't know if he was writing them or what. He only submits these documents by the end of December 2020. Come the new date, which is only the February 2021, we then appear, his lawyer's not there. Oh, what has happened? No, his lawyer's withdrawn because he hasn't paid the lawyer anything. So we now proceed. Then there was another date. The magistrate wasn't there. There was a different magistrate. I must say he's probably the only one I've met in the 5 years that I've been busy with this, who tried to be helpful and say, look, I'm not interested in your issues with each other. It's about the children. Try and come to an arrangement. The lawyer I had at the time tried high and low. The man is unwilling. He is still holding on to the marital home, which is an 8-bedroom house, refusing to sell it. And by the way, charging me monthly for a room. He was even earning income off that house because he had tenants there. And he just point blank tells the magistrates, oh, I'm sorry, I can't afford it. I can't afford it. And they just fall for this. My lawyer said, are you telling me you choose to maintain an 8-bedroom house, but you can't afford to pay maintenance for your 2 children? Yes, no, I can't. Oh, shit. He puts his hand on his heart and gives a whole dramatic performance. Then, of course, it's back and forth dates and things get postponed. And then he wants more information on this and more information on that. He's wanted printouts of the children's accounts which don't even exist. I've gone to the banks to get letters from the bank declaring that this is the only account in the child's name. And then our most recent, and then of course there was one date in April where he just didn't appear. Now surely that was contempt. He doesn't appear, they don't do anything about it. And then he submits a medical certificate which shows that the time he went to the doctor was only that evening of the day that he was supposed to be in court, which to me was a bit suspicious. But the magistrate doesn't say anything about it. The clerk doesn't say anything about it. We enter the next date when the trial only began. This is from 2019, only began in April 2021. And the magistrate doesn't say a word about his contempt of court, not pitching. And now my last date was just postponed. We just got an email from the clerk saying, sorry, it's postponed. And I'm still waiting for a date. And in the meantime, I'm living off buying waste in the shops and people's kind donations like a charity case. Now, how can this be okay? But our wonderful president makes great speeches about gender-based violence. I've had my full of dealing with I've tried to get I've been to the domestic violence court about psychological and emotional abuse. I've had no joy there. My entire experience of court, and this is why I asked our magistrates clued up on dealing with narcissists. The attitude of the magistrates at the Bishop Davis Court was, oh, okay, so if he's not hitting you, okay. So he's not hitting you. So the only kind of abuse taken seriously seems to be physical. I've spoken to the court manager in Cape Town. She referred me to some different women's organizations. I call them. They say to me, no, they can only help me if it's a matter of domestic violence. I phoned the Legal Society. They can't help me. What do I do? Really, what do I do? I'm sorry for becoming so emotional, but this has really been an arduous process. Thank you.
No, you're welcome, and thank you for sharing that with us. Now, your story obviously is something which I do hear quite often, and many people do not believe it because they think it only applies in theory, but not necessarily applies in their life. And that is exactly why these questions are being posed and why all these people are posing these specific questions, because the maintenance courts are failing people. And also with my past webinars with Felicity and guests, quite an activist in child maintenance matters, that is a narration coming from what's happening in the maintenance courts. The government on paper draws beautiful legislation, beautiful amendments to the Maintenance Act, stipulating that now you can, blacklist a person, you can use Vodacom, MT, and Cell C to get the person's details into the maintenance orders can be made based upon previous agreements and so on. However, the reality of the matter is the maintenance courts needs a revamp. So to the caller, unfortunately, I can sympathize with you, and I wish I had a quick answer, do this, do that, do that. I have a range of possibilities you can do, and my best scenario would be complaining to the ministers, complaining to the provincial government, because if there's apathy on the ground level from the maintenance court's point of view, clearly it's ongoing. So you might be the one file, and tomorrow someone else comes and they'll perpetuate the apathy, the nonchalant type of ways of dealing with these type of matters, and they need to be exposed. I'm not referring to any person specifically, you can quote me on this, but they need to be exposed. These officers, these maintenance clerks, if they aren't doing their jobs, and I know you have complained to the court manager, maybe they're also part of, the same type of attitude, is this one of those things, we are overworked, we have many files, whatever the excuses are, but it is totally unacceptable. The Children's Act, the Constitution, there is an imperative on the maintenance courts to do their jobs, to ensure that maintenance is provided. So my advice to you is, I do not know how far you went up to the minister's office, going writing to the radio stations, writing to the newspapers, to the TV, complain to them, explain to them your situation as you outlined it here. You've approached a maintenance court, this is the timeline, they're not doing their jobs. Let them get on board here, let them now start consulting. I'm talking about the media, with these maintenance officers, mention names. Let us get some answers, because I think that will be the only way we can actually, get results without spending money on legal fees, because legal fees is so expensive. And the problem is, should you spend money on the best attorney or advocate, and that advocate now has to deal with a nonchalant court, I don't think you'll get your money's worth. So I sympathize with you. You're welcome to pose any further questions. You have our email address. You're welcome to pose any additional questions via email as well, and I hope I'll be able to assist you. But my advice to you under these circumstances, something that will not cost you anything, is to complain. And I do know, and I say this because based upon years of experience, that if you complain to the right person, and the proper noise is made, people start doing their jobs properly. So I hope I have been some type of assistance with you, and you're welcome. I saw the comment you made now. Thank you very much. If you have any further questions and you would like to join us again and like to call in again, put up your hand and I will be happy to unmute you, or you can do that yourself. Thank you very much for that. Okay, let us go to question number 4, and at any time you're welcome to pose any additional questions. Question number 4 from the Northwest. How does one claim for past costs the prolonged maintenance dates the courts have led to me paying for everything, and the father says he will only pay for what the court said he should? Interesting question, and a question which many maintenance courts and officers do not know how to apply, and that's very sad and very strange. And I'm speaking about experience. The question basically being posed over here is, yes, we all know if you apply to the maintenance court and you apply for child maintenance, the order going forward is always granted. For example, okay, the father can afford to pay maintenance of X amount of rands. You should be paying that from the 1st of the next month or the 7th of the next month going forward. But what about the maintenance incurred for the minor child before the order is granted? Let's say the child is 6 years old, the father never supported the minor child. What happens to that? Now, in terms of the Maintenance Act, you are allowed to claim for that amount. It's not a real maintenance because there's no order that has been made, but it's cost incurred for the minor child. You're also allowed to claim for birthing expenditure for the minor child as well, despite the child now being 6 years old. It is possible. So I implore to everyone, if you are applying for child maintenance, ensure that in your application form, stipulate, I would like to have the following moving forward. Of course, the court must still inquire and determine whether or not it's reasonable, but I'm also claiming for child maintenance since the birth of the child, the birthing expenditure up until now. It's very important that you do that. Come with a figure. Nobody will know for exactly how much it will cost because you didn't keep receipts. But obviously the child maybe went to creche, the child needed to eat, So you can come with some type of a figure. So the child cost, for example, now, for example, X amount of thousands of rands per month, whatever it is, maybe work it down. Obviously, there was inflation, things cost a bit cheaper at that time. So please look into that. The Maintenance Act is clear on that. On the application form, it deals with that as well. So I hope that answers the question from the Northwest. Question number 5. How does an unmarried single parent get a passport for a 6-year-old child? The father cannot be found and the child is solely raised by the mother. Now, that is one of the questions which I deal with in webinars a lot, and a question which I get posed to a lot, and something which I, on a regular basis, appear for clients in court for. In terms of the Children's Act, both guardians of the minor child should consent for the minor child to be given or issued a passport. So that's the law. So the mother might go to the go to the Department of Home Affairs. The mother will go there and say, I would like to apply for a passport for my minor child. Here's a birth certificate. I do not know where the father is. They will say, no, that's, maybe you're lying. I'm not saying they say that. Maybe the father is around, but you want to leave with the child overseas without the father's consent. And the law says both guardians' consent is required. And they will persist that we will not provide you with the passport unless the father is present to give consent. I presume some departments might not follow that. I do not know, but that's a general trend which I've been experiencing over the last few years. I've had clients who had a scenario where they could not have found the fathers 5 years ago, 6 years ago, and the Department of Home Affairs then have issued a passport without the father's consent, but then they come see me 5 years later because the passport expired. And I ask the question, they say, no, that time it wasn't a problem, but now it is a problem. So it seems to me the Department of Home Affairs is causing that, are requesting or demanding that we will not provide a minor child with a passport unless both parents are present to give consent, unless a court orders otherwise. Either divorce order will stipulate that the mother's consent is only required, or the Children's Court might make an order in that regard, or the High Court will make an order in that regard. Regarding matters concerning passports, I would advise you to approach a High Court for such an order. The High Court will obviously not only deal with the issue concerning a passport, I'm referring to the specific questionnaire now on the screen. The High Court won't only, or your application should not only be for the dispensing of the father's consent for a passport, your application should deal with various guardianship rights as well. For example, you do not require the father's consent for the child to be enrolled into a school, for the child maybe to relocate, whatever the case may be, because you have a specific problem here. The father is missing in the child's life. So under those circumstances, go to the court for an holistic view order dealing specifically with how can a court resolve issues going forward because the father is missing. Tomorrow you have to enroll the child into high school. The schools are saying, no, we require the father's consent. We're easy. Then you'll have to move from high school to high school until you find us one high school who is sympathetic with you and willing to enroll your child without the father's consent. So if you are, the specific questioner, going to approach a high court to dispense with the father's consent for the application for a passport because the father is now missing, you can't find the father, ask also that the father's guardianship right be disposed of completely regarding the minor child. Because you can't find the father, unfortunately, you'll have to make an application for substituted service, meaning you'll have to serve or notify the father regarding your application via the government gazette or the local newspapers and so on, depending upon the court. So I hope I answered that specific question to you. Just be smart on what you're asking for the court. Ask for a bit more than less. Question number 6 from the Western Cape, and here all the questions are from the Western Cape. I have been trying to get a divorce court date for 3 years. What is the delay? Okay, my quick answer could be possibly COVID-19. I do not know which court it is the High Court or the Divorce Court, the Magistrates Court. That could be an issue. I also do not know how far the divorce proceedings are. Have
the various internal aspects of the divorce been resolved, for example, discovery of documentation, pretrial conferences, and so on. The case management part of it has been resolved. But once all that have been resolved, then the court date should be quite a few months, but it shouldn't be more than a year, depending upon the court. So if you are legally represented, many times, and that's come to my desk, and I'm not saying it happens in practice, it's the norm out there, but when complaints come to me, obviously, it's because there are problems. The attorneys do not communicate with the clients. They do not advise the clients what is happening in the specific case. So speak to your attorney. If you do not have an attorney found out by the court, what is happening, what is the delay, and let that delay specifically resolve the matter. Because, for example, sometimes the courts are efficient, but the parties themselves are not completing their specific role. For example, discovery of documentation. You know, for example, if you would like to use a certain document in court at a hearing, for example, maybe a pension fund document, or a report from a professional, whatever the case may be, you have to disclose that specific documentation to the other side, discover it. And that could be something that can cause a delay in the finalization of the matter. Because no court will give you a court date unless the internal or the procedural aspects before the trial date has been resolved. I hope that answered that question for the Western Cape. Question number 7. Why does a father get away with not paying maintenance? He buys new cars and wears flashy clothes. This is unfair. Of course it's unfair. I mean, how can someone who is obviously living a reasonably good life here buy new cars, wear flashy clothing, not pay child maintenance? I cannot take this a bit further, but then you should apply to the maintenance court as soon as possible and start doing your thing, you know, enforce your rights to child maintenance with a minor child. As the person who called in early on mentioned, there are certain problems she has experienced, and obviously the father in her specific scenario was one of those deadbeat fathers who does just not want to pay, or there's a principal of a school. My advice to you is go to the maintenance court, do what you can. If that doesn't work, climb up the ladder, but don't fight until you obtain child maintenance. I know it's sometimes difficult, and but all that I can say is don't give up. Question number 8, in favor of the other party filling up their sales. So it depends what side of the fence you're on. My experiences are when the courts do find in favor of the mother, it will generally be in a child contact or care and custody matter when the child is quite young and the child is in the primary care of the mother and the court is convinced obviously the child would be best cared for by the mother. So there's a bit more of a preference for the child to be with the mother based upon the age and who's caring for the child. As the child gets older, the preference starts going away and we focus more on what's best for the minor child, not necessarily gender, based upon the gender, but more holistically speaking. But the law, the courts should always apply what's best in the child's, what is in the child's best interest. Sorry about that. If it's a child maintenance matter, I do not see any reason to argue that the courts find in favor of the mother. I would say it all depends upon the mathematics of the case. Of course, if the father is super wealthy and the mother is not so wealthy, not doing too well, then obviously the mother's case becomes a bit easier. And the father who has the money might not be happy with that. Question number 9. Can I change my marriage to A and C? Interesting topic. Okay, this applies more, not to divorce, more to marriage, but it does form part of our theme. Now, A and C means antenuptial contract, meaning the two scenarios out of community property with a accrual system, and the other scenario out of community property without the accrual system. We all know what the accrual system means. It's basically benefiting from the other party's growth of the estate. I'll give you a quick example. If the parties are married out of community property, meaning that during the marriage, whatever belongs to you, what belongs to him belongs to him. So there are two separate estates. And if you are married without the accrual system, meaning at divorce or at death, that remains the case. What belongs to you belongs to you, what belongs to him belongs to him. If you are married out of community property with a accrual regime applicable, obviously you would have entered into an antenuptial contract stipulating that. And during the marriage, what belongs to you belongs to you, what belongs to the other party belongs to the other party. People can't come and take money from you because your spouse owes them money. However, at death or divorce, that's where it kicks in. if you are married with a cruel regime, you would have a claim against your spouse for basically the growth of his or her estate during the marriage. That's a quick and simple way of explaining it to you. So if at the start of the marriage, your spouse's estate was worth, let's say 100 Rand, and at divorce, his estate is now worth 1,100 Rand. And your estate at marriage was 0, and now your estate is still worth 0 at the divorce. Meaning your spouse had a growth of 1,000 Rand and you had no growth. Meaning that you would obviously be entitled to 50% of the growth of your spouse's estate. Meaning you would leave the estate worth 50 Rand. Sorry, 500 Rand. My apologies for that. And your spouse will leave the estate, leave the marriage, my apologies, with 500 Rand. So you work it out that way. If your estate grew to 10,000 Rand and his estate only grew by 1,000 Rand, then obviously you will have to give him half the difference, which would be 4,500 Rand, because you deduct the growth of your estate being 10,000 Rand less the growth of his estate being 1,000 Rand gives us 9,000 Rand. The difference is 4,500 Rand. So yes, it is possible to change your marriage to an antenuptial contract. Basically what the person is saying here, can you change it to out of community property? That would be an application to the High Court. It needs to be the High Court. It cannot be done in the Children's Court or the Divorce Court. You approach the High Court and you make an application to the High Court for the change of your matrimonial property regime to out of community property. So that is possible. The court will grant that if the court is convinced that it will not be prejudicial to your creditors. That's one of the requirements. And of course, you must live within the province and so on. So that's question number 9. Yes, it is possible. Question number 10. Yes, there's only 13 questions. Okay, those of you who are online, please note you are welcome to put up your hand and I will deal with you as well. You will put up your hand on the Zoom and you can call in. And after question number 13, we will go to those specific questions on the Zoom. Question number 10. Can adopt a person who is 23 years old? Very interesting question, and not the first time that question has been posed to me. Can you adopt an adult? The answer is no. He's an adult. You can't adopt an adult. You can only adopt a child under 18 years old, yes. So 17 and below. Question number 12 from the Western Cape. Why do I need to undergo a blood test if I'm not the father of the child? 2 scenarios. Number 1 would be child maintenance. The mother says, you know, you are the father of the child, you should pay child maintenance. You say you're not the father. Of course, how do we resolve this matter? Be via blood test. That's unfortunately how it works. The mother will say, I was in a relationship with his father, didn't work out, child gets born, the father says, I'm not the father. How do we resolve it? We go and do a blood test. Question number 13. The last question from the from the pre-registration. The mother does not want to work. The court sees nothing wrong. Okay. Why must I pay for all the school fees? Very interesting question. It's obviously a question regarding the courts. The courts should obviously be fair. The court should not prejudice one parent above the other parent. If the mother does not want to work, the mother must explain why she does not want to work. Is it fair? Is it reasonable under circumstances? If it's not reasonable, answers are not reasonable, the court will obviously have to now force her to go to get a job. And the court should not see nothing wrong with the mother not wanting to work. But there is a specific scenario that could be applicable that says it makes more sense for the mother not to work and the father should contribute all of the minor child's expenditure. I do not have the scenario in front of me. All that I know is that the law says that each party should maintain a minor child according to their means. So the mother cannot decide on her own, I do not want to work, I will not be responsible for any of the minor child expenditure, but the father must be the one that works and he must pay for all the minor child expenditure. That is totally wrong. So I would implore upon you, bring that argument to the court and stipulate, I can only afford to pay the following, or I will pay for everything so long, but the mother needs to show to the court that she is trying to get a job and she is trying her best to become employed. Thank you for that. Those are the 13 questions to the participants who have registered and posed questions. Many participants have not posed questions. There was quite a huge amount of people who registered for this webinar. Obviously, you do not have to join via the Zoom. You might be working, you might be shopping, you might be attending to certain things. But the nice thing about the registering for this webinar is that you'll get a video later on, and I would obviously deal with your specific questions. So let us now move on to the live questions on the Zoom. Let me just move the screen over here. Let me just sift through them. Sorry about that. Okay, the first question is, how do I deal with an ex-spouse who refuses to sell the family home and pay me half share? Okay, the court order says it should have been sold in December. Is this not contempt? Okay, let's deal with that. If the court order says it must be sold, it must be sold. And so you make an application to the court to force the sale of the property. And basically what happens is, if the other party does not want to sign any documentation, the court order will stipulate specifically that if he or she does not sign the specific documentation, the sheriff of the Honorable Court will be authorized to sign the documentation. So you make an application to court, you outline the facts, you outline to the court that there's a court order in place, and the property must be sold, I must get my half. The party obviously did not comply with that. The court makes an order that the property will have to be sold either by auction or private sale, whatever the case may be. And if the party does not want to sign, the sheriff will gladly sign and the property will be sold. So that resolves that matter. The unfortunate thing is you'll have to go to court and it costs some money for that. Yes, the same person who posed the question early on was, why does it take so long to obtain maintenance via the maintenance court? That question was answered early on as well. Then I have an additional question. What is the ratio of earning? What if the ratio of earning is very different? Surely then 50-50 cannot be applied. Of course, you do not pay maintenance based upon 50-50, you pay maintenance based upon your earnings, your proportion to your means. So if one party earns much more than the other party, of course, he or she must pay more money. However, it's very important to note that when we say means, we're not referring to only income, we're referring to assets as well. So it is possible for somebody who earns very little money, let's say 10% of what the other party earns, but he or she owns property. I'll give you a practical example. Let us say the father earns 50,000 Rand per month and he owns no property. The mother earns 10,000 Rand per month, but she owns property worth millions, let's say 50 million Rand worth. Now, her income is less, is 10,000, and her father's income is 50,000, but she owns property worth 50 million. I'm upping the figures here. Clearly, she should be paying a greater amount of maintenance towards a minor child as opposed to the father, although her salary is less or her income is less. She might have to be paying 90% of the income based upon her asset value worth 50 million. Next question on the live Zoom. How does a single unmarried mom apply for a passport if there is no contact with the father? I think I've answered that question early on. We'll have to make an application to the court. And the court, because if you can't find the father, then obviously you have to get the court's consent to serve him via the newspaper, whatever the case may be. And then you approach the court and the court will obviously grant you consent. But as I mentioned early on, the best thing to do is to get a holistic order whereby you will never require this person's consent again going forward. Make an application for substituted service, meaning service via the newspaper, it can be very expensive. So try your best to find the whereabouts of the father. Getting a tracing agent, some of them do not charge if they don't find the person. It should not be that hard. Speak to his family and so on. Next question, somebody that partook in last week's webinar, welcome back again. As I mentioned last week, I am busy waiting for the report from the family advocate. My ex-husband seems to be very confident that he will be granted primary residency of our son. He has created a fake Facebook profile and stalking my page. Makes it seem like I'm promiscuous, and based on my social life, says he will be granted residence. Does the family advocate take into consideration the social media status of a parent, or is it solely based on being an unfit parent? Yeah, I think the family advocates are past, looking at social media and let's say, you're living a good life. I mean, when you're dealing with these type of matters, you have to look at the matter based upon the facts of the matter. Who can care for the minor child better? So if you are somebody that enjoys partying and living the good life, and if you are promiscuous, I'm being hypothetically here, the question still is, can you care for the child? That is the bottom line. So if you go out at night, the child is well looked for after at home, and you go out and you enjoy yourself, you're allowed to do that as long as the child is being cared for properly. So I hope that answers the question. So what your ex-husband is doing, he's doing that, but I don't think the court will make a decision based upon that. There's so many other things to look at. It's like a car is worth, they say, 500,000 rand worth, and now the tires are dirty. Doesn't make the car now less worth. The car is still expensive worth, So we don't look at the tires alone and make it say no, because the tires are dirty, the car is useless. We look at the thing holistically. So I hope I answered that specific question over there. The court will have to apply their mind to the matter and make a decision what's best for the child, just considering all factors. Another question, are magistrates trained to realize when they are dealing with a narcissist? I do not think they are trained specifically regarding that. I think they should be able to see it, if they are dealing with that. But sometimes with the limited interaction with this person in front of the court, they would not necessarily know that, because a narcissist puts up a certain presentation, and you'll only know this person is a narcissist if you dealt with that person on a regular basis for months, or you lived with a person, or you had a relationship with that person. You do not necessarily find it out at the first meeting with this person. And I would imagine these magistrates meet with these people, they waited 20 people before him or her. That person comes in front of him, puts their best foot forward, and the magistrate would not be the wiser. And a comment regarding that, good question to that person that asked about a narcissist. Another question. Oh yes, another person commented over here. It says, you are welcome to join me in contacting the media. So ladies and gentlemen, those are all the questions that have been posed today. I see no questions on the Facebook Live. Any of my Zoom participants, if you have any questions, you're welcome to pose it now. We are now entering into exactly 1 hour. That's a good time to end this webinar. But if there are any questions, you are welcome to pose it. You're welcome to put up your hand. If I have not dealt with any of your specific questions, please feel free to put up your hand and I will deal with that. Okay, I see the hand up here. You're welcome to unmute your microphone, the person whose hand is up.
Thank you. I hesitated just in case someone else would like an opportunity, because I did have one earlier. I take note of what you've said about pursuing further and going to the media, etc. And I've jotted down a few ideas of places. It's not the first time that I've heard this. And I tell you what's been holding me back is the fear of, obviously, retaliation from the narcissist. And because, he would be crazy enough, even if he has no money, he would take a loan out just to sue me for defamation or, whatever the case may be. So should I be concerned about going to the media, or should I refrain from naming his name? How would you advise to go about pushing the matter forward publicly and yet being safe enough? Because I clearly can't afford to defend myself.
No, that's fine. I understand where you're going to. I think, if you'll be laying a complaint against the maintenance officers, and you'll be laying the complaint to them formally, number one, and you'll be most probably informing the media as well that I have a problem with the maintenance courts, with the maintenance system. So they might not necessarily be interested in your specific facts. They will obviously not mention the minor child's name. They won't mention certain parties' details. They shouldn't do that. But you are now making it public to the media that the maintenance courts are acting inefficiently. maybe not only, it does not apply to your specific case, it applies to various other cases as well. So that would be the angle regarding that. Your angle will not necessarily be, I'm exposing my facts, my specific case to the maintenance court or to the media, to the media.
Okay.
I'm exposing the issue that I have with them not assisting me. Are you with me on that?
The general issue, I get that, and I would be able to do that. However, when going back to the maintenance court, because my issue is as yet unresolved, does that not mean that I would now have jeopardized my own application? Wouldn't they hold that against me?
I do not think so. I would say you would fall more of a... It depends on your complaint. You are complaining to the media that the maintenance courts are inefficiently dealing with my matter because I have climbed the ladder. You know, I have gone further up. I have complained to the court manager. They have not assisted me. I've laid a formal complaint. I've laid a formal complaint to the local government, you know, provincial minister of justice, dealing with the issues I have with the maintenance court. And I'm still nowhere where this is concerned. Therefore, I'm informing the media about the problems I have with the maintenance court. Are you with me where that is concerned? So, but I would advise you to first maybe follow those specific avenues.
Okay.
Formally doing it and advising them that you do not assist me, I will have no alternative but to expose the, you know, improper functionings of the maintenance court, because this is now my time frame, which I have. And as I mentioned earlier on, when you move now to from Wynberg to Pinelands falling under Cape Town, they should have expedited your file, because they should have, if they could not have granted you with a interim maintenance order in Wynberg because you now moved, they should have ensure that the file is as quickly as possible it goes down to Cape Town Court with notes in place stipulating we do not have jurisdiction. Please assist this lady as soon as possible. So if you look at the Maintenance Act, and look at the regulations, and look at the Constitution and the Children's Act, and all these specific laws, the case laws applicable, you would think that anybody going to the maintenance court, they will act as an ER, as an emergency room, you know, working as quick as possible to assist you. That is the theme that comes out of the law and the legislation. But the reality is, when you go there with a child that's hungry, you know, people not being fed, you know, people not having money, although the other party has money to pay, they don't treat it as an emergency, they treat it as another file which we'll deal with in due course. And that's a flavor which needs to be presented to the public, telling them that despite the maintenance courts and the law coming across that the maintenance courts are there to assist you. Yes, and they do assist many people. Don't get me wrong. I'll be honest with you. I have to be fair. But my case over here, they have not dealt with it in a very fair fashion, and I would like to complete. So I've you know, followed all possible remedies I could have followed internally. They still didn't assist me. I have no other alternative but to expose the maintenance system.
Okay. Okay. Thank you.
You're welcome. You're welcome to, for that. So unless there's anybody else who's putting up their hands, I think we are basically done for today. And I would like to thank each one of you for posing those questions, all those 13 questions. For those of you who have registered for this webinar, there is a webinar next week and Saturday again. It will most probably be again at 11:30. Please register for that as well. And I like this interaction, and that's the only way we can all this benefit and learn from each other. So, and those of you who have came on The Voice, unmuted the microphone, thank you very much for that. And those of you who pose questions as well live via Zoom. I hope you have a lovely day. Saturday, it's now 12:33. I hope you have a wonderful weekend going ahead, and I hope to see you online next week and soon again. Thank you very much. Good afternoon. Thank you for joining us on this live webinar. Today's topic, does child custody matters need to be a fight? And if you can see on my right-hand side, there's a lady hitting a guy. I'm not trying to be gender unequal in the sense of why is a female hitting the man. I did for a picture online, and that's the one we could find. Nonetheless, it's proverbial, fight, not necessarily physical. Does child custody matters need to be a fight in the sense of, must there be a battle? Must there be an argument? Must you get lawyers on board? Must you, you know, put up guards and prepare yourself to take the other party on or to teach the other party a lesson? Must there be acrimony? That's where I'm going to. Or Can the matter be amicable, friendly, settled easily? Is that possible? Or does it need to be a fight from the word go? For argument's sake, if the mother says, "Father, is it fine if you do not have contact on a Sunday evening so that the minor child can come home early in order for me to prepare him for school the next day?" The father says, "How can you tell me that? I'm the father. I can decide when I want to bring the child back." There's this continuous acrimony, argumentation all the time. So that's the topic. Does child custody matters need to be a fight? Or can it be amicable? Can it be friendly? My advice to you is, if you want to get good results out of your child custody matter, it should not be a fight. That's where I'm going to. Once parties are no longer civil with each other, whereby the parties are now arguing with each other all the time, they're always involved in acrimony, they're no longer amicable and civil as they used to be while as they were together, as husband and wife, as partners, lovers, friends, whatever the case may be. Once that is out of the window and the parties are losing respect for each other, the challenge which we as lawyers and third parties who are there to assist parties in resolving the issues have is that the door, or that one specific door that you could always use in order to resolve issues, are no longer there. That is the respect the parties have for each other. I can use a simple example. If there's a meeting taking place, there's a chairperson and there are parties to the meeting, and the meeting follows a certain procedure. When one person speaks, the other person listens, and so on. You can object if you want to, but in a very nice and proper way. However, if people start shouting at each other, they start disrespecting the chairperson starts disrespecting the participants of the meeting, what happens then? They lost respect for each other. It is virtually, not I would say impossible, but it will be extremely hard for the parties to move forward in a constructive and a workable manner. It's very hard. Therefore, the question which I am posing again, does child custody matters need to be a fight? My answer to that is simple: no, it does not have to be a fight. It has to be understandable. There needs to be understanding. The parties need to be able to be in a position to listen and ponder upon what the other party is saying, where they're coming from, where are they going to, and with the hope that the other party will understand where you're coming from and where you're going to. However, if the parties are entering into the specific arena, into this ecosystem, with the intention of battling and fighting and showing the other party a thing or two, 9 out of 10 times, the matter will not be resolved in an amicable manner. And what does it mean? It means that you have to get lawyers on board. You might not get what you are entitled to. Justice might be delayed. For argument's sake, let's say you are the father and you'd like to have contact with the child on a certain date, because you took this antagonistic approach in dealing with your specific problem. The other party might be very hard-headed, make life very hard for you, causing you to incur more fees, causing you to pay lawyers a lot of money in order for them to fight your battles for you. And at the same time, should this matter come to a court, to a tribunal, the magistrate's court, the children's court, whatever the case may be, and they see these issues before them, that father and mother are very toxic with each other. In other words, whenever the mother and the father are in the same room together, they start arguing, they start fighting. And that might have an adverse effect upon which order, or what type of order, the court may make in the specific child custody matter. So in short, that's what this video is all about today. Does child custody matters need to be a fight? The answer is no, it does not have to be a fight. It is advisable if it is not a fight. In that specific way, you will get the best possible results in the matter. I hope it assists you, and thank you for watching, and I hope you have a lovely day. Good afternoon. My name is Mohammed Abduroaf. I'm a practicing advocate in the Western Cape, and today's short video will deal with the aspect of child maintenance. When it comes to child maintenance, the child's best interests are of paramount importance. This principle is immortalized in our Constitution and applied in our courts of law. Therefore, in relation to child maintenance matters and specifically to child maintenance courts, the moment a parent files an application for child maintenance, the principle should apply. Before we move on a side note, it is not only child maintenance that a maintenance court deals with. A spouse may take the other spouse to the maintenance court for personal maintenance. Let's move on to parental maintenance obligations. Both parents have a duty of support towards their minor child's proper living and upbringing. This should be in accordance to their means, standard of living, station in life, and the needs of the child. This is found in our Constitution, common law, and also applies to divorced parents. According to Section 15.2 of the Maintenance Act, the duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. Furthermore, the duty is not discharged when one parent earns substantially more than the other. According to Section 15.3 of the Maintenance Act, in determining the maintenance amount, the maintenance court must take into consideration the following: that the duty of supporting a child is an obligation which the parents have incurred jointly, that the parents' respective shares of such obligation are apportioned between them according to their respective means, and that the duty exists irrespective of whether a child is born in or out of wedlock, or is born of a first or subsequent marriage. Any amount so determined shall be such amount as a maintenance court may consider fair in all the circumstances of the case. Lastly, there is an onus on both the maintenance officer and the maintenance magistrate in placing evidence before the court in determining a fair maintenance amount. This is our starting point. Processing the maintenance application. When a parent approaches the maintenance court for child maintenance, it is the duty of the maintenance clerk to expeditiously process the application. In doing so, the clerk, through the other resources the maintenance court might have, should ascertain the details of the other parent and ensure that he or she is brought to the maintenance court as soon as possible for a maintenance inquiry before a maintenance officer. Therefore, for example, should the maintenance clerk not have the living or working address of the father or the mother, then he or she must enlist the assistance of the maintenance investigator to obtain it. For that, he or she can make use of search companies, tracking resources, the maintenance investigator, and furthermore banks, SARS, etc., in order to obtain the details of the other parent. Now, let's move on to the issue concerning getting the non-paying parent to the maintenance court. After the maintenance application has been processed, it is a duty of the maintenance court to ensure that the non-paying parent makes his or her way to the maintenance court as soon as possible for a maintenance inquiry. This inquiry is held before a maintenance officer. Even if the maintenance court's diary is quite full, it should still be expedited, giving both parents adequate time to make arrangements to appear at the maintenance court. Therefore, if the next available date for the maintenance inquiry is in 3 months' time, the parties can use this time to make arrangements with their work, obtain necessary information for the inquiry, or make alternative school traveling arrangements for the kids. There should therefore not be a delay in notifying the parents of the date of the maintenance inquiry. Furthermore, when notified of the court date, both parents receive a document stating what information they should bring to the maintenance inquiry. These include 3 months bank statements, salary advice, and proof of expenditure for the parents and the minor children. Giving the parties adequate time to obtain this information will be vital and in the child's best interest. The last thing we want is for the matter to be postponed, to another date due to either parent not having been given adequate time to obtain such documentation, even though the mother made the application many months ago. Now let's move on to the maintenance inquiry before a maintenance officer. The maintenance inquiry is the next legal step in the process. This is where both parties appear in court. This is where things becomes a bit interesting. Sometimes at the inquiry, it is the first time the parents are in the same room together. Since the child was conceived, quite often both parents do not know how much the financial both parents do not know the current financial affairs of the other parent. The parent asked to pay the child support, furthermore, does not know how much a child costs to be maintained. Then we have the possibility of the issue of denial of paternity. What sometimes happens is that the father denies paternity. This he would either do out of spite or due to genuine doubt on his side. This would often be the case if there was a brief encounter between the parties when the child was conceived. Sometimes the father is married to someone else, and for the sake of his current marriage, he needs to deny paternity. Once the paternity tests are finalized, the parties would need to return to court again for the results. If the results are positive, in that he is the father, then the inquiry proceeds. If he is not the biological father, the application would obviously be removed from the role. Now we can move on to the role of the maintenance officer. Again, the golden standard in which the inquiry should be conducted is that of the child's best interest. This is of paramount importance. The maintenance officer should therefore ensure that all the financial information about the parties are properly disclosed. This is very important. However, at the same time, the maintenance officer should try to settle the matter, taking into consideration the child's best interests. Should the parents not be forthcoming regarding their income and expenditure and the needs of the child, then the maintenance officer must subpoena witnesses if need be and make use of the maintenance investigator, which is dealt with next. Section 7.1d of the Maintenance Act empowers the maintenance officer to require a maintenance investigator of the maintenance court concerned to perform such other functions as may be necessary or expedient to achieve the object of the Act. Section 7.2e of the Maintenance Act empowers the maintenance investigator, after being so instructed by the maintenance officer, to gather information concerning, number one, the identification or whereabouts of any person who is legally liable to maintain the person mentioned in such complaint or is alleged so liable, the financial position of any person affected by such liability, or any other matter which may be relevant concerning the subject of the complaint, or gather such information as may be relevant concerning a request referred to in section 1c above. Now that we looked at the important role of the maintenance officer and maintenance investigator, we move on to the role of the maintenance magistrate. This is where the formal inquiry takes place. Should the parties not be able to come to an agreement regarding the amount of child maintenance to be paid at the inquiry before the maintenance officer, the matter would then have to be taken or forwarded to the maintenance magistrate for formal inquiry. Here the court has to properly consider the means and needs of the mother, the means and needs of the father, and the needs of the minor child, therefore make a maintenance award. There is a legal obligation upon the maintenance officer and the magistrate to conduct a thorough inquiry. The court should not play the role of an umpire. Therefore, a passive attitude should not be taken by a judicial officer in a maintenance inquiry and then give judgment. Should all go well, at the end of the inquiry, a maintenance award should be made. We thank you for watching this video, and we would appreciate it if you could share this video, and we're looking forward to you partaking in the next live video. Thank you. Good morning. Thank you for joining our live webinar. Today's topic, child custody and child maintenance, Q&A. Good morning. I received a few questions from persons regarding this topic, and it seems to me that there is a need for a live Q&A at least once a week, whereby you can send us questions and we can deal with it live on our platform. We have a few questions. I'll get to it shortly. If you have a question, please pose it as soon as possible. Sometimes there's a delay from the time you press enter to when it appears on my screen. I have 4 questions which has been posed already. How often can I apply for child maintenance increase? How long must I wait until I can apply for a reduction? Interesting question. What do I do if my child does not want to visit the father? Happens often. Who has a larger say over the child's life, the mother or the father? So those are the questions I'll be dealing with. And if there are any other questions, please leave a comment on the Advocate Mohammed Abduroaf Facebook page, and I will deal with that as well. Let's head into it immediately. Okay, the first question. How often can I apply for a child maintenance increase? So let's deal with a scenario. The parties would not come to an agreement regarding child maintenance for whatever reason, and one party approached the maintenance court. The maintenance court obviously had to do an inquiry, and the parties may have agreed to it as well. It happens often whereby parties do not wish to litigate child maintenance issues. They come to an agreement, a sensible agreement, and that specific agreement is made in order of court. That could be the one scenario where the parties approach a maintenance court, or one party approaches a maintenance court, and the maintenance court makes a maintenance order. So that's a date when the maintenance order was made. The other scenario could be whereby the parties where the parties got divorced, and the divorce court, either the magistrate's court or the high court, made a divorce order with a maintenance clause in it. So there's another scenario where a maintenance order has been made. And it happens sometimes where the children's courts make parenting plans in order of court, and inside the parenting plan there's also a maintenance provision. So those are the 3 potential scenarios. Now the maintenance order is made. The question which the questioner posed was, how often can I apply for child maintenance increase? Now, looking at that specific question, there's 2 legs to it. Number 1, the maintenance order was made, the party applied for child maintenance increase sometime thereafter. The question is, when can I apply for it again? Or if you are watching this video, another scenario which I'll be dealing with is how soon after the maintenance court made a maintenance order, an increase or a first order, can you apply for an increase? The long and the short of it is there is no specific date. That's very important to note. The moment there is a change in circumstances, for either you're the applicant, the mother or the father, or in relation to the child, that justifies an application for an increase immediately. I'll give you a practical example. Let's say the child currently attends a school, and the specific school carries on from grade R right through to grade 12. Fine, the child is in that specific school. In grade 7, for argument's sake, something happens, the parties moves out of nowhere, they have to move to a different area, and now the child needs to change schools. School fee is much higher. Although the mother applied for maintenance a month ago, because of this new circumstances that arose, which causes the child to cost much more money, automatically there's a material change in circumstances, and the mother can apply, or the caregiver can apply to the maintenance court for an increase. Now, the maintenance court made an order stipulating that the father should pay more maintenance because there's a change in circumstances. They looked at his income, his expenditure, the mother as well, and the child, and they worked that amount. Okay, father, you need to pay more child maintenance because the child is attending a different school, despite you've been at my doorstep 3 months ago where I dealt with this matter for an increase, but the issue regarding the change in the school was not on the table. Let us say, for argument's sake, going forward, the child attends a new school. For some or other reason, the father loses his job. He no longer can afford to pay the child maintenance. or to pay a certain amount of child maintenance. Immediately then, he can apply to the maintenance court for a deduction. But that is all the second question, which I will be dealing with shortly. And at the same time, should the mother, for argument's sake, under these circumstances, although she applied 3 months ago for an increase, the court granted it to her because the child cost more money. Last month, she applied for another increase because the child changed school. Now, all of a sudden, a month later, COVID-19 kicked in, she lost her job. Then she can apply for another increase in child maintenance. So there is no specific time period. I think you guys figured that out based upon my discourse. Nonetheless, if there is a change in circumstances, you are welcome to approach a maintenance court, and they should be able to assist you. Let us deal with the second question, which I touched on a small bit early on. How long must I wait until I can apply for a deduction? Same principle applies, a reduction or an increase. So usually the deduction would be the person who is paying the child maintenance. If his or her circumstances have changed, even if the circumstances change regarding the other parent, for argument's sake, let us say the father is paying the child maintenance and he is happy with the amount and he can afford to pay the amount, but for some good reason the mother became extremely wealthy. Now the question is, must he still pay half his salary or quarter of his salary toward child maintenance, despite the mother being extremely wealthy, whereby she only spends not even 1% of her salary towards a minor child because she came across a lot of money? Those are material circumstances that causes and allows the father to approach a maintenance court soon and immediately, stipulating there has been a material change. The mother is not providing maintenance according to her means. Her means is much, much more. And also at the same time, it's not fair that I spend a third of my salary toward child maintenance, whereby the mother is extremely wealthy and she's paying much less. So under those circumstances, the father would have a case because there's a change in circumstances regarding the other parent. You will have to deal with the matter based on almost with the same situation. Let's say there is no maintenance order in place and the mother is super wealthy, the father is not so wealthy. Obviously, the court will make a reasonable order stipulating the father should pay a smaller amount. Therefore, when the father applies for deduction based upon the fact that the mother is earning much more money, the court will have to look at this matter again, rework out the mathematics and what is a fair amount. And at the same time, should a child attend a very expensive school during primary school, for argument's sake, till grade 7, a very expensive school, and the father is paying half the school fees, but not directly to the school, a monetary amount, which is a globular figure, which is towards the maintenance of the child's school fees, clothing, food, accommodation, etc. Now the child goes to high school and she gets a bursary, whatever the case may be. The result thereof is that the child's education expenses are extremely low. She must only pay the registration fee and a small monthly fee, and that's it, compared to what they paid previously while the child was in primary school. Under those circumstances, because there is a material change in the mathematics, in the expenditure of the child, that causes a father to make an application to court for a reduction in the globular figure of maintenance which he has to pay. I hope that answered that specific question. So there is no time limit on whether or not you can make an application for an increase or a reduction in child maintenance. Please note, if you have any questions, feel free to leave a comment and I will deal with that. I shall deal with it. The next question deals with child custody. It goes as follows. What do I do if my child does not want to visit the father? Okay, there are two scenarios. Number one would be there is no court order in place, no children's court order in place, no divorce court order in place, which allows or affords the father care and contact rights to the minor child. If there is no such court order in place, that becomes a bit difficult for the father side. But let me deal with the other scenario. The other scenario will obviously be where there is a court order in place, whereby the children's court or the divorce court specifically says that the father should have contact with a minor child every second weekend, half school holidays, birthdays, Father's Days, religious days, and so on. If there is no court order in place and the child does not want to visit the father, that is quite a concerning thing, because The question is, who's sitting in front of me? Is it the mother or the father? If it's a mother sitting in front of me, then I would advise the mother, please go to a professional person, a psychologist, a social worker, to determine why does the child not want to go to the father. Not based upon what the child is telling you. I do not want to go to dad, because whenever I go to dad, dad's other children are there, his stepmother is there, and I don't like them very much. I prefer to be at home playing PlayStation, being online, etc., because there's Wi-Fi and all the good stuff is here. But my dad is no swimming pool, and I prefer being here. Those could be the child's reasons. Are they good reasons? Are they long-term sufficient reasons for a child not to have any contact with her father? Because this is life. People move on with their lives. Or is the reason, no, I do not want to go to dad because whenever I'm a dad, they scold at me, they rude at me, etc. But that's what the child is saying. We need to get a professional person, a psychologist, social worker, to speak to the child and determine why does the child not want to go to the father? Are they cogent reasons? Are they good reasons? Are they the child acting up? Child playing against both parents? Is it silly reasons? That's what needs to be determined. So the expert will have to speak to the minor child, speak to the father, speak to the mother, and try to resolve the issue. What is in the child's best interest? Is it in the child's best interest to stay by the mom, watch TV games, screen time, and have no contact with the father, and 5 years down the line, when the child is older, she moved away from her dad, and they just became, estranged from each other? Is that in the child's best interest? Or would it be in the child's best interest if the father tweaks some of his behavior, the mother tweaks some of her behavior, the child does the same, and they try to resolve this matter? So that's a scenario whereby the parents have no order in place. The expert will hopefully try to assist the parents in trying to resolve this matter. Why does the child not want to go there? That's now where the mother is in front of me. If the expert says, no, mom, I think it's best for the child not to visit the dad because of X, Y, and Z, and this is my report, and then that report needs to be seen to the father, and the father needs to come to terms with that. And hopefully the father will work towards the recommendations in the specific report. If the expert recommends, no, child, you need to go to the dad, there's nothing cogent in what you are saying, you're just being unreasonable, like any child might be under those circumstances, and then the mother should cooperate and work towards the father having contact. If the father is in front of me and he tells me the child does not want to have contact with me, then I would also follow that specific route and stipulating, get a third party on board to investigate, to speak to the minor child and find out what the reasons are. If the child does not, if the expert, who gets on board, states that it's best for the child not have contact, or contact should be limited, or contact should be this or that or that, the father needs to take note of that, and the father needs to work towards fixing things so that contact can be regular and back to normal. If the expert stipulates that the father should have contact and the child is acting out, as I mentioned earlier on, and the mother does not agree to that, then unfortunately the father will have to take this matter to court, and the court will have to determine what is in the minor child's best interest. One step before that could be trying to mediate the matter, but in my view, usually if there's a social worker involved, they speak to the parties, they try to resolve matters that is, in any event, a type of mediation. But nonetheless, each case is different, and the tools available will apply differently to various people. But I always recommend mediation. It must be somewhere in the equation, and also getting a professional on board, an independent professional person on board, to assist the parties in trying to resolve these specific matters. Okay, I have a question, a live question, goes as follows. What if the father dies and he must still pay the maintenance? If the father passes away and the minor child requires maintenance, a claim can be made against the estate of the father. That gets preference over other claims. So if the father passes away and the minor child requires maintenance, you need to speak to the executor of the estate of the father, and a claim should be lodged for maintenance for the minor child from the estate. I hope that assists you, and people need to do that. People need to know that if somebody passes away, you can file a claim for child maintenance against the estate of the deceased party. That was a live question. If anybody else has additional questions, feel free to pose it, and I'll try my best to answer it. I hope I answered that question correctly. And the last question from a previous 3 questions, put it that way. Who has a larger say over the child's life, the mother or the father? Interesting question. And a question which is sometimes difficult to answer in isolation. Sometimes you'd want to have some facts in front of you, a scenario, background information, child with a mom, child with a dad, they broke up, they're divorced, the child is 12 years old, the child lives 10 kilometers from the mom. So those are the data which I would prefer to have in answering these specific questions. But if a party has parental rights and responsibilities over a minor child, then he or she has exactly the same rights and authority and power as other parents. So the mom and dad have equal say in the minor child. I'll make it easy for you. Either parties are married, done, full stop. Both have equal rights regarding the minor child. No one has a greater say. Obviously, as human beings are, and we expect parents to be reasonable. If they have a discussion regarding what school the child should go to, they should be reasonable, and the mother might know better because she's done the research. So the parties needs to come to an agreement the same way as mom and dad who lives in the same home. Let's say they are married, and then are having discussions regarding the child. The father doesn't say, I have a greater say over the child's life. Or the mother says, I'm the mother, I'm the biological mother. I have a greater say over the child's life over you. That doesn't work that way. You guys need to come to an agreement and work together regarding what's in the minor child's best interest. If you cannot come to that agreement, unfortunately, my advice, as I mentioned earlier on, get a professional on board to try to assist you regarding what's best for the minor child. Try to mediate this matter. If the matter is so serious, for example, which school the child should go to next year. And those are complicated matters because how does a judge know? How does a magistrate know? How do I know as a lawyer what school will be best for the minor child? I can presume, for example, if I like soccer, would that mean that school will be better for the minor child? If I do not like tennis, would it mean a school that has tennis is not as good for the minor child? Whatever the case may be. So speak to a professional, get somebody on board, try to mediate this matter. There are various factors applicable, for example, school fees, location, what the child want to become when he or she is older, the child's grades, etc. We are going to with a scenario in isolation. The parties need to discuss these matters because a mother does not have more rights over the child than a father. There can be scenarios where the mother does have rights. For example, if the father was not married to the mother and he made the mother pregnant and went missing, of course the mother has more rights over the child than the father. But if the father was involved in the child's life since birth, automatically he acquires those rights. And he has just as much rights over the child as the father, as the mother, my apologies. However, if there is a dispute and the parties cannot come to an agreement regarding what is in the child's best interest, the matter will unfortunately have to go to court, and the court will ultimately have to determine what is in the minor child's best interest. Okay, that deals with those 4 questions I have and the live question which was posed. If there are not any additional questions, I will take it as this video should come to an end. And I'll thank you for your time. I hope you have a lovely week ahead and hope to see you online soon. Thank you very much. Good morning. Welcome again to our webinar. Today's topic, a follow-up from yesterday's topic. We had many questions yesterday, and after the webinar we had some more questions which I had a look at but I could not answer, and hopefully we can elaborate upon that again. If you have any live questions as we had yesterday, feel free to pose it, and obviously I'll try my best to answer it for you. You have to post it on the Advocate Mohammed Abduroaf Facebook page. If you post it on any other page, I'll see it later on, but obviously I would not be able to answer it and engage with you with regard to that. Nonetheless, today's theme would be a bit different. I'll focus on the issue concerning child custody, child maintenance and divorce, but from a different angle, dealing with third parties, non-parents. I can't deal necessarily with that in relation to divorce. However, I can deal with that regarding child custody. For example, can an uncle have child custody, an aunt, a grandmother, stuff like that. Child maintenance. May you claim maintenance from grandparents, from uncles and aunts, and so on. So that will be the angle from where we will deal with that. And with regard to divorce, a different angle would be, what do you do if you cannot find the spouse to get divorced? You guys are married, however, separated. Your spouse went missing, and now you want to get divorced. So it's a bit of a different flavor regarding that. If you want more information regarding this topic, please watch our video of yesterday. If you are watching it from Facebook, it should be on all our pages. If you are watching it from YouTube, it should be the previous video that would have been posted just before this one. Nonetheless, let us begin with this interesting topic, and I'll be keeping an eye on the Facebook page for any questions that you may have and which you would like me to answer live. And that's the only way I can answer them. On the issue concerning child custody, now in South African law, only mothers and fathers can have parental rights and responsibilities by default. When a child is born, grandmother has no rights, grandfather has no rights, aunt and uncle have no rights to the minor child. If the parents decides to move overseas or move away or not allow any of the parents or siblings or their siblings to have any contact with the minor child, that is it. Unfortunately, you as uncles, aunts, grandparents have no default rights to a minor child. And the same way, by default, you have no responsibility towards that child, for example, paying child maintenance and so on. There might be a social responsibility, a cultural or religious responsibility, but from South African legal perspective, there is no obligation. The parents are responsible for that. That's a default situation. That's the point of reference. However, when dealing with matters concerning children, in child custody matters, we focus on what is in the minor child's best interest all the time. If a third party, let's say an aunt, cares for a minor child, and the parents are unable to care for the minor child, and the aunt looks after the minor child, rears the minor child, and now a few years later, the parents clean up the act and they decide, oh, no, we're taking the child back and we're continuing caring for the minor child. That is good and well. I'm happy for that. However, now the parents decide, we had a bit of a fallout with the aunt. The aunt still keeps telling us how to care for these minor kids because she looked after them for 5 years. And we're cutting ourselves from this aunt, or from my sister or the child's aunt. What happens then? Must the aunt accept it? If the aunt wants to accept that situation, that is fine. Nothing will happen after that. Or the aunt can say, you know what, I think I want to remain in the minor children's lives, continue forming part of their lives. And if the aunt makes such a decision, the aunt can approach the court. And the court can apply its mind to the situation. And if the court believes it will be in the minor child's best interest for this aunt, this third party, to acquire parental rights and responsibilities over the child, for example, have rights to have contact with the child on a regular basis, whereby the minor child might overnight by the aunt's home every second weekend, meaning the parents would not have any actual physical contact with the minor child for those 4 days in the month, every second weekend. Then the court will make such an order because it would be in the minor child's best interest. And under these facts and circumstances, if the aunt cared for the minor child for 4 or 5 years, the minor child at some point believed the aunt was her mother or their mother or his mother, and the minor child misses his aunt and wants to see this aunt because the parents were missing. The child now knows, okay, this is my mom and dad, but you were not my mom and dad for the last 4 years. You can approach the court, and the court can apply its mind to the matter, listening to what the father has to say, the biological father, biological mother, listening to what the aunt has to say. Maybe there's an expert on board, the school teacher, family advocate's office, psychologist, counselor. See what all they have to say. And if it concludes that it is in the minor child's best interest for the third party and aunt to acquire parental rights, the court will make such an order. These third parties could be anyone. Could be a grandmother, a grandfather, could possibly be a very older sibling, that's also possible, or totally third parties, people that just cared for the minor child. That is not a problem. Obviously, the court will look at all the circumstances and all the facts. I do not, for one, believe that if a minor child was cared for by certain persons for quite a long period of time, and now the parents decide to take back the minor child, that it would be in a minor child's best interest not to have any contact with those specific persons. That would not be in a minor child's best interest. In my view, if all else is equal, obviously, I can think of a scenario, which is my job, where it will not be in a minor child's best interest. But generally, should it be a normal situation, it would be in the minor child's best interest for this third party to have care and contact to the minor child. So that's a spin where I'm dealing with child custody from a different angle. We focus on what is a minor child's best interest. Regarding child maintenance, we have discussed in our previous video yesterday how child maintenance is calculated. We dealt with a few scenarios, etc. But let's take it from a different spin. Let's say, for argument's sake, the parents themselves cannot afford to pay the child maintenance or to maintain the child financially. Let's say the mother earns a small amount of money and the child lives with the mom. The father, unfortunately, cannot be found, or the father cannot afford. He's a student or he's working, but he's earning very little money. But the child requires a lot of money. Not a lot, but more than what the parents can afford. The mother's parents, they are around, but they are pensioners and they also have limited monies. But the father's parents are quite wealthy. They have money. And they can afford to maintain this minor child because the father cannot maintain the minor child at all. Under those circumstances, it is possible to approach the maintenance courts, and the courts would look at all the circumstances, all the facts of the matter, calling the parents, the paternal grandparents, maybe calling the maternal grandparents as well, to verify that they cannot afford to also contribute. And the court would make a fair decision, and the court may order that the paternal grandparents of the child, despite the parents not having been married to each other, that the paternal grandparents should maintain the minor child, should pay some form of maintenance in order for the minor child to be able to live. For example, the child was fine, the child was quite young, and the mother could survive with her money to care for the child, but now the child has to go to daycare, or the minor child has to go to creche, or aftercare, whatever the case may be, or to school. And those are quite expensive. Child requires school clothing, etc. And now the mother requires more money. Father cannot afford it. His parents can afford it. If her parents can afford it, wonderful. She can approach the court to enforce them as well. But generally, the mother's parents would give their contribution, whatever it may be. So that's a one spin on child maintenance. The other spin, or the other issue that may arise, is that one parent, or at least a parent who has to pay child maintenance, no longer lives in South Africa, lives overseas, lives abroad. And now you would like to claim maintenance from that specific parent. Obviously, our courts have only jurisdiction over people living within the area of the jurisdiction, basically South Africa, or the Magistrates Court jurisdiction, or the High Court's jurisdiction, and so on. For example, the High Court in Cape Town would have it over the Western Cape. The Magistrates Court in Cape Town would have it over the Cape Town area, and so on. Johannesburg, KwaZulu-Natal, etc. That same principle applies. But a judge in Cape Town cannot direct an officer in the United States, officer, do this, force other party to pay maintenance, and so on. That's not how it works. We do not have power over other countries. And the same way, they do not have power over our citizens. There are, however, international agreements, treaties that have been signed between countries to sort out these issues. One would be, for example, the Hague Convention on Child Abductions. That's not a full term, it's quite a long term. But nonetheless, if one parent removes the child from South Africa, takes the child to a different country, to consider the other parent, that's seen as child abduction, and we can apply international legal principles, and following certain diplomatic channels, the minor child could have to be returned to South Africa. So we work with the governments are working together regarding that. But nonetheless, we're discussing child maintenance. There is an act called, a piece of legislation called the Reciprocal Enforcement of Maintenance Orders Act, South African piece of legislation dealing with the reciprocal enforcement, meaning reciprocal. South Africa has an agreement with America, for argument's sake, and they will assist each other in enforcing whatever maintenance orders that are in place in the Pacific countries. I am seeing certain questions. Thank you very much for that, and I will deal with that shortly after I've explained the scenario. So we have an agreement with the United States, certain states in the United States, South Africa has an agreement with them, whereby if the person who has to pay maintenance lives in the United States, a complaint will be made locally in South Africa, in a South African maintenance court. You will outline that you are the parent, the child is living with you, these are your expenditure, this is the father, he lives overseas, in my example here. And there'll be an inquiry, and the court in South Africa will come to a determination, okay, under these circumstances, the child costs X amount of money, and the mother can afford so much, and we think a reasonable amount of maintenance would be X. They would send that documentation via diplomatic channels to the state in America, to their Pacific maintenance court, whatever they have that side, and that maintenance court will get hold of the father, call him in, and then do an inquiry that side. And they would come to an amount, and that specific amount would be made an order of court in the United States, and obviously that details will be sent down to South Africa via diplomatic channels. So the opposite also applies. If a person who has to pay maintenance lives in South Africa, the authorities in the United States will send that specific order be made, that side, a provision order to South Africa. We will call in the other party, look in the matter, come to a decision, and obviously make an order and send the order down to the United States. So that is typical enforcement of the maintenance orders. So that's something interesting where that is concerned. We have some questions. Wonderful. Let us deal with that. We copy it in quickly. This will be question live. Question 1. Thank you for that. That's the first question. I see there's a follow-up on that specific question. Same person. Let us deal with that. Let me copy that in as well. Okay, so I will definitely deal with that question. Thank you for that. But before I deal with the question, let me just finish the topic on child custody, child maintenance, and divorce. So the next theme from a different spin would be divorce. As I mentioned earlier on, please watch yesterday's video, some more details regarding this topic. Let us say the parties, they are married, and one party cannot be found, but the party remaining in South Africa wants to get divorced, or he knows where the other party is, but unfortunately cannot serve the documentation on them. So remember, this is how South African law works. In order for a divorce to take place, divorce documentation needs to be served on the other party, and in South Africa. If you want documentation to be served upon the other party in a different country, we do not have sheriffs there. So we have a sheriff in South Africa, South African Board of Sheriffs, a member of them, and he knows his job. He knows how South African law works, and he knows how to serve summonses and documentation upon the other party. The United States, the UK, China, Finland, New Zealand, Australia, they have their own processes applicable over there. So we do not direct sheriffs that side to serve documentation. However, the parties want to get divorced. Under certain circumstances, if you cannot get hold of the party, or you know the party is overseas, let us deal with the overseas part. You approach your court locally and advise the court. I've issued divorce summons, but the other party lives in the United States. I only have an email address where this party is concerned. I do not have anything else, but the email address works. Can this documentation be served upon him via email? You will explain that to the court, and the court will say, you know what? I think this is the only way you can proceed with this matter. I hereby give you leave to serve the summons upon the other party via email. And you get the order, the attorney would obviously email the other party the summons, for scanning the summons, the email to the other party. And if the other party does nothing within 10 days, obviously the divorce can proceed on an unopposed basis. And should it proceed on an unopposed basis, the judge will look at the file. The judge will say, I don't see a return of service, but I see, okay, there's an order that was granted previously stipulating that the summons can be served upon the other party by email. Or I see an affidavit here from an attorney stipulating that the summons was served upon the other party by email. The judge will be happy, and at least that requirement would have been met. The court would be convinced that you informed the other party about the divorce. If the other party knows nothing about the matter, too bad. Wonderful, life goes on. But if the other party decides to oppose the matter, it proceeds as any opposed divorce matter. Okay, that was that was the 3 topics: child maintenance, child custody, and divorce. I have another question. Let me deal with that quickly. Copy and paste it. And that's it. If there are any other questions, I would like to deal with that as well. Question number 1. Can in-laws, the grandparents or aunt, force themselves to minor children that does not know them at all? Will the emotional not be in the best interest? Okay, I get the gist of the question. No, they cannot. They have no parental rights at all, so they cannot do that. It's your job as a parent to protect the child from any third parties. You know, obviously, as families, certain issues involved, complications involved, and so on. But in principle, they have no right. And for me to be blunt, if they are consistently imposing themselves, you can approach the court and get a protection order against them. Obviously, you would try to avoid all of that. I only have 2 lines of question here. I'm giving you a general answer. Try to mediate, try to resolve these issues. But if someone persists, because a person does not have a right to the minor children, you can approach the domestic violence court and get a protection order against them. But ultimately, my answer is no, they do not have a right. Let's deal with the second question. Question number 2, live question. Can a judge grant a divorce if the other party does not want to sign the paperwork? There is no obligation upon the other party to sign the paperwork. The paperwork is what you want. So let's say you want to have custody and the other party wants to have custody. So there's no obligation upon him to agree to that. Ultimately, the court would have to make a decision here, evidence. So if a divorce wants to be resolved quickly, you get the party to sign documentation, so the divorce is resolved, and there's no need for us to run a full-blown trial, call witnesses, and put people on the witness stand and argue at the end of the court case. That's not necessary because the divorce has been resolved. If the divorce has not been resolved, they're not willing to sign any documentation or to agree upon anything, fine. The matter must just proceed as normal. The same way, for example, can a criminal charge, if you're somebody charging you for theft, can that go ahead without you admitting to guilt? Yes. You say you're innocent and the proceedings must go ahead. The same way with a divorce. The party says, I'm not willing to sign it. Perfectly fine. You follow the proceedings, discovery, providing whatever documentation the other party wants. Make sure the matter is still ready. Get a date for the judge. Go on the witness stand. Prove your case. The other party will do exactly the same. At the end of the day, the court will make a decision. So regarding your question, yes, you can proceed. It will obviously take a bit longer as the case, should the parties come to an agreement regarding the divorce. I think that is it for today. I see no other questions that are being posed. There's no one else that has any live questions. Thank you very much for your questions and for your time for watching this video. And I hope to see you online again soon. Have a lovely day. Good morning, everyone. Once again to our live webinar on Facebook Live, dealing with Q&A on child maintenance and child custody by myself, Advocate Mohammed Abduroaf. I'm a practicing advocate in Cape Town. I specialize generally in family law matters. I do other legal matters as well, as I'm called upon to do, but on family law matters, I'm quite au fait. I've been practicing it for over 15 years, and every day I learn more things. That's why it's a legal practice and not a legal perfect. Every day you're practicing the law. If you have any questions on child custody and child maintenance, feel free to pose it, but it needs to be on the Advocate Mohammed Abduroaf Facebook page, as you can see above. That's the page where you have to leave a comment, and I will answer it. I see we have one question. Let me just get to it. Let us do this. Copy it. This is question number 1. Thank you for that. If question number 1 and any other question is succeeding question number 1, want to add anything, just mention question number 1 or mention number 1 and your additional comment. It gets a bit messy on the Facebook Live page. Okay, the question is as follows, and you can all see it on your screen. I applied for maintenance against the father, and I suspect he has taken retrenchment after we served him the papers. I can't claim for future maintenance. What can I do? It's a challenging answer because do you want me to be creative here and take the presumption that he will not pay child maintenance, and we need to now attach his pension fund, his pension payout. Or if you have a concern that he will not pay, then it could possibly mean that you'd like to get a lump sum held somewhere. But that hasn't been confirmed yet. And the court did not decide on what amount of maintenance is reasonable. Is your claim reasonable? Should you be claiming more? Should you be claiming less? What can you afford? You might have obtained a retrenchment payout or will be receiving a retrenchment payout. What is that amount? Is it a huge amount of money? Is it required for his specific living needs? He worked for that, he worked and he paid money every month into a retrenchment or retirement fund. I'm just being general here. And now he needs to be paid out and he needs to use that money to look after himself. If he complies with his maintenance obligations and he pays whatever needs to be paid, then he can do whatever he wants to do with that money. It's his money. And that's my policy always, that as long as you pay your child support, your reasonable child support, what the children requires and what you can afford and in terms of your means and so on, considering all factors, the other parties, the primary caregiver's income expenditure as well, you can live the most lavish life you want to because you have complied with your obligations. I would presume the same applies to tax. If you pay your tax, you can do whatever you want to do with the balance of your money. The same with child maintenance. Pay it and that's fine. So in answering your question, the court first needs to determine whether or not there's a claim for there's a competent claim for child maintenance, in the sense of, is the amount that you're requiring or you're claiming from the other party, is it a reasonable amount of money, and is it an amount allowed in law? When I say an amount allowed in law, I mean based upon your income, your expenditure, the father's income and his expenditure, his future income. He might be cashing in on a retrenchment package, but at the same time, he might be working elsewhere as well. Or furthermore, he might have other assets. So the long and short of it is, please finalize the maintenance matter as soon as possible. Speak to the maintenance court about the retrenchment package. Mention that he is obtaining it. Maybe the maintenance court can obtain relevant information regarding that. So you have relevant data regarding the specific retrenchment payout. And after you obtain all that information and the maintenance order has been made, and he does not pay maintenance, then you can start looking around and say, no, we now want to start attaching the specific money that he has in his bank account, wherever it is. But I think your claim might be a bit premature now, because you made a maintenance claim against the father. He is not in violation of any order, and there's no reason to believe that he will not be paying maintenance in the future. If he does do that, he's committing a criminal offense, and then you can proceed with a different claim, either garnish your order, attachment of an amount of money, whatever the case may be. So then you'll be in a better position to deal with that. I hope I answered the question. You are questioner number 1. You are welcome to pose any additional questions upon that. I have question number 2. Let me copy and paste that into the screen. As I mentioned earlier on, if you have any, if you're watching this video, please feel free to say where you're from, where you're watching this video from. It's always nice to know that. So this will be mark number 2, and I'll delete the spot. I call this a whiteboard. I don't know if that's an appropriate term to use. Let's deal with this. Which act explains exactly how subpoena has to be served on a person? Please can you state the act? It's a bit difficult because then you will have the the regulations, civil procedure that would apply, the Magistrates Court Act, the Magistrates Court's rules. Then if it's a High Court, the High Court Act, the High Court rules. And then if it's in terms of maybe the maintenance laws, the Maintenance Act might have certain regulations applicable or not. So it depends on those things, but I think that will be a bit premature for me to discuss that,
the best I would say is determine that you want to obtain a subpoena. You approach the relevant court and advise the court you want to obtain a subpoena, and the court should be able to assist you with obtaining a subpoena for whatever reasons is required. The court issues a subpoena in any event. If it's a magistrate's court matter, look at the Magistrates Court Act and the rules of the Magistrates Court. I would advise you to do that. If it's a High Court matter, look at the High Court rules and the Supreme Court Act, if I'm correct. Let's move on. An additional question two. I'll just do this. What are the specific processes that has to be followed? Can I collect a subpoena from the court, take it to the police station, and ask the police officer to serve the accused? So an accused is a criminal matter. So you don't subpoena a criminal, an alleged criminal. The person gets, if the person must be subpoenaed, it will be subpoenaed by the police officer, by the criminal process. So I do not understand, are we referring it to a maintenance matter? Possibly, I do not know. Or am I allowed to do this? Is there a specific process? As a commander of the police station was trying to convince me there is another way. Only the court can send it to the police station. I disagree, as I have personal experience of this. Thank you. I do not feel this falls under the category of child custody and child maintenance, and it's a procedural aspect. The best thing I would advise you to do is have a look at the law, speak to an attorney, say you want to obtain his services. Can he serve the specific subpoena on other party? I do not know what type of subpoena it is. It is for non-compliance with maintenance order, it's a maintenance application subpoena, criminal, civil. So those are all different specific scenarios that would apply. I hope you good luck with the specific issue you have, but it doesn't really fall under the topic of today's discussion, being child maintenance and child custody issues, not necessarily civil procedure or criminal procedure, and how to bring someone to court. That would be the court's job, or alternatively an attorney, but it's a different topic. I hope that assists you, and I'm sorry I could not be of any additional assistance regarding that. Okay, I think we have question number 3. Let us copy that one quickly. Question number 2, if you have any additional comments that you're welcome to mention it, and I'll paste it and I'll answer it. You know, my answer might be the same, it might be different, depending upon the facts. Question number 3 asks the following: what does it cost to get equal custody and time with my son? I would presume you're referring to financial cost in legal fees. So it can be free, because if you approach if you approach a children's court, you can represent yourself. It can be further free if you approach the High Court. You represent yourself, there will be no cost applicable. If you want to appoint a legal representative, I cannot thumb suck here how much it will cost. It depends on various factors: the lawyer's hourly rate, how much time he has to spend on your case, time drafting, court appearances, and so on. Is the matter opposed? If the matter is opposed, meaning the other side wants to fight against you, then the cost can be for anything from here till there. How much petrol does the party want to throw into the car? So for every strike the other party makes, you need to defend and counterpunch, for lack of a better way of stating it. So I cannot say how much it will cost, but I do know some matters are done very speedily. Unopposed matters are quite simpler than opposed matters. Unopposed meaning the other party is not opposing the relief sought, and the court will also have to determine the case based upon what you are saying and what's best for the child based upon what you are saying. I do not want to guess. High Court, Magistrates Court, I do not want to put any figures out there. It will just be a guess, and the guy sitting next to me can be non-lawyer. His guess will be just as good as my guess. But if the matter is unopposed, it will be reasonable. You can fix the amount more or less. It's an application either in the High Court or in the Magistrates Court. If the matter is opposed, the fees can just spiral. Postponement after postponement possible, or it can be done very simplistically, depending upon the court, depending upon the judge, depending upon the facts. I hope that answers question number 3. I see question number 2 posed another question or comment, sorry. Let us, for the sake of fairness for everyone, I would like to do justice to all my questioners.
I do not want you to think that I don't deal with you. Yes, it's a maintenance matter. So I presume it's a criminal complaint for non-compliance with the maintenance order. It's not your job to serve the subpoena, and I don't think you should. You can serve the subpoena. A police officer should serve the subpoena under these circumstances. I honestly do not believe that you can do that under these circumstances. It sounds like a criminal matter referring to an accused, and it's not the complainant's job to serve it. And the final comment would be no problem and thank you. You are welcome. Any additional comments? If I'm incorrect, if it's a civil matter, an application for maintenance order, or subpoenaing the party, or calling the party to court for an application for reduction or an increase, let us know and we will deal with that. Yeah, question number 1 had an additional comment. Let me copy that in quickly. Let us get that into the system. Question number 1, that's him. Or her. I went to court and they said I must return on my court date on 22nd of March. So I suspect he will finish the money. He only has 2 years of service in the company. So I would advise you under those circumstances that you need to maybe approach a maintenance court and tell them your dilemma. It does not mean he will not pay maintenance afterwards. If there is that apprehension and you presume he will not be paying maintenance, then obviously you need to act upon it. I do not know the amount of money you're talking to. He only worked here for 2 years, so I presume that the maintenance amount won't be, the retrenchment amount won't be that huge. Also depends upon how much the person is earning. So it's a difficult situation to deal with because you are making the claim, the allegation that you know you will not pay maintenance and therefore need to attach this retrenchment amount because you are afraid that he will not pay the maintenance afterwards. But you have not determined whether or not there is a justified claim in the amount. And we haven't determined based upon whether or not what your portion of maintenance should be and what the other person's portion of maintenance should be. Sometimes it's hard to give these webinars because you're talking to a screen, you're not seeing anyone. I think we're going to upgrade these webinars where we are allowing people to join us via voice as well, and we can incorporate that into our video. So you can call in via WhatsApp, we will get the sound into the system, and everybody would be able to hear that. And maybe going one step further, we can have those people who want to engage with us via video, we can stream them in via Zoom as well, and we can put them onto the screen. But for that, I might require some additional assistance. I hope it answers question number 1's answer. You need to get the maintenance matter done as soon as possible, and alternatively, or what you could possibly do now is go to the maintenance court and mention to them your concerns. Here's another question, question number 4. We copy it in. Therefore, if question number 1, 2, or 3 has any additional comments, you're welcome to pose it. Just mention question number 1, 2, or 3. Question number 4, comment is the following. If I have lost contact with the father of my child and we have had a maintenance order in place, I want to go to the maintenance court as soon as possible. There's no time lapse for that. And lay a complaint against him. More than likely, they'll follow the criminal route and they will subpoena him to the criminal court, and more than likely, he will start paying or come to some type of an agreement, some type of an arrangement. The civil route would obviously be that they can start attaching his property, but I would actually advise you, start the process. He owes you the money and he has to pay it. First step, go to the maintenance court and they should be able to assist you. And they will assist you. The very bare minimum they should do is find out where this person is, subpoena him to court, and start the process. I hope that answers your question. You can still do something. And my advice to you is, whatever has questions, feel free to pose it and I'll try my best to answer it. Please remember, if you're watching this video, the Advocate Mohammed Abduroaf Facebook page. Just above there says post questions on Advocate Mohammed Abduroaf. Type that into Facebook and you should get a page, and if while this video is streaming, this video will appear on that specific page. We're also now allowing or making it possible for you to pose your questions before the time. If you are not available at the next
webinar. I unfortunately cannot stipulate what time it will be with this COVID-19 and judges and courts having different ways of operating. You must wait for your phone call. You only find out in the morning whether or not it will be virtually done or via in person. It's a bit challenging, but I try to do these webinars at about between 9 and 10 o'clock. And yesterday's webinar was the afternoon because I was in court the entire morning. But however, that's how it goes, and we'll try our best. But if you have a question and you're not available to watch these webinars, or you do not know what time it will be, you're welcome to message us that question on the Advocate Mohammed Abduroaf Facebook page. Message, say, question for the next webinar. You must mention that. Question for the next webinar. Otherwise, I wouldn't know, is it a question, a general question, or is it a question for the webinar? So mention question for the next webinar. These are the facts. And at the next webinar, I will pre-post it onto the whiteboard so we can start dealing with that immediately. Then when you come back from work or wherever you are, or you have free time, watch the video and I should have dealt with that specific question. I have another comment. Oh, the questioner says, thanks, you are welcome. The last question, question number 4. You're welcome, and I hope that answers your, we did answer your specific question. If there are any additional questions, feel free to pose it. Otherwise, I think that's our webinar for today. 20 minutes of live streaming. If there aren't any, I thank you for your time, for watching this webinar, and I will see you online tomorrow morning again. It will be in the morning, most probably between 9 and 10 sometime. But if you have any questions before the time, please feel free to post it. Have a lovely day, and I'll see you online soon. Thank you very much. Good morning. Welcome to our live webinar streaming on Facebook Live. I hope you all are well. You had a lovely start to the week. It is May. We had a public holiday on a Saturday. Doesn't help many people. Some people are really not working, but those of you who have been working on Saturday, I trust that you were paid double for working on a public holiday. Unfortunately, I think I also worked on Saturday. I thought I got paid double, but that's fine. That's the job of a lawyer, to do his work and make sure his client is happy with the results. Nonetheless, our topic today, care, contact, and guardianship rights. Is there a gender preference? Before I start with that topic, I'll give people a few moments to join us and to have the opportunity to interact if you want to. You may interact via the Advocate Mohammed Abduroaf Facebook page. It's above there. Or you can send us a message later after you watch this video. And tomorrow or Thursday, when I do my next webinar, I will refer to those specific questions and deal with them later. And I shall also leave a comment or a reply to your comment stipulating what time I will be doing my next webinar dealing with your specific question. Nonetheless, we are live now, and let us get the wheels moving. Care, contact, and guardianship rights. Is there a gender preference? What do I mean by that? Does the law prefer having a situation where the mother is a primary caregiver of the minor child as opposed to the father? Is there a stereotype that believes that mothers are better caregivers overall throughout the minor child's life than fathers? Is there a preference that fathers are better caregivers for boys as opposed to girls, and vice versa? That's what we are dealing with today, the preference. The reason why I chose this topic is because many people, especially men, they come to me for assistance with the view that they are only entitled to certain care and contact rights. For example, that they are only entitled to have contact
on every second weekend, and maybe midweek contact and half school holidays. They come to me with a predisposed view and understanding that the law will never consider the possibility of them being primary caregivers. And that's not how the law works, and I will be doing them a disfavor, and to all my viewers, a disfavor if I promote that specific understanding and view. What the law looks at is what is best for the minor children, despite gender. We all know that mothers work just as hard as fathers. They have jobs, full-time jobs. Fathers have full-time jobs. In a domestic relationship or situation, either by marriage or partnership, whatever the case may be, mothers and fathers go to work. The child wakes up. Both parties may, depending upon the facts, assist the minor child in getting dressed, feeding the minor child, whatever needs to be done to get the minor child to start the day. The father might be the one that takes the minor child to school, and the mother may be the one that collects the minor child. Should the minor child fall ill, depending upon how the schedule is the next day, if the father has an easy day the next day, then under those circumstances, the father will take care of the minor child the night before. If the father has a busy day, or he had a busy day and the minor child is ill, then the mother will take care of the minor child, and so on. So there's an equal caring of the minor child. Now, dealing with that specific scenario, should those specific parties separate or divorce, they need to now determine what should happen to the minor child. How should care and contact arrangements be implemented? Is there automatically a default scenario situation that the minor children should now be living with the mother? The father will be moving out. The child should remain with the mother. Well, the mother is leaving the matrimonial home or the family home, and the kids must go with the mom, despite it always having been that both parties cared for the minor child during the relationship. Now, unless you want to apply the stereotype or the common example, not the common example, the common view, that if a child falls ill, it's only the mother that can care for the child. If the child requires something, the mother must do everything. The job is for the father to go to work, earn a salary, and the mother stays at home and she looks after the kids, looks after the home, make sure the home is clean, food is cooked, and so on. That could have been the old stereotype, how things used to work in the past. It still applies to some certain households still. Many households follow that specific scenario. There's nothing wrong with it at all. Where the mother remains at home and she cares for the kids. She irons the father's shirts, makes sure that everything is done. So when the father comes home, he can eat and she will continue looking after the kids. Now, under those circumstances, it would make logical sense for the minor child to remain with the mother should the parties separate. And I will be honest with you, that makes sense. It makes logical sense. It won't make sense for the father under those circumstances, especially if he never really cared for the minor kids. On weekends, he spent time with the minor children. They went out to the beach together as a family and so on. However, when it comes to the caring of the minor child, when a child requires assistance with homework, who taught the child how to potty, to use a toilet? Who taught the child how to do things that a child requires somebody to assist him consistently with? Obviously, the mom, not the dad. The dad was at work. He was earning a living. He was working for the family, and that's admirable. It's good. However, under those circumstances, it makes sense to follow the stereotype and stipulating. Under these circumstances, the minor child would be best cared for if the minor child remains with the mother. However, if the facts are different, if the facts are that the father cared for the minor child just as much as the mother, maybe, but less is possible, depending upon the circumstances. But now they're separated and a decision has to be made. The question is, how should they continue parenting the minor children post-separation? Should it be 50-50, which I have no problem with if it's workable, where the minor child will remain with one parent for 1 week, or 5 days, or 2 days, or 1 day, depending upon the facts, depending upon the circumstances. If both parents live opposite the minor child's school, so the minor child knows, tonight I wake up in my mom's home, I'll go to school, and on my way back, I'll be going to dad. Mom knows that the child won't be coming to her, so she can do whatever she needs to do. The next morning, child wakes up, and he goes to school, and he comes back home to mom. That's fine, it works, it's workable. I am not a judge of families. I never were, I never was, and I do not intend to be one in stipulating what would be the ideal family situation for you. But if you ask me my professional opinion, my professional answer will be what is workable. Is 1 day on, 1 day off workable? I can see problems, but if it's workable, it's workable, and that's wonderful. Is a 5 day on, a 5 day off workable? 1 week on, 1 week off workable? 1 week, 2 weeks, 2 weeks, 1 month, 1 month. If it's workable, wonderful, and it will be a happy family. That's very important. I can come with a perfect parenting plan, spend time drafting it, well drafted, good English, good grammar, if this, if that, if this, if that. That applies, well drafted, admirable. However, if it is not workable for the specific family, it's useless. It's a useless piece of paper. It is causing more problems for the family. However, if the parenting plan specifically states that the father can only see the child every second weekend for 1 hour, it's workable. And that's what the people want. The father travels all the time. He lives in Johannesburg. It's a fly down once a month. It's workable and understandable, and that will be the ideal parenting plan. Great. We have some questions on the screen. It's all pre-created, and I typed it out and I pasted it onto the screen for the purposes of getting some context. Let us deal with the first question. I am the mother of my child. Does the father have a right to have primary care over my child? Now, I won't give a yes or no answer because the person is asking me a subjective question, not a hypothetical question applying to the general laws. Subjective question to her, I would have to ask the mother quite a few questions. Firstly, how was care and contact exercised whilst the parties were separated initially? If they have only now recently separated, I'll ask questions, for example, who cared for the minor child predominantly during your relationship, your marriage, whatever the case may be. I'll ask the specific questions. If the child fell ill, who cared for the minor child? Who done this, who done that? I need to understand what are the dynamics applicable here. If the father was actively involved in the minor child's life, just as much as the mother, the dynamics are different than a situation where the father worked very hard to feed the family, to care for the family. However, the question is, post the separation, can the father also care for this minor child just as well as the mother can? Things have changed. We have to relook the matter. So my answer to my client, the mother in this circumstances, would be, it depends a lot on the history, on the past, and the capabilities of the parents. A lot of things can also happen. A mother can have a nervous breakdown. She can fall ill chronically, which can affect her capability for caring for the minor children. That could happen in a given scenario. I need to know all these specific information before I can give my opinion. It's only my opinion as to what is practical and workable under the circumstances and whether or not there's a prima facie, a first glance, it is a case. Obviously, if the mother tells me, no, the father is the one that cared for the minor child all the time. I'm the one that worked. I'm a jet setter. I'm a CEO of a company. I never did anything to the minor children. He taught him to ride bicycle. He taught him how to fasten their shoelaces. He's the one that potty trained them. He's the one that does all their homework, and so on. They are getting good grades because of him. He's the one that takes them to school and brings them back. He works himself, and he works online, and his clients are in the States, so he works at night, etc. But I'm the mom. I'm the biological mother. I give birth to these kids. Surely the mother will say, should I not have the kids now and the father can have visitation rights? The logic is tainted. Under those circumstances, it will make logical sense and legal sense for the minor children to be placed in the care of the father, and he can continue doing what he does. And the mother can obviously have contact every second weekend, etc. Weekend contact is very important, but during the weekends, there is schoolwork, homework, routine. Unfortunately, the routine will get spoiled a bit because there's not two households. But that's the reality of people breaking up, divorcing, separating, etc. I hope that answers that fictional client's question, and let's get to the next question. Do fathers have a right to have sleepover contact if the child is still young? Very interesting question. One that gets posed to me quite often. And answering it will obviously assist if we apply the question or the comments I made early on regarding question 1. Obviously, if a child gets born, is born, comes out of the mother's tummy, the child is breastfed, it makes logical sense. The child must be with the mom. I support that view fully. I do not think a father can care for a newborn child unless there are other issues, complications, the mother is unable to care for the child, etc. But the normal circumstances, the mother can be the top CEO, the most busiest person on earth, but when she gives birth, she won't be working. She'll be dealing with a child. And it makes logical sense, in my view, for the mother to care for the child, unless there are other circumstances, other facts that will persuade me otherwise. But now the child is older. The child is off the breast. The child is now eating solids. The child can, does not require someone to care for the child the entire night. The child sleeps for 4 hours on one, 6 hours on one, whatever the case may be. I do not want to specifically stipulate an age. Each case is different, each family is different. But the child is self-sufficient to a certain extent. Then the question will be, can the child be the care of the father? And can the father care for the minor child, despite the minor child being very young, on diapers still? Can the father care for the child during the evenings? Now, how do I deal with such a question? It's a factual thing. Is he capable of doing so? Does he have the insight? Does he have the knowledge on how to care for the minor child? Has he experienced contact during the day? I do not believe in that the father never ever had overnight contact, therefore he should never ever have future overnight contact. We need to start phasing things in. Give the father an opportunity to develop that skill, and that skill will obviously get developed should he spend time with the minor child during the day alone. The child will take a nap during the day. The challenge will obviously be now if the child should overnight by the dad the entire evening. Yes, it's possible that child might be missing the mom and be apprehensive and say, where's my mom? I'm not used to this bedroom. But wean it in. Let the child during the day sleep in that bed or wherever the child will be sleeping in. Keep the child a bit longer there. Maybe till later the evening, mother can collect the child. So the child can fall asleep at the dad's place, but wake up again and go back to the mom. So you create a phased-in approach, which is very important. So my answer to question 2 is, yes, it's possible for a father to have overnight contact if the child is at a young age. It's possible. Depends upon circumstances and other the facts of the matter. If the father is someone that's tired during the evening, has to work early the next morning, and he's making that request based upon wanting to show the mother thing or two, but the child won't be looked after very well, that's a different scenario, because then a very young child might not be the ideal candidate to have overnight contact by the secondary caregiver if the child is too young. If the child is a bit older, I'm going to mention age just before going to grade R. Child sleeps right through the evening, child is quite big, mother and the child can have a WhatsApp video or call the evening before the poor child falls asleep, etc. No, that's a different scenario. Then the facts changes a bit. The father can be extremely busy at work, but the child overnight there, they spend some time together, the child falls asleep, has breakfast with the child, tells the child at school, and that's it. So those are the scenarios which you have to look at. My guess will be just as good as your guess, but it all depends upon the facts of the matter. That is question number 2. Question number 3. My son wants to stay with me permanently. I'm the father. The mother does not agree. What can I do? Very important considerations that needs to be applied. Father wants to have primary care over the minor child. The mother does not want that to happen. We have to look at all the factors. Of course, the age of the child, the history, how often the child had contact by the dad, how often has a child had contact for half the school holidays, etc. Are we there? Are we far from that? Do we still need to get there? Do we still need to develop a strategy to get to there? For argument's sake, if the father only contacted a minor child for 2 days per month, the case becomes a bit more harder. It will be better for the father to try to get more contact first, half the school holidays, and then work towards being the primary caregiver. Not necessarily going to 50-50 first, but 50-50 is actually a situation where both parties are primary caregiver. And I believe if 50-50 works and has been made, it's harder to go and make a case for primary care. But it's possible. Nonetheless, we have to look at all the circumstances, all the factors mentioned in question number 1 and question number 2. And the court will have to determine what is in the minor child's best interest. Is it in the minor child's best interest to be with the dad? Can the dad care for the minor child just as well as the mom can, and even better? Will the minor child's education, psychological, emotional needs be looked after when the minor child being cared by the dad, better than the minor child needs would have been looked after with the mom, etc.? When I mention the word needs, remember, money has nothing to plays no role in the specific scenario. The father can be extremely wealthy or extremely poor. Doesn't matter. The question is what is best for the minor child. If the father is extremely wealthy and is not in the minor child's best interest to be in his care, then that's it. The father must pay more maintenance to the mom because the mom would require the maintenance if she cannot afford to pay for it. And in the same breath, if the father is extremely poor, but he believes he can care for the minor children better, and he can, actually, factually, it's worked out. The mother is extremely busy, working, jet-setting, etc. And then under those circumstances, the mother must pay child support to the dad. Thank you very much for your time, for watching this webinar. No, there were no live questions. I do not see any. But nonetheless, you're welcome to post questions before tomorrow if you're watching this webinar on Tuesday, the 4th of May. If you're watching it on Wednesday, the 5th of May, I might have had another webinar and I shall not deal with these questions again. Have a lovely day and stay safe, and thank you for watching. Good afternoon. Welcome to our webinar. Today's topic, childcare and contact, or sometimes referred to as custody and access. The new term since the Children's Act came into operation, we're using the term care and contact. So that's the way we go about that. Many people still refer or use the term access and custody. And of course, there's the issue of concerning guardianship as well, the legal rights or the lease regarding a minor child. Nonetheless, let's deal with today's topic, childcare and contact. Generally, I'll be dealing with the issue concerning various aspects of child custody, child maintenance, guardianship, relocation, and so on. Nonetheless, we have a few questions which people posed previously in the last few days. I have changed the questions a bit to deal with it more in a more legal fashion. Sometimes when people pose these questions, they use shorthand, they type it from their phones, and sometimes you do not know exactly what the gist of the question is. But nonetheless, I tried my best to not to lose too much of what the people have typed when they send these questions to us, and hopefully I'll be able to do justice to the specific question. So I have 5 questions on the whiteboard. This must be number 5 as well. I have 5 questions on the whiteboard and I'll be dealing with those. If you have any live questions, if you are watching this video live, please make use of the Advocate Muhammad Abduroaf Facebook page. I'll be keeping an eye on that specific page, and if you do pose a question on that specific page, I will deal with it. I am seeing a question now live as well, so thank you very much for that. Anyone else have live questions, feel free to pose it. But let me first get through this question list of the people who posed these questions previously. The first question is, the mother is suffering from depression and I think she is bipolar. What can I do if I want to have custody of my child? I see him every weekend and he's 4 years old. Okay, so reading between the lines is a father posing this question. He believes the minor child, he believes that the child is not being properly cared for by the mother because of the mother suffering of depression, and he potentially believes the mother is bipolar as well. Now he wants to have custody over the minor child. So the question you'll pose to me, or someone will pose to me, is it by default if a caregiver, a primary caregiver, suffers from depression and is bipolar, does that make that specific parent unable or inadequate of caring for a minor child? And of course the answer is by default not yes. I cannot say yes, it does, because with depression, with bipolar, there is medication for that, and if it's well treated, you should not have a problem. You can continue with life. And also the specific patient or the specific parent may be able to affect the caring capabilities of a minor child of 4 years old. But I'm looking at that from that specific angle. The other sphere we have to look at is the father. Can he care for the minor child? Why is the minor child in the first place not with him? That's very important. And the specific father does not mention that he is capable. He's not providing us with that information to substantiate that he can care for the minor child better than the minor child is being cared for by the mother, despite the depression and despite the bipolar. Or I'm not obtaining information from the father explaining to me the level of the depression. How does it negatively affect the caring of the minor child and the bipolar? Does it affect the minor child, or is the minor child very happy? Because a 4-year-old child is supposed to be happy, enjoying life, going through those milestones, learning how to run, to talk well, to play, to possibly spell the name and so on. So that's what the child of 4 years old has to do, not necessarily having a parent assisting him with assignments, homework, etc., and X, Y, and Z. So nonetheless, if the father in this specific question believes that he can care for the minor child better than the mother because of other reasons as well, for example, he can, stay up at night to care for the minor child should the minor child be ill. His structure, his work program allows him to be a caregiver of a 4-year-old child, and he has the temperament, the patience, and the insight on knowing how to look after a 4-year-old child. Then wonderful, then maybe the playing field becomes equal on that basis, but not by reason of the mother suffering from bipolar or depression. So I hope I answered that specific question as objectively and as properly as possible. Nonetheless, let's deal with question number 2. I have a job offer to work in Dubai. I work as a teacher currently in Gauteng. My child is 10 years old and I want to take her with me. The father's name is on the birth certificate and he does not agree with my daughter going with me. What can I do? He pays maintenance. Okay, a scenario which comes about quite often these days, the issue of relocation. Here we have a primary caregiver, a mother caring for the minor child. The father pays maintenance, and I'm certain he has contact often with a minor child, maybe in terms of a parenting plan or some type of agreement the parties may have. But that's not an issue. Things are going well. Now the mother wants to relocate to a foreign country, and in this case, Dubai, to teach. And she would like to take a child with her of 10 years old. Now, what differentiates international relocation matters with the normal that generally the child in the normal circumstances would be living in the same suburb, the same province, both with the parents. And therefore the only issue is how much contact should the minor child have with the other parent, every second weekend, half school holidays, and so on. Here we're having a scenario where the minor child will relocate with the primary caregiver to a different country, to a foreign country, leaving the parent who remains in South Africa with a total different level of contact with the minor child. He might see the minor child once every 2 years physically. Yes, we know we have Skype, we have Zoom, we have FaceTime and so on. But however, that aspect of picking the minor child up from school, taking the minor child to school, extramural activities, spending weekends with the minor child, going to the park, going to the pools, going to the beach and so on, will not happen anymore. So here we're dealing with the issue concerning international relocation, which is quite complicated in the sense of the court must first determine whether or not it would be in the minor child's best interest to relocate with a parent in the first place. So we're not dealing with care and contact issues at that specific time. Then the second leg would be what type of care and contact arrangement should be in place for the specific parents should the minor child relocate with a primary caregiver. But those things are not that hard to work out because, contact would usually be unlimited at reasonable times. And reasonable times can be a bit complicated. Okay, Dubai might not be much of a problem, but let's say the minor child relocates to the United States, whereby a good time for the minor child might be in their afternoon between maybe 5 or 4 and 7 or 8 o'clock. However, that might be a total different time zone in South Africa. And that could cause certain type of complications with the parents having contact. Either the father would have to wake up extremely early or he'll have to be awake extremely late at night in order for him to have contact. Nonetheless, under these circumstances, seeing that the father is involved in the minor child's life, his name's on the birth certificate, the Department of Home Affairs would obviously require the father's consent for the relocation. They would require that. And at the same time, for the mother to apply for a passport, the Department of Home Affairs would require the father's consent as well. In a matter like this, we would have to convince, and the mother is the one asking for the advice, so we are answering this question on behalf of the mother, putting on my advocate's cap for the mother. The mother would have to convince the court that she set up a situation in Dubai that will be conducive for the minor child's well-being. In the sense of she's looking after the minor child while in South Africa during the week, taking him to school, feeding him, caring for him, doing his assisting him with his assignments and so on. But should the minor child relocate with her to Dubai? No, the child should not relocate. Firstly, school, change of school, friends, family, contact with the caregiver as well. The father would not have contact with the minor child as often as he has, maybe every second year. And with COVID-19 being so difficult, we do not know what will happen in the future. He might see the minor child, after a very long time again, physically. So he would argue that. And what would his argument be? If he's very good, he would not necessarily argue on the basis that the mother cannot go overseas. He would argue that if she wants to go overseas, she can go overseas and she can do what she wants to do. But the minor child should not go with the mother. And with saying that, he would have to argue and present to the court that he can care for the minor child adequately in South Africa and the mother can go away. So that's a debate that has to be determined. And if you look at that specific scenario, that specific situation whereby he caring for the minor child, we have to say, is it best for the minor by the father who has no experience? Let's say those are the facts. He has no experience, the minor child does not know him so well, him or her. So I hope I dealt with that specific question. And if I have not, you're welcome to comment a bit further. The third question, and the person that posed a question on Facebook, I shall deal with your question after question number 5, and then we can unpack it further. What do I do if my child does not want to visit? You must follow the order. But if you have a situation whereby the child does not want to go, and the parent who would be exercising contact in this specific case, the father is adamant he wants to have contact to the minor child, and there's a court order in place stipulating that, I strongly believe under those circumstances, you need to take this matter back to the court. The court needs to resolve this issue as soon as possible. Because of 17 years old to have contact with another parent if the child does not want to, without trying to mitigate the matter. And the way to mitigate the matter would be to take this matter to court, because a child of 7 years old is very vocal and we do not want to traumatize this child. Until then, unfortunately, depending on how far she acts, the minor child would have to go to the father unless she goes to court urgently, and the court can relook this matter sooner than later. And because the minor child is 17 years old, there are a lot of variables who play. Number one could be the minor child might turn 18 years old in a month's time. And now you have to go to court, urgent litigation to be heard in a week's time, where that order will only be applicable for the next 3 weeks' time. I think parents will be silly to litigate a matter for 17-year-old on that specific basis, spending so many thousands of rands on legal fees just for the father to have contact with a minor child for the next 3 weeks. and the child will become an adult after that. Okay, so my answer, in summary, my answer would be basically focus on what's best for the minor child. However, because there is a court order and the parties cannot come to an agreement, urgently approach the court and have the court reassess the matter and determine what is best for the minor child. That was question number 3. Let's deal with question number 4. I am in the process of getting divorced. I was told that I can ask for maintenance from the divorce court. Is it possible, or must I go to the maintenance court? The answer is yes, it is possible in a pending divorce matter to approach the the divorce court itself for a order regarding child maintenance, care and contact. That's possible as well, and also a contribution towards legal cost. So that is possible. For example, it can also be done before the divorce and also with the divorce summons being issued as well. So that is possible. Question number 5, the last question before we deal with the live question. The father of my child is missing. He does not pay maintenance nor visit the child. The last time we had contact was in 2000. That's quite some time ago. I think that should be around, it is 2010. My apologies for that. 2000, the child would be an adult by now. I want to get a passport for my child. Home Affairs says I need a court order. How do I get it? Okay, so let's deal with this matter from the foundation. Minor child, the father and the mother are guardians over the minor child. So they both have parental rights over the minor child. I would presume these parties, maybe the child's name is on the birth certificate. I would presume the father is involved in the child, was involved in the child's life at that specific time. But now when the mother went to the Department of Home Affairs and showed him the birth certificate, they said, oh, okay, I see, there is a father, we require his consent. The mother might say the father was not involved in the child's life since 2010. They'll say, how do we know that? You could be lying, whatever the case may be. And they require the father's consent, and they'll tell you, if you cannot get the father's consent, you need to come back to us with a court order. So that's what the mother needs to do. We make those type of applications quite often, whereby parents have challenges in, number one, maybe living or assisting the child in his life, for example, enrolling to schools, extramural activities, consent. For example, let's say the child has to go for an excursion and they require the guardian's consent, or the minor child would like to go overseas on some trip because the child is very talented and the guardian is not available and hard to be found. So nonetheless, under these circumstances, I would advise the specific person to urgently approach the court and ask the court for an order that the court appoint him or her as the sole guardian of the minor child, and in this case, the mother. So basically, you approach the court, you tell the court, these are the problems I have for the last 10 years. Father is missing, he never paid any maintenance. I had problems with enrolling the minor child to primary school, to high school. I'm still having problems. I cannot get a passport for the minor child. All these problems, but the father is nowhere to be found. The High Court will assess this matter, and the court could possibly make an order that, Mom, we believe you, we accept what you are stipulating. Here is an order stipulating that you have sole guardianship rights over the minor child. Go to the Department of Home Affairs, show this order to them, and they would not ask for the father's consent. So that is possible. The court would obviously make an order like that if the court believes it would be in a minor child's best interest, but generally, if the father abandons the minor child and the family and so on, the court would make such an order. Okay, I hope that answers question number 5. If I have not, and you are watching this video, and you have posed a question to us, this usually happens this weekend, you're welcome to comment. We have now the live question. Let us deal with that. Okay, here's a live question. Hi, I'm going to the maintenance court tomorrow. I saw my ex and son at the restaurant and went to say hi to my son. He quickly called his lawyer and said it's harassment. Can he do this? I'm in Johannesburg from Durban and hardly get to see my son, but he says it's his time with the child. All I did was say hello and hug my son, etc. He was excited to see me. I do not necessarily per se, I wasn't there, so I do not know what the other dynamics are, but on the facts mentioned over here, if you were, for whatever reason, coincident at the shopping mall and you see your son, normal people, they greet each other and hug each other. So he would obviously have to prove to the court that it is harassment. What would be harassment would be that you stalked him, you came out of nowhere, you knew you're following him, and that is why you were there and you planned this from the word go to be there and to see your son and to, of course, communicate with the son and limit or in some way or another, not frustrating his contact with the son, but also, you know, you'd prefer you not to have been there. But nonetheless, on the facts which you have mentioned to me, I do not see any form of harassment. If you were there, by the way, and it was a total coincidence, and you in no way frustrated his contact with a minor child. So that should be fine. If I did not deal with the matter properly, please tell me and I will try my best to answer it in a different way. So nonetheless, thank you very much for your time, everybody. That was 5 questions and 1 live question. I think we dealt with it quite well in the last 25 minutes. Thank you very much for watching this video, and I hope to see you online again soon. Thank you for joining us. These type of webinars are very beneficial to people because it gives them the opportunity to pose a direct question to a legal practitioner that specializes in family law. You may come across your specific legal problem for the first time and do not know how to deal with it. Sometimes it's very useful to engage with a legal practitioner who practices or who specializes in the specific field of law, and he or she would be able to fast track your knowledge on this specific topic. Therefore, as I've always welcomed people to pose whatever questions you have. I see we have a live question. Thank you for that. Let me read it out. My daughter's father has opened her an Instagram, Facebook, and TikTok account. She is only 9 and I haven't been consulted about this. Is there anything I can do to protect her from this or do legally? It's a difficult question to deal with. It's not a criminal offense for him to open such an account unless Facebook or Instagram does not allow it, or they might allow it but with parental oversight. And some parents, for a 9-year-old child, they might find it reasonable for him or her to have a Facebook account whereby they will keep a close look out on it. So they will monitor it. Generally, parents would have to discuss these specific things. They cannot, at every point where modern technology comes in, where certain decisions regarding a minor child has to be made, they always at loggerheads. So here it is now the Facebook account, where the parties now have an issue and a problem regarding that. I'm not referring to this specific commenter. A different scenario would be where the child has to get a cell phone. Parents are now at loggerhead. Maybe if they were in the same in one relationship, living together, they would have resolved that specific issue more differently, but they do not, or they cannot. Now, this is a typical issue where the parents have to discuss, they have to work around it, because if Facebook is lawful for a 9-year-old child to have an account with, I do not know, I have not done the research, this is the first time I have had a question like this. And if it is legal and a specific parent wants to have that, that is now obviously that parent's decision. But if you feel that it is harmful and it will cause some type of negative impact on the minor child, and it will actually happen, then the only way I can see this matter can be resolved would be for you to approach the court of law and ask the court to force the parent to stop with the action of creating social media accounts for the specific minor child. You cannot go to the police. What will the police do? It's a Facebook account. What will the charge be? Opening an account for a minor child, unless there are illegal activities taking place on the account. So therefore, please verify firstly whether or not a 9-year-old child can have a Facebook account, or is it the father's account whereby he's posting pictures of the minor child day-to-day activities. But from a point of view, parents should be able to discuss this. As I mentioned
as I mentioned earlier on, tomorrow there will be a different problem, something else, and these specific parents cannot agree upon these things. If the parties were in a relationship, they would have discussed it, they would have argued it, and they would have made a decision regarding that. So from a legal point of view, I cannot really see any recourse as, for example, going to the police station and so on. The other recourse would be to contact Facebook, to contact TikTok or Instagram and say, this is a 9-year-old child, please close the account, but I'm certain they can open up an account again on a different name and a different username, etc. The only option I could see or presume would be to approach the High Court, and the High Court will have to make a decision if it is in a child's best interest. It can be very expensive. But then tomorrow there's another problem, another issue. Co-parenting counseling, I'll say that's most probably the best thing to do, because when it comes to these type of things, the parents have to agree upon it. And if they cannot come to an agreement, what does it mean? The account shouldn't be opened, or the action should not be taken place, or if they cannot come to an agreement and the party who proposes something, can he go ahead with his or her suggestion, for example, giving the minor child a cell phone or not? That is where counseling and co-parenting comes in. The best of co-parents are the best of parents, and that is best for the minor child. The commentator went further and says to put a stop to it, as she was told by her dad to keep it a secret. It's clearly a family issue. It's not necessarily a legal issue. Tomorrow the child, not the specific commenter, I will never refer to anybody specifically who comments, that will be wrong upon me. But let's say tomorrow we have a scenario where the father lets a minor child wear a certain type of clothing. It might be inappropriate for that specific family environment, and tell the minor child, please keep quiet. Do not tell your dad or your mom about this. So whenever the child visits the mom or the dad, the child is allowed to do certain things, or the child is allowed to do swimming or cycling or piano. The parties might be very religious at the father's home, and when the minor